Good morning, everyone. It is my greatest pleasure to welcome you all to the first edition of the Global South ADR THIRUNAAL or Day 2025, a landmark event that brings together ADR practitioners, institutions, and dignitaries from across the globe, exploring the evolving landscape of international arbitration in the Global South. Let me begin by introducing the institution behind this initiative, the Kovise Foundation Conflict Resolution International, KFCRI. Founded by Mrs. Surya Narmada, horticulturalist and agri-arbitration consultant, and a visionary with a unique background in horticulture and a deep commitment to integrating ADR into the agriculture sector. KFCRI was established on 15th October 2016 with aim of making dispute resolution more accessible, inclusive, and impactful. We are more than privileged and honored to have the guidance of Mr. V. Inbavijayan, a globally respected arbitrator with over 2 decades of exclusive arbitration experience. He has presided over hundreds of domestic and numerous international arbitration cases, earning recognition for his expertise and impartiality. Mr. Inbavijayan currently serves as the managing partner of Global LLP and the global advisor to KFCRI. He is empaneled with prominent institutions such as SLNAC Sri Lanka, TAI Thailand, BIAMC Indonesia, AIAC Malaysia, DIAC Dubai, SECA Saudi Arabia, TRAC Iran, CRCICA Egypt, IIAC, ICA, and ILC SCA India, CTAC and SHIAC China, HKIAC Hong Kong, and NYIAC USA, among others. His expertise spans commercial, maritime, construction, and investment disputes. And he is also a SIA fully approved tutor, course director of all modules in arbitration and regional pathway leader. He is also a fellow of Chartered Institute of Arbitrations, a distinction that reflects his deep commitment to professional excellence in arbitration. Mr. Inbavijayan has been instrumental in facilitating the establishment of numerous arbitration institutions, further advancing the global area framework. His strategic vision and unwavering commitment to integrity and capacity building have been pivotal in shaping KFCRI's growth and its global standing in the ADR ecosystem.
Sorry for that. And thanks a lot, Shakti, for the wonderful introduction about KFCRI. Let me just take through the participants to the statistics of KFCRI. Over the years, KFCRI is emerging as a pioneer force in the field of ADR, consistently placing predominant significance on the appointment of young and women arbitrators, thereby fostering an inclusive and diversity within the arbitral community. The institution has also successfully facilitated the appointment of arbitrators in over thousands of banking and financial disputes and several domestic cases, reflecting its active role in strengthening the ADR ecosystem in India. It has conducted more than 40 structured training programs across the globe and has hosted and participated in over 100 seminars and conferences. In collaboration with Indian Institute of Technical Arbitrators, KFCRI has also conducted the IITR Empanelment course, a specialized training initiative designed specifically for engineers aimed at enhancing their professional competence in arbitration. To date, over 200 individuals from diverse professional backgrounds have been accredited through these programs, reflecting KFCRI's holistic approach to nurturing ADR professionals across disciplines. Additionally, KFCRI has also signed more than 25 MOUs with both ADR institutions and law schools across India and abroad to efficiently promote the notion of ADR exchange services globally, furthering its core commitment to capacity buildings. It has also conducted ADR roadshows at over 25 institutions across India, for which several leading law schools to promote awareness and interest in ADR among young, vibrant legal minds. This institution has also inducted over 150 interns from prominent law schools across India, providing them with a strong foundation in ADR and training them as a tribunal secretaries in arbitration. In the past year alone, KFCRI has facilitated the involvement of these trained interns as a tribunal secretary in over 120 cases, thereby reinforcing its commitment to capacity building and procedural efficiency in the arbitral proceedings. Even though the global challenges posed by the COVID-19 pandemic, KFCRI has remained resilient and innovative, leveraging online platforms to conduct webinars, training programs, competitions, conferences, and ensuring community and continuity and the growth of ADR in education and practice. Moreover, KFCRI has also been a forerunner in introducing dedicated virtual dispute resolution, which we termed as VDR, rules which KFCRI has its own specific rules, which is called as VDR rules, ensuring efficient and accessible proceedings. As an appointing authority, KFCRI maintains a sector-wise panel of arbitrators with deep subject knowledge, ensuring that disputes are resolved with precision and relevance. The institution is also active in mediation programs, offering both training and actual mediation proceedings, further expanding its impact in the ADR ecosystem. Thank you a lot.
Today's event, the Global South ADR THIRUNAAL Day, marks a significant milestone, being the first Congress of ADR practitioners and institutions in Global South countries. As cross-border commercial disputes grow and economic partnerships evolve, the role of international arbitration becomes increasingly critical, especially in developing and emergency economies. This 24-hour online event serves as a dynamic platform to explore that evolution and to understand how arbitration can foster stable, predictable, and business-friendly environments across the Global South. At its core, the event also seeks to collaborate with like-minded individuals and institutions, building a global community committed to the advancement of ADR. This event brings together a diverse group of participants from legal professionals and arbitration practitioners to multinational corporations, government bodies, NGOs, and students. Whether you're here to learn, share, or collaborate, we believe that insights and connections you gain today will be both meaningful and enduring. Thank you all for being a part of one of its kind of event. We look forward to a day of rich discussion, shared knowledge, and future collaboration. With that, we are honored to begin this enriching 24-hour journey. To start the day, we're delighted to welcome our very first speaker, Ms. Golda from Papua New Guinea. Ms. Golda Guerrero, founding partner of Guerrero Lawyers, a distinguished legal professional from Papua New Guinea with a multifaceted career in law, governance, and corporate leadership. As the co-owner of a family-run law firm, Ms. Guerrero brings a wealth of experience in legal practice, complemented by her strategic roles on the boards of prominent institutions such as Post PNG Limited and Moniplus, where she serves as an independent director. Her legal acumen is matched by a commitment to ethical governance and institutional development. With a strong foundation in both private practice and public service, Ms. Guerrero exemplifies the evolving role of legal professionals in shaping policy and advancing access to justice. We are delighted to welcome her today as she shares her insights on the ADR landscape in Papua New Guinea, a valuable perspective shaped by her leadership and dedication to the legal profession. We are truly honored to have you, Ms. Golda. The virtual floor is now yours.
Ma'am, I think you're on mute.
Thank you very much, all. I'll just be very brief because Papua New Guinea is a country in the Pacific region, and arbitration is quite a new regime over here. The new arbitration regime replaced our PNG's Pre-Independence Arbitration Act of 1951, and so we've only been a signatory to the New York Convention since 17th July 2019. It's quite a new development in PNG's legal system, as we have now an Arbitration International Act and the Arbitration Domestic Act, which were both passed by the PNG National Parliament just recently, as last year, 20th February 2024. and certified later on 16th May 2024. So it's quite recent. In Papua New Guinea, we haven't had much arbitral cases or awards given. But our Arbitration Domestic Act and our Arbitration International Act were drafted in line with the UNCITRAL Model Law on International Commercial Arbitration of 1985, the model law, as everyone knows. And because PNG acceded to it in 2019, that gave effect to the United Nations Convention. The territorial scope of the regime, generally both the International and Domestic Arbitration Act of PNG only applies if the seat of the arbitration is in PNG. Currently, most arbitration occurs in either Singapore or Hong Kong or Australia as the seat, not in PNG. That's in terms of the current legal framework. In terms of the key trends and development in arbitration in our Pacific jurisdiction, with reference to Papua New Guinea, the confidentiality provisions are incorporated in our domestic legislation and the International Arbitration Act of PNG. Arbitration is an alternate dispute resolution process, and so we do have a court referral system. So the National Court has the authority to refer disputes to arbitration, either on its own motion or with the consent of the parties, helping to ease the burden of PNG's judiciary. We do not have a separate international commercial settlement of an investment dispute center. It's just goes through the normal national court process. So we do recognize foreign arbitral awards, and they're usually through the national court. I guess we do have regional influence in terms of trying to position ourselves to be more arbitral friendly in the Pacific, especially with neighbor countries like Fiji and Vanuatu, which are also modernizing their arbitration frameworks to attract international business as well. I guess the other key trends or development under our legislation would be the as I mentioned, earlier, the arbitrability of the dispute is usually dealt with through a court referrals or court-annexed arbitration. Having said that, that does not affect the current application of existing legislations provided for under our domestic arbitration. So it just stipulates a mechanism for dispute resolution apart from the current arbitration under similar or acts. Since the National Court refers matters to arbitration, the extent of the court intervention is also provided in the Act, and actually provided the court, neither the court nor any other court intervene on the matters governed by the Act. Yeah. The statutory time bars and conditions precedent such as the Act, as well as both the domestic and national arbitration acts by the state. However, there's a separate legislation under the domestic laws, which is our Claims by and Against the State Act, which has that limitation. Because that Claims by and Against the State Act does not apply to our International Commercial Arbitration Act, even though the state is a party. In terms of representation of arbitral proceedings, it's strictly limited to lawyers. So you can be duly qualified as a legal practitioner in PNG to be an arbitrator. Yeah. The other key, I guess, is the public policy is catered for under both legislations, the Domestic and International Arbitration Act of PNG, as long as I'll just read it. As long as it is declared for the avoidance of any doubt that for the purposes of these sections, an interim measure or arbitral award is in conflict with or contrary to the public policy of the state if it was induced or affected by fraud or corruption, or it is repugnant to the general principles of humanity. I guess that's a general. Moving on, the involvement of public and private entities in global arbitration. So the state-owned enterprises often engage. We've also been going through several state-owned enterprise reforms as well. So it's quite new in that space, although it could be used as a way of resolving disputes relating to international trade, investment, and regulatory matters. Arbitration does provide state-owned entities with a neutral forum to settle conflicts efficiently, avoiding lengthy litigation in national courts. I guess some key aspects of arbitration involving SOEs may include, because we haven't had any as such yet, but sovereign immunity. So the state-owned enterprise may invoke sovereign immunity to avoid arbitration. And this depends on whether they are commercial or government capacity. In terms of PNG state-owned entities, they are owned by the government through their commercial arm, Kumo Consolidated Holdings Limited, a separate company, government-owned entity. In terms of, so state-owned enterprises can be involved in ISDS cases, either as claimants or respondents. We haven't had much regulatory changes in terms of arbitration involving state-owned enterprises, but it would intersect with our national laws and international treaties. Navigation through our legal frameworks here in PNG. It's quite sensitive because it's involves the government, so there's political sensitivities when it dealing with state-owned entities, and obviously different laws as well, like the public laws that you have to consider in terms of like the Public Finance Management Act, and generally dealing with projects that the state-owned enterprises undertake. Disputes involving state-owned enterprises, yes, can be politically charged when the public funds or national interests are at stake. And other than that, I guess the main highlight would be the confidentiality clauses, the role of lawyers, strictly to arbitration, strictly to the legal profession. Time bars, and yes, the recognition of enforcement of arbitral awards. Apart from that, I have nothing more to add, unless anyone has any questions.
Thank you, Ms. Golda, for the excellent presentation about the arbitration regime, particularly the Papua New Guinea's new arbitration regime. No doubt, 1 year has gone. The new arbitration regime of Papua New Guinea is obviously going to be a catalyst, making PNG one of the very significant countries in the global south to become an arbitration-friendly destination. We hope so, surely on it. But interestingly, what we analyzed as part of institution in the global south, this particular regime change has given notable differences between the ability of courts to intervene in the proceedings, particularly the breach of an arbitration agreement. per se. And it also dealing with much on the limitation period, legal representation, particularly on the claims by and against the state, and adding on the codification of the principles of confidentiality and privacy. All these is excellently codified, and as a stakeholder who's quite interested to get involved in the region in PNG for arbitration, it is making PNG courts as a source for guidance from the principles of English common law. And even though I think more than a long period after the independence, this reform is quite a valuable reform, no doubt on it. What as a final say, what we can observe is that this new arbitration regime is presenting an opportunity to promote international trade as well as commerce very significantly. And as Madam Golda was mentioning, this new regime is going to create a robust arbitration framework that is going to offer an alternative means of resolving complex commercial disputes, interestingly using the confidentiality, the neutrality, and very significantly this efficient process which leads to an enforceable arbitration awards. That is the very the necessity of the hour when it comes to a dispute resolution process, the enforcement. Thank you, Madam Golda, for the insightful information about the arbitration regime in PNG. And we are very happy on behalf of KFCRI to have you as an first speaker on this 24-hour virtual event. And it is our team thanking you on a very significant day. This is going to be a milestone. We are going to make multiple announcements about what is going to be the future about Global South arbitration. Thank you.
Thank you very much. Thank you very much, Sean.
So now I'd like to welcome our next speaker, Mr. Ho Si Chol, a distinguished legal professional and a current representative attorney at the Hyundong Law Firm in South Korea. With a career spanning over 2 decades, Mr. Ho has held prominent roles, including legal advisory team leader at Korea Electronic Power Corporation and general manager of legal affairs at Korean Air. He is also experienced arbitrator with the Korean Commercial Arbitration Board and serves as a Supreme Court public defender. His academic contributions include adjunct professorship at Donga University and Sogang University, reflecting his commitment to legal education and thought leadership. We are privileged to welcome Mr. Ho Si Chol to share his insights on the area landscape in South Korea and to contribute to the depth and diversity of today's discussions. Over to you, sir.
Mr. Oshu, you have to unmute your audio. Yes.
Can you hear me now?
Yes, yes, perfect, perfect.
Okay. Good morning. Hello, everyone. My name is Oh Se Chol, and I am an attorney based in South Korea. I've been practicing law for over 18 years, mainly in the areas of civil, administrative, and corporate law. I run my own law office in Hyundong District, Gwaeong City, just outside of Seoul, where I provide legal services to individuals, companies, and local government institutions. In addition to my litigation work, I'm also an accredited arbitrator with KCAB. So far, I've handled more than 6 mediation cases through the KCAB, and I'm proud to say that more than half of those cases were successfully settled through my mediation. My main interest lies in promoting fair and efficient ways to resolve disputes outside of the courtroom, especially through ADR mechanisms like arbitration and mediation. I'm also increasingly interested in areas like intellectual property and technology law, as I believe they will play a key role in the future of legal services. It is a great pleasure to be part of the Global South ADR Tribunal, and I look forward to learning from all of you and sharing Korea's experience in ADR. Here is a quick overview of what I'll be covering in this presentation. First, I introduce the main arbitration institutions in Korea with a focus on KCAB. Then I walk you through the procedure at KCAB from filing a case to receiving the final award. After that, we'll look at arbitration in Korea more broadly, including its advantages, international law, and recent developments. Finally, I will wrap up with a short conclusion. Let's get started. First, the Korean Commercial Arbitration Board, or KCAB, is the largest arbitration institution in the country. It was established in 1966 and offers services for both domestic and international disputes. It operates with separate rules depending on whether the case is domestic or international. Besides KCAB, there are other specialized arbitration institutions in Korea, including the Korea Medical Dispute Mediation and Arbitration Agency, which handles medical-related disputes. The Press Arbitration Commission, which deals with media and press-related cases, and the SME Technology Mediation and Arbitration Committee, which focuses on resolving tech disputes for small and medium enterprises. Let's take a closer look at several important parts of the KCAB arbitration process. First, initiation of arbitration. Arbitration officially begins when one party submits a request for arbitration to KCAB. This request must include a brief summary of the dispute, the names and the contact details of both parties, a copy of the arbitration agreement, and the specific relief or outcome the party is seeking. Once KCAB receives the request, it informs the other party and or asks them to submit a response to arbitration within a set time. Number two, international legal basis. Appointment of arbitrators. In international cases, parties can agree to appoint either a sole arbitrator or a tribunal of 3. If they can't agree, KCAB will step in and appoint arbitrators from its qualified domestic or international panel. All arbitrators must be neutral, independent, and free from any conflict of interest. Now let's continue with the other important steps in the KCAB arbitration process. Pre-hearing and written submissions. Before the main hearing, a preliminary case management meeting is held to set the case timeline. During this phase, both parties submit their statements of claim and defense, relevant documents, evidence, and expert reports, and witness statements, if applicable. All communication and document exchanges are done through KCAB's secure online system, ensuring smooth and organized case management. Number 4, hearings if needed. Hearings may be held in person, virtually, or in hybrid format, depending on what the parties agree on. These hearings may include oral arguments, cross-examinations, and expert presentations. However, in some cases, especially those that rely heavily on written documents, a hearing may not be necessary. These steps ensure that every case is handled efficiently and fairly, based on the needs of the parties involved. The final step in the KHAV arbitration process is award issuance. After carefully reviewing all the submissions, the arbitral tribunal issues a final and binding award. This award usually includes the findings of fact and law, the specific relief granted, and how the costs and legal fees are to be divided between the parties. The award is generally issued within 12 months from when the tribunal is appointed, but this period can be extended if needed. This final step ensures the dispute is resolved with clarity, finality, and enforceability. Let's now take a look at arbitration in Korea, focusing on the key institution and its advantages. Number 1, KCAB, the key arbitration institution. The Korean Commercial Arbitration Board was established in 1966 and is the country's main arbitration body. It handles both domestic and international cases and operates KCAB International to focus specifically on global disputes. KCAB also provides useful tools like model arbitration clauses, case management service, and access to a list of experienced arbitrators. Number 2, advantages of arbitration in Korea. Korea offers several advantages for arbitration. It has a pool of experienced and bilingual arbitrators, ideal for cross-border cases. The procedures are efficient and the awards are enforceable both in Korea and internationally. Arbitration here is often more cost-effective than going to court abroad. Korean system is modern and aligned with international standards, supported by a strong legal framework. Its strategic location in Asia, along with advanced infrastructure, makes Korea an attractive venue for arbitration. As a result, it's becoming increasingly popular with both Asian and global companies. That's why Korea stands out as a leading hub for international arbitration. Now let's focus on international arbitration in Korea. Seoul is quickly becoming a regional arbitration hub, thanks to its modern infrastructure and strong legal framework. KCAB International is globally recognized and manages around 60 to 100 international cases each year, using procedures that align with the international arbitration standards. Korean courts are very supportive of arbitration. They respect party autonomy and uphold arbitral awards. The Seoul IDRC offers state-of-the-art facilities for hearings and meetings. KCAB also works closely with other leading arbitration institutions around the world, helping to expand its global network and continuously build expertise in international dispute resolution. All of this makes Korea increasingly attractive destination for resolving cross-border disputes. Let's finish by looking at some recent trends and developments in arbitration in Korea. First, we can see in the graph, there is a growing number of foreign-related arbitrations being handled by KCAB International, showing Korea's rising reputation as a trusted venue for international dispute resolution. Second, The Korean government is actively encouraging arbitration, especially in public contracts, to promote faster and more efficient resolution of disputes. Finally, Korean arbitrators are gaining more visibility and influence globally. Many are now participating in major international forums like SIAC, ICC, and HKIAC, which highlights Korea's expanding role in the global arbitration community. These developments show that Korea is not just keeping pace, but actively shaping the future of international arbitration. To conclude, Korea's arbitration system is built on strong international foundations like the UNCITRAL model law and the New York Convention, ensuring it meets global standards. Recent amendments to the Arbitration Act and supportive government policies are helping the system grow and modernize. Thanks to its speed, expertise, and confidentiality, arbitration in Korea is becoming a reliable and effective method for resolving both domestic and international disputes. With this continued development, Korea is well positioned to become a leading hub for international arbitration. Thank you for listening.
Thank you, Mr. O. It was an excellent presentation in a nutshell. Interestingly, I happened to have a good exposure with KCAB, which is the Commercial Arbitration Board of Korea. Recent past, the role of KCAB International, as you rightly pointed out, is a very significant role in arbitration, particularly the development of arbitration seat to be South Korea. Seoul, obviously, it is considered to be heart of every individual, which has a good connection with India, particularly even though it is part of the global north, the contribution what South Korea is eventually giving to the significant role of the arbitration in the global south, we have to appreciate. Why? Because the huge investments what South Korean entities and companies are facilitating in the global south has rapidly developed. If you can see since 2018, I think Professor O would accept this. Investment treaty arbitrations in South Korea have experienced a rapid growth. The first investment case was initiated in 2019, if I'm not wrong, by a South Korean government-owned corporation. They filed against an Indian government. Very interesting. I happened to be part of the research work on this particular case, wherein the arbitration found grounding pursuant to the India-Korea Bilateral Investment Treaty. This treaty was signed in the year 1996, as well as they dependent on the India-Korea Comprehensive Economic Partnership Agreement 2009. And here, the fact involved was the Indian government's failure to supply the gas under the relevant agreement. Here, in this particular case, it was very clear, understood that the South Korean government wanted to engage in investment arbitration as an inevitable part, that is very important, of its dispute resolution and investment as such. We have to appreciate, and we from KFCRI, particularly seated in India, a significant country in the global south, are very happy that the South Korean government is one such sovereign state which is accepting and engaging in investment arbitration. It's very rare to see, such a commitment from a government. And to this end, there are only very few adverse award which happen to be not so friendly with investment arbitration involving Korean parties. But no doubt, the arbitration jurisprudence, what we can see in South Korea, as rightly Professor O was highlighting, and interestingly, being part of a law firm quite significantly involved in multiple arbitration work. The cases dealing with arbitration jurisprudence eventually engages the South Korean courts interest in the application of the KAA, the Korean Arbitration Act, when it also involves domestic legislations and mandatory regulations. When you see on multiple cases wherein the Korean Debtor Rehabilitation and Bankruptcy Act, which did not have a preferential effect on this act, there are the developments which was happening, particularly when we look on the regulations of terms and conditions. Neither international mandatory nor extraterritorial applicability were given some clarifications. But as a wholesome understanding of the role of the Korean Commercial Arbitration Board as an institution in South Korea being a global north country, is anticipated to further promote Korea as a hub of international dispute resolution in Northeast Asia and beyond. In line with this legislative provisions, the government, the sovereign state, is also understood to be eager to convey to the international arbitration community a message of openness to meet the growth, the demand for cross-border commercial dispute resolution, and also better facilitating transboundary transactions. This can be reflected, as Professor was highlighting, by the state's compliance with the arbitration awards, particularly when it comes to enforcement, and the court's choice of the arbitration jurisprudence. As part of the Global South country, in order to catch up with its arbitration, particularly Asian arbitration counterparts, some legislative and policy gaps will need to be addressed. No doubt, it is not a clear understanding of this arbitration culture in South Korea, but interestingly, the development of the Korean Commercial Arbitration Board, particularly having its international wing dealing with international cases, the barriers of language has gone, and now KCAB, particularly the South Korean legislation, also is a guiding principle for the Global South countries to act. The South Korean declarations or reservations in the New York Convention is giving a greatest opportunity for all of us. The Korean Arbitration Act, which was first enacted in 1966, as Professor was highlighting the history, had some revision in 1999 to literally adopt the UNCITRAL model law. And in 2016, when we look on the Korean legislature, which passed an extensive amendment to this act, and the 2016 amendment, which is literally adopted of the amended 2006 model law, also is a welcome note. And all these set together, I think Professor Wu would accept that South Korea has also become a relevant destination or a seat for international arbitration. The notable work of KCAB, wherein our Professor O happened to be a panel arbitrator. Thanks, Professor O, being a KCAB arbitrator, coming forward for this event to share the inputs. this KCAB is the greatest example of how an arbitration institution should function. I think the contribution, what Professor O is facilitating to KCAB is noteworthy. And being KCAB the only officially recognized arbitration institution in Korea, not only an institution doing or facilitating institutional arbitration, KCAB also acts as an appointing authority for KCAB arbitrations and may also act as an appointing authority in non-KCAB arbitration seated in Korea. That's a very unique policy when we see about KCAB. In addition, what in our research and in the cases involved with KCAB, what we can understand is that in early 2018, if I'm not wrong, Korea also launched the Seoul Maritime Arbitrators Association, SMAA, which is similar to the very traditional arbitration association, the London Maritime Arbitrators Association, or similar to the Singapore Chamber of Maritime Arbitration. The growth in maritime arbitration also was taken into consideration, and Korea was one a traditional seat or a stronghold for arbitration, wanted to pull in maritime disputes also, in addition to investment arbitrations, commercial arbitrations. Now it is going to emanate as a hub for maritime arbitration also. With this, the great note about KCAB and the Korean seat for international arbitration, the specialized arbitration court also is a complementing factor. Even though we can't see as such a specialized arbitration court, certain courts which are established in Korea are considered to have a specialized subdivisions that handle international or cross-border cases. No doubt, Korea is going to be a seat for international arbitration, which is going to flourish. And with this development, and particularly professionals like Professor O and many of his colleagues in South Korea, we in KFCRI are going to take this forward in the future announcement of a greatest alliance among the Global South arbitration institutions, as well as universities and other academic bodies in Global South, along with the sovereign states in Global South. We are going to announce a greatest alliance, and that alliance is going to partner with Korean entities, Korean law firms, as well as, interestingly, with Professor O and KCAB. With this note, I thank Professor O for sparing his valuable time, particularly sharing his thought about arbitration in Korea. Thank you, Professor O.
Thank you, Mr. Inbavijayan. Yeah.
Thank you.
Thank you. Thank you, everyone.
We are pleased to welcome our next speaker, Mr. Harsh Mahaseth, a distinguished academic and legal scholar from Nepal, currently serving as an associate professor and research fellow at the Center for Alternative Dispute Resolution, Jindal Global Law School, OP Jindal University. With a specialization in public international law and Asian legal studies, Mr. Mahaseth has taught a leading institution including Nalsar University of Law and Mahindra University, and is recognized as one of the top-cited international law scholars in India. He is the co-founder of College Ket, a platform supporting students in their academic journeys abroad, and has held key administrative roles such as Assistant Dean and Assistant Director at JGU. A graduate from National University of Singapore and NALSA, With additional diplomas in diplomacy and journalism, he has authored over 50 peer-reviewed journal articles and 175 publications in global media. We are honored to welcome Mr. Harsh Mehseth to share his insights on ADR landscape in Nepal and to contribute richly to today's discussion. Over to you, sir.
Thank you so much. Namaste, everyone. My name is Harsh Mahasit, and thank you for the lovely introduction. And thank you so much to Inbavijayan sir as well as KFCRI for this invitation to talk about Nepal's role in international arbitration. If I might ask, will I be allowed to share my screen, or will I just ask for the next slide to come on?
I think we will assist you in changing the slides, sir.
Okay, sure. Then, if that is the case, just give me a minute because I had a couple of links open. So, just to give you a bit of background about Nepal so that you can understand more about where we are located as well as some of the context. Nepal is a landlocked country which is sandwiched between two major countries, India and China, which is the first piece of information. The second, which is important and also I think quite similar to our previous speaker, Professor O, is also that a lot of work that happens in Nepal happens in our national language, in Nepalese. And unfortunately, until now, a major part of it still continues to happen in our national language, Nepalese. And so, even for that, if we have a look at, if you could maybe just go to the next slide, because the next slide just talks about the 5 pointers that I was supposed to look at. Yes. So, in this, if we have a look at the third point, which is influential rulings by local courts, all of this is very tough to access as well for anyone from outside of Nepal or that does not know the Nepalese language, because all the court rulings would be in Nepali. I have added a few of them in my presentation as well. Hopefully, that is of help to understand more about Nepal. And the third thing to understand about Nepal is that we run on a specific calendar called the Bikram Sambat calendar, and that is going to be useful over here because the years that you will be seeing in our acts will be different from the usual AD years that you will be seeing. Because in Bikram Sambat calendar, we are already in 2082. So when we have a look at our act over here, you might see 2055 or 65. So I will try to give you the approximate year in AD as well in such circumstances to hopefully to ease things through. That being said, if we have a look at the neighboring countries in Asia, specifically South Asia or Southeast Asia, we would see that many countries do have very prominent roles in international arbitration. So, to give the example, India has a very robust arbitration situation scene. If we look at Southeast Asia, we would see Singapore with SIAC, Thailand with THIAC, as well as Malaysia with KLIAC. In comparison, Nepal does not have that robust of a place for international arbitration. However, that has been growing over the past few years. So, could you please go to the next slide? Do I have access to go to the next slide? Because I'm not sure where we are right now. If someone can confirm, am I on the overview PPT slide right now? I just moved it forward.
Sorry to interrupt, sir. Actually, it's a small technical glitch. Please give me a minute.
Okay,
Yeah.
sure.
Sir, is the slide visible?
Yes, it is.
Thank you, sir.
Okay, thank you so much. So, as we can see from the overview, Nepal has seen an increasing engagement in global legal and economic frameworks, as well as because of this, we do see growing importance being given to international arbitration. And interestingly, we do see both the public as well as private sectors uh, gradually becoming arbitration aware, as I will show you in the coming slides. We do have government agencies and state-owned enterprises who have started to increasingly incorporate arbitration clauses in their cross-border contracts. Specifically, certain areas have started doing this. As you can see, construction, hydropower, telecommunication are some areas where we have seen this growing importance being given to international arbitration. And of course, this shift does reflect a growing confidence in arbitration's efficiency and neutrality compared to the traditional court litigation. And to give you the fact scenario, there is a lot of delays that are suffered in traditional court litigation, due to which we see the growing need for arbitration. Can you go to the next slide? Um, yes, thank you. And I am just giving a caveat. I was I was here for most of Professor O's lecture as well, and he had a really lovely PPT. Unfortunately, mine is a very basic PPT that I use, which will basically just have the title as well as some of the facts. So apologies in advance for that. So coming back, if we have a look at the public sector involvement and private sector involvement, in public sector, we do see that the government is seen as a party in some occasional involvement in investment treaty disputes. We do see some state-owned enterprises as well in a limited capacity, in very few instances right now. However, that is an emerging area where there has been more involvement over time. And there are ongoing updates to our arbitration laws. There is an institutional role, as the government has put in efforts to promote Kathmandu as a potential hub for regional arbitration. While talking about that, in 2013, we did start the Kathmandu International Arbitration Center, KIAC. And when we're talking about ongoing updates, as you will see in the coming slides, there has been a recent update to our Arbitration Act, which is the Arbitration 2025 Ordinance. So I will be getting into that very slightly in the coming slides. So can you move to the next slide? Thank you. So while we have seen public sector involvement, there is definitely a huge private sector involvement as well, as we do see the increasing use of arbitration clauses in international commercial contracts. And as I had given examples, construction, energy, and telecommunication sectors are some of those sectors. Not just that, we do now see law firms and professionals have started specializing and gaining expertise in international arbitration practices. A lot of my colleagues, as well as juniors from college, have now started working in arbitration in Kathmandu itself. And it's not just that, but even Nepalese businesses are also increasingly involved in cross-border transactions, which has led to their participation in foreign administered arbitration proceedings. Now, while talking about foreign administered arbitration proceedings, we do see a lot of these cases being handled by the International Chamber of Commerce or the Singapore International Arbitration Center. And while this does show the importance of having clear arbitration clauses as well as a growing understanding of the arbitration norms amongst these Nepalese parties, we do see that most of these cases are going to SIAC or other arbitration centers rather than staying within Nepal itself. However, that being said, thank you so much for changing the slide. That being said, we do see that Nepal has seen the increased use of arbitration in construction, hydropower, infrastructure, telecommunication, and there has been this gradual shift from litigation to arbitration in commercial contracts. That being said, one very interesting thing I was just discussing with a couple of my colleagues a few days ago was with respect to the cases that come in front of the KIAC or in Nepal itself. Very interestingly, as I did mention that all of our laws as well as all of our judgments, everything, the entire process happens in our national language, Nepalese. Interestingly, arbitration, when we do go to arbitration, it can be decided either in English or in Nepali. And that all depends upon what the contract stipulates. So if the contract stipulates that it has to go to arbitration, and if they specify it has to go in a specific language, English or Nepali, that will take precedence over the Nepalese language, even if the contract says it has to go to arbitration and the language will be English. However, if there is no clause, then if both of the parties decide that it will go in Nepali, it will go ahead in Nepali. Can you go back? Thank you. So, that being said, there is greater awareness and training among legal professionals and corporate councils, the Nepal Bar Association, our bar council, and a lot of academic institutions are increasingly offer ADR-focused programs. I think just last month, we had a program for developing ADR skills in which a lot of organizations as well as law schools are organizing these programs, not only for the law students, but also for advocates, so that they are also increasingly aware about the different methods that are available under ADR. Now, these programs usually do invite all of these councils as well as, let's say, academics, judges who all know about ADR procedures to train all the students as well as other lawyers. And very interestingly, this has been happening nearly every month to alternate month now. And with that, we do see this increasing push towards ADR focused programs. Not just that, unlike our neighbors in India, where alternate dispute resolution as well as mediation have become core courses that have been mandated, in Nepal, we do not see that right now. We have started to see courses on ADR in the past few years, which I think is a positive aspect. However, there is still a lot that needs to be done. And of course, as you can see, there has been a push for digitalization and the use of online hearings post-COVID-19. And as I was mentioning, there is a new ordinance that has been promulgated this year itself, just a few months back. And could you move to the next slide now? Yes. If we have a look at our framework, the Arbitration Act of 1999, which is based on UNCITRAL model, however, there are of course gaps in this. Nepal became a signatory and there was accession in 1998. This enables recognition and enforcement of foreign awards. So apart from the 1999 Act, we also do have our Mediation Act of 2011, which is a very interesting act if you have a look at it. I had just done some research on the Mediation Act as well. However, it does complement ADR in Nepal, after which we do see the Arbitration Ordinance of 2025. There are several changes that have happened over the past 26 years. However, the latest ordinance is of 2025. And as I was mentioning, the Kathmandu Center for International Arbitration, apologies, was established in 2013. And while it had aimed to serve as a hub for regional and international commercial disputes, it is still in its very early nascent stages of development and recognition and has not been able to establish itself so much as the other neighboring countries that I did talk about in South and Southeast Asia. However, it is on track for that. If you can move ahead. Can you go to the next? Yes, thank you. So that being said, I was asked to look at a couple of influential local court rulings in which I have given three specific case laws. And over here, as you can see, this is what I was mentioning. The case, which is Bridgeline Corporation versus Agricultural Input Corporation, is a 2062 case. 2062 is Bikram Sambat. And since we are in 2082, we are minusing 62 from that. So this is 20 years back. So if you have a look at our judgments, we do have judgments from a few decades ago. And from this one, which I would say is the earliest one to look at, till what is happening right now. And the reason I was talking about how I selected three specific case laws and why these are important is also because, as I mentioned, all of our judgments are in Nepali, and this is just a basic translation or just my understanding. And also, I think this one is from a specific author that I had seen who had written about the specific topic as well. So I have compiled these three landmark cases that I thought are influential local court rulings that impact arbitration. So this first one, Bridgeline Corporation, if we have a look, the court has interpreted the existing arbitration laws and set a good precedent. So while rejecting writ petition, the court held that so long as there is an alternative provided for in the law, writ jurisdiction should not be invoked as a usual course of action. And so the Supreme Court held that it can entertain application or appeal only against the appellate court order or decisions. If you can move to the next one, I do see that I'm running out of time, so I'll just try to finish this in the next 1 or 2 minutes. This case of 2067, which would be 15 years ago, of Department of Road versus Viva Construction, held that where the dispute is to be resolved through arbitration, the court cannot enter into the factual questions, consider the evidence, and provide a decision in a manner similar to a normal case. So Supreme Court held that where there has not been any grave error in law, the court cannot invalidate an arbitral award. And if you can move to the next one. Over here, I'd also provided a link to the arbitration law in English. So this specific case, which is 2077, 5 years back, some would be 2020, which is Department of Roads versus Arbitral Tribunal, comprising of Mr. Sureshman Shrestha, Mr. Kamla Upreti, and Mr. Narendra Kumar Shrestha. The Supreme Court over here held that the court has the authority to invalidate an arbitral award and revert matter back to arbitration only under specific circumstances which are found within our Arbitration Act. And that is the link over there that I was going to open it and show you those. However, my slides will be available to all of you, hopefully, and you can have a look at this. Due to paucity of time, we will not be opening up that link. So if you can just move ahead, and I'll just move to, can you, yes. There are a lot of challenges to international arbitration in Nepal. It is facing significant challenges due to limited institutional support and infrastructure. The country also quite lacks a robust and widely recognized arbitration center, which is capable of handling complex or high-value disputes, as well as there being a limited pool of experienced arbitrators and trained legal experts. Due to which, as you had seen in a few slides before, a lot of parties do prefer going to, let's say, SIAC, and which leads to higher costs and also limited opportunities for local capacity building. Not just that, there are also judicial delays, as I was mentioning, as well as unpredictability in enforcement of these arbitral awards, as well as a lot of gaps within our own act as well. And there is a reluctance amongst domestic parties to opt for arbitration because a lot of parties do not still understand, or they're quite unfamiliar with the concept. So if you can just move ahead. However, that being said, there are a lot of opportunities in Nepal because we have seen an increase, as I was mentioning, in the conferences, workshops, as well as capacity building programs, not done only by the Nepal Bar Council, but also by leading law schools, as well as by organizations that bring together not only law students and lawyers, but also judges and academics. And as I mentioned, several law schools have also started to add ADR courses and even promote ADR competitions. And with that being said, there is a need to develop a strong and independent arbitration institution in Nepal. And we have seen a good start to that. And we do see a great progress coming over the years. And with that, there is just hope that this continues, and with more knowledge, more awareness, and more capacity building programs, we can see the international arbitration scene as well as the, in general, ADR scene in Nepal grow in the coming years. So thank you so much. Namaste. Thank you so much for inviting me, sir.
Thank you, Professor Harsh, for the insightful information about arbitration in Nepal. An interesting thing to share with you. I recently had a visit to Nepal for the Nepal ADR week, which was initiated by the Nepal International Arbitration Center. And significantly, multiple arbitration institutions in Nepal joined hands together and just structured that. And the takeaway was being a very landlocked country, as you rightly started with. Nepal wanted to initiate this green protocol in arbitration. And there was a declaration given on the end of that particular week stating that every Nepal arbitration institution, Nepal arbitration practitioners predominantly wanted to go for green protocol or green arbitration, a very interesting initiative wherein Nepal is going to be a major stakeholder in it. In my personal note, what I feel being a neighboring country and Nepal being part of the SAARC regional arrangement, there was one council, if in your research you can further stretch on it. It was called the SAARC Arbitration Council, which was initiated by all the member states in the South Asian region, wherein it wanted to bring in not only the arbitration institutions, the academic units, as well as the sovereign states in South Asia, to have a common legislations for arbitration. That was an initiative taken by SAARC Council, but for what reasons, it's yet to take off. But interestingly, the development, what you highlighted in Nepal regarding the growth, the significance, the uniqueness in Nepal arbitration arena, particularly the ADR arena, it was a good note from the government. The government had the initiative. The government is very keen that not only Nepal is good for spiritual tourism or for the general tourism or the wonderful opening to the world tallest peak. Why can't Nepal become a hub for arbitration? Not only in the context of international arbitration, but also in a green international arbitrations. And in that initiative, I feel it is very much required that we as an institution based in Global South and Nepal being a significant player in the Global South, we have to partner in a way how it has to be so that the path has to lead that every parties, whether it's a Nepali party or the Indian party or the parties from Global South, have to consider the seats, not only Kathmandu. Kathmandu being quite vulnerable for multiple reasons, particularly on the geological issues. We have the multiple arena in Nepal itself. There are multiple regions in Nepal wherein the court system as well as the legal systems are facilitating to make Nepal as a country to be a hub. I think in this front, we have to take it quite seriously, and our partnership should be in a long term, wherein the proposed Global South ADR Alliance, we expect your institutions, your academic bodies to partner, and we have to explore the greatest opportunity within the Global South. That's very significant. Thank you. Thank you, Mr. Harsh, for spending your valuable time so early in the morning. Being an initiative of 24 hours, your contribution is most valuable and commendable. As an academician, you always most welcome for our institution to take this task to the next level. Thank you.
So for the next speaker of the day, we have Ms. Andrea Orta. Ms. Andrea Orta, we are honored to welcome you, a distinguished legal professional with over 15 years of experience in dispute resolution, corporate, and transactional law across the infrastructure, transportation, energy, and financial sectors. As the founding partner of Orta Gonzalez Cecilia Abogados, Ms. Orta has built a reputation for excellence in both litigation and arbitration, representing domestic and international clients in civil, commercial, and administrative matters. She serves in key leadership roles with the global arbitration community, including as coordinator of the Arbitration Commission of the Mexican Bar Association, Vice President of the International Center of Arbitration of the Chamber of Belgium and Luxembourg in Peru, and the member of several prestigious bodies such as ICC Task Force on Disability Inclusion in Committee and the Award Scrutiny Commission of CIAM-CIAR, a seasoned arbitrator and counsel under UNCITRAL, ICC, ICDR, CAM, and CANACO rules. Ms. Orta also contributes to legal education as a professor of alternative dispute resolution at University of Panamericana School of Law. We are delighted to welcome her today as she shares her expert insights on the evolving ADR landscape in Mexico, offering a valuable perspective shaped by her extensive experience and leadership in the firm. With great pleasure, I now invite Ms. Andrea over to you to address us.
Hi, good morning and good afternoon, everyone. I am really happy. It's a pleasure to be here today and take part of this important conversation on international arbitration for 24 hours. This is a great event, and I'm delighted to share with you some insight on what is going on in Mexico. And I will start giving a little bit of context. Mexico adopted the UNCITRAL model law in 1993, when Mexico entered into the North American Free Trade Agreement, the NAFTA, that we executed with the United States and with Canada. And since then, Mexico has been considered as an important seat of arbitration. And I will refer to some statistics that show that Mexico is a really good seat so far in arbitration. And then I'm going to address some challenges that we are facing right now due to some changes that we are living in Mexico, basically based on government decisions. So ICC issued some statistic in October of last year. When you read the report regarding the cases in Latin America, Mexico to that date, October 2024, had 35 new cases. It was the first time that Mexico came before Brazil, which came in second with 29 cases. And the statistics that were published, preliminary statistics that the ICC again published in February this year, Mexico is considered within the 10 top jurisdictions of the seat of arbitration in ICC cases. This reflects that Mexico has significantly strengthened its position as a regional hub in international arbitration. Not only because we were ranked within this top 10 seat of arbitration, for February in this year, there were registered 30 cases, but 100 Mexican parties were involved in ICC cases. So we can see that in Mexico, we really use arbitration, although I have a personal critic to the way it is used, because we don't use arbitration as we should be using it. If we compare it with other countries such as Peru, even Panama, we don't have a lot of arbitration. And also considering the country that we are in, the position we have in North America. But these figures reflect the increase of participation, not only in arbitration, but Mexican businesses that are growing and that they give trust in Mexican legal framework and an institutional capacity to handle complex disputes. And in Mexico, we do not distinguish between national or international arbitration. The model law that is embedded in our commercial code regulates arbitration, both national and international, in the same way. So I think this is also something important, because in Mexico, the practice in arbitration basically reflects the international practice of arbitration, and most practitioners in arbitrations in Mexico have a lot of experience also in international arbitrations. And I think one key point at this part, let's say, of Mexico being an important seat of arbitration, not only for Latin America, but also for the world, is that we have had, since the adoption of the model law, the support of the judicial branch. Our judiciary has over time become a more arbitration friendly, with several court decisions reinforcing the principle of minimal judicial intervention and the enforceability of arbitral awards, which obviously is something that the users of arbitration, which is the companies doing business in Mexico, are really interested in that. And also, Mexico has several respected arbitration institutions, such as Canaco, which is the Chamber of Commerce of Mexico City. This chamber has its own center, which is the Mediation and Arbitration Center. And we also have another institution, which is the Centro de Arbitraje de Mexico, the CAM. And this institution play a really important role in both domestic and cross-border disputes. And I will also refer to the statistics of ICC for 2024, because during that year, ICC registered 152 new cases that were administered under the expedite procedures provisions. And I want to take a minute here and to talk about this topic, because I believe it is important for you to know that the Center of Mediation and Arbitration of the Chamber of Commerce of Mexico City, that we call it Canaco, I think it was one of the first institutions in the world that issued the rules for expedite procedures or for small claims. And this was before 2013. And since the date of the issuance of these specific rules for expedite procedure and small claims, we have seen an increase of the use of these rules over the time. And the rules were issued for two main reasons. The first one was to address a need expressed by the chamber's members who require disputes to be solved quickly. For example, in Canaco, we have registered some cases that were solved within 60 days, which is it's a lot. You have a ruling around 3 months. And it has special features, the rules. For example, the rules of the expedite procedures in Canaco states that the award doesn't need to contain the reasoning for the decision of the arbitral tribunal. Of course, there has to be a reasoning behind the decision, but you don't need to have the whole topic addressed in the award. And the other distinctive feature that the rules wanted to cover, and I think this is a really good one for young practitioners, it was an initiative also to help young lawyers to have their first case, so they can have their first designation in this type of procedures. So I think this initiative that in Mexico has been implemented for a really long time right now helps to solve cases efficiently, because it also contributes to the professional development of the next generation of arbitration practitioners. And well, right now, I'm going to address, because I think it's the important part here, it's what are the challenges that we are facing right now, considering that we have had a really past where the judiciary branch has also support the arbitration, and that's why we are a good seat for arbitration. And I'm going to address two important changes that we are going to see how they can impact arbitration and what is the landscape that we're expecting due to these specific changes. And well, the first one, and maybe you all know about it, the Mexican judicial reform that signed into law in September of last year by our president, it implies an institutional amendment affecting the judiciary. So this judicial reform entails some structural changes, reorganizing the Supreme Court. I'm not going to address these changes, but I'm only address the changes that I think will impact or may impact arbitration. And I think that one of the important aspects of this reform is the elimination of judicial career requirement and the selection of judges via vote in a popular election. And this will be an implementation, a change that will happen not only but at federal level, but eventually that will happen also in a local level. And with this reform and with the impact that it may have in the new type of judges that will come to the judiciary, maybe the people that do not have a lot of experience, not only in arbitration, but general experience talking about the law. So there's a concern regarding what will happen with the criteria and the precedents that we have already to this date in connection to the arbitration, but a good expectation that we have derived from this reform is that we believe that the judicial reform may increase a move to arbitration, specifically in commercial arbitration, because parties are afraid of the uncertainty that have turned into international arbitration as a mechanism to evade the uncertainties of the courts. So people that have their cases before the new judicial branch may seek another type of resolution, dispute resolution, such as arbitration and also mediation dispute boards. But we cannot say this is something that we need to celebrate because we believe there's another type of uncertainty in this regard because commercial arbitration is not the ultimate resolution. Arbitration and a well-functioning judiciary work hand in hand. So the judiciary plays a crucial role in supporting arbitration by assisting with the tribunal constitution, granting provisional relief when requested by a party, and I think most critically, facilitating the enforcement of arbitral awards. So this is the case that we are facing right now because there is some uncertainty on how the new judiciary is going to work and if the good rulings and precedents that exist to this date in connection to the arbitration will remain. Actually, the judiciary has given a really good support to the arbitration, not granting anti-arbitration injunctions that were somehow the application for such type of measures increased in the last years, and the judiciary has stopped this practice. But let's see how it's going to work when we have the new judges. And the other challenge that we are facing is that in January of last year was published the General Law on Alternative Dispute Resolution Mechanism. And this is a federal law. Before this law, each state has its own legislation on mediation. And this law recognizes some ADR, some alternative dispute resolution, such as negotiation, mediation, conciliation, and arbitration. We still don't have the complete regulation and guidelines for this law. They haven't been issued yet, but so there's some uncertainty in this regard also. And we are seeing how this law will apply in the practice. But there are some concerns regarding this specific law because, for example, one disposition contained in this General Law of Alternative Dispute Resolution Mechanism is that the requirement for being a facilitator, that's how the law identifies a mediator or a conciliator, it states that the person acting as a mediator need to be Mexican. So this is not a requirement that we have, for example, in Canaco. I am the former director of the Center of the mediation and arbitration of Canaco, and we do not have this type of requirements because actually we do international mediations and we also do international arbitration. So we are really on some uncertainty and we are skeptical on how the new judiciary is going to act. But well, so far, I believe that we, in a landscape, in a general landscape, we are a good seat in arbitration. We have really good arbitration practitioners. We have the support of the universities, and I think it's very, very important for the kids and for young students and young practitioners to be prepared and to cover the arbitration. I have seen during my practice how the arbitration landscape has changed. I heard the previous talk, and I like that Nepal is gonna go green. And actually, in Mexico, we adopt a lot of these initiatives as the pledge to have diversity, gender diversity. We also have, I was the only Mexican member of the task force for inclusion in disability. And there are many efforts that have been carried out in Mexico that are trying to increase the arbitration sector in Mexico. We have specific sectors that normally uses arbitration, oil and gas and energy. And normally it's because of the companies that do business in Mexico for the government enterprises such as Pemex, the oil company, and electricity. They are users of arbitration. But what we believe is that arbitration can also be a good way or to implement this type of solution for all the companies. But however, we have done a good effort in this regard. I think we need to improve and reinforce the knowledge of this type of ADRs because what we need is a fast decision on disputes. And I think we have acquire that with arbitration, but we need to acquire that with mediation. And I hope that we can implement more dispute resolution in Mexico. And so far, I think this will be my previous one. I don't know if I was told to finish 5 minutes in advance. I don't know if there are any questions there.
Andrea, it's not an issue. You can just further share some valuable points about the Mexican arbitration scenario another couple of minutes.
Yeah, perfect. Well, actually, I think that when I think about Mexico, is that the law, it's very similar to the model law. We only have one amendment that it was done in 2011, I think. And it gives the judiciary a really fast procedure in order to enforce the setting aside procedure, because it's very important. I think in Mexico, we have a really high standard when parties are seeking for setting aside an award. We have good rulings stating what should be understood or interpreted by the judges when they are discussing public order. That you know that public order, as some authors say, it's the unruling hers. And I think we have good resolution in good rulings on that regard. People have respected during these years the competence principle. So the judiciary normally, when they have a case that has an arbitration clause, they send parties to the arbitration. And I think we have good rulings also trying to enforce the spirit of the arbitration agreement. When the parties agree to arbitration, what they want is to have a solution to the dispute in a really effective way, but in a procedure in which you have all the right and the whole opportunity to really present the case. And when you search the precedents that we have in arbitration, you can tell that the judiciary actually honors the spirit of the New York Convention. Mexico was signed the New York Convention, and we are a sophisticated hub. We do not have a different practice between international and national practice, and I think this has also been reflected on how the judiciary has stand in support of the arbitration. And although if you compare Mexico to another countries, we do not have a lot of institutions administering the arbitration and other type of ADRs. Like, for example, I was hearing that Peru has like 200 and something institution. Of course, we do not have that number, and actually national institutions are like 2, 3 institutions, but they have members behind this institution that know the international practice. So you see that in the cases in Mexico, you see some trends that are implemented in international arbitration, but do you see them implemented also in national cases? I have seen in the last cases in which I am acting as an arbitrator, the MID conference, in which actually it helps the arbitral tribunal and the parties somehow focus the dispute in the key aspects that can help the arbitrators to solve the dispute. And we are using more and more the internet, these platforms from the institutions. So I think that there's a lot of things that have been done in Mexico, but there's also a lot that can be done because we are, and when I'm saying we, I'm referring to the Mexican arbitration community and practitioners. We are really capable to conduct complex disputes. And the awards that have been rendered in Mexico, most of them are enforced. And actually, talking about the expedite rules, some people are concerned because I know in some countries it is not possible for the parties to agree that the award will not contain the reasonings for the decision. But in Canaco, we have had cases which were submitted to the courts, Mexican courts, and the judge has stated that when you are talking about arbitration has specific rules, and you should not interpret the arbitration in the same way as a judge will interpret a ruling issued by a national judge. And I think this is important because in this case of expedite procedure, and I think there's a trend in using this type of rules because you have the ruling in really few months. In the case of Canaco and in other institutions, you have like the solution like in 6 months, 7 months, but you can enforce such awards. So I think the concern that I do have an award, but I don't have the reasoning described in the award, it's not really, let's say, a real concern because we have enforced, well, not we, but in Mexico, parties that use these type of rules, the expedite rules, have enforced these type of the awards. And I think this is also a really important reflection on how the Mexican judge understand arbitration, that in Mexico, people do understand the need to do business, the requirement of the business environment, and normally it's not the same needs that you will see in some courts, because with the pandemic, we saw that our courts were closed for several months, and in arbitration, practitioners were having hearings via Zoom or any other platform. But actually, it has been proven that arbitration works. So I hope that with all these changes, Mexico can have a lot of more arbitration, considering the economy worldwide that is Mexico. And I think that sometimes some changes are accelerated due to some external factors, and maybe this judicial reform and the way that international commerce is being carried out may impact in the way that arbitration has been evolving in Mexico.
Thank you, Andrea. It's an excellent thought, what you have just put forward. The country where your base, Mexico is doing a lot of reforms in arbitration, but per se, it is whether it is going to promote arbitration or it's going to just relook on the arbitration process. No doubt, amid concerns about these Mexicans' judicial reform, what you highlighted and the perspective of a former director of an arbitration institution, arbitration stands as the powerful alternative, whether it is going to be Mexico or any global South countries or global North countries. For arbitration to succeed, it needs to eventually have a legal framework that ensures autonomy, that ensures fairness and efficiency. That is the takeaway, what we can understand from your presentation. But to keep Mexico, anyway, there is a back-to-back presentation. Your former colleague, Mr. Edwin, is going to share for another 20 minutes. To keep Mexico as an attractive for arbitration, as well as ensuring an efficient resolution of dispute, we have to focus not only on institutional framework that is going to avoid over-regulation and strengthening arbitration institutions, whether in Mexico or the partnering countries. The fostering a culture driven by governmental as well as non-governmental institutions surely would uphold the highest standard of voluntary compliance of award. All set together as an arbitration practitioner and being part of several arbitration institutions, ensuring autonomy, fairness, efficiency, as well as compliance of award. That is the expectation of the parties. And despite these challenges, at this juncture, representing a very, very significant country, Mexico, this situation is going to give us an invaluable opportunity to rethink arbitration in the Global South. That is the outcome of your excellent presentation. Thank you, Andrea, for accepting within a short notice. We are just behind you for a week, more than a week. And we are very happy that even though it is quite late in Mexico, you just wanted to share your thought on the growth of arbitration. And at this point, being a former official of an arbitration institution and now a practitioner, we are very keen to make this arbitration in Global South to be a 24/7 affair. We are available. We all have to be available so that the judiciary is going to support us. The court system is going to be with us. The reforms also would go along with this. And as an alliance of all the Global South ADR practitioners, academicians, academic bodies, as well as institutions, we can facilitate. That has to be the theme of this gathering. We have just making it as a trial. Anyway, this is a trial, and we need your support in a long-term basis so that it is going to be a win-win situation for all the stakeholders. Thank you. Thank you, Andrea. And any further questions comes, it will be shared with you. Thank you. Bye. Have a nice weekend.
So before we move on to the next speaker of the day, we at KFCRI would like to share a short video that highlights our institution's journey and gives you a better insight into who we are. Please sit back and enjoy this presentation.
As a protocol, looking into the development of the sustainable growth, we intentionally, for some occasions when you are playing this video, the audio has been cut so that we are adhering to the protocols. And with this note, I'll just hand over to my colleagues to take it forward to the next session.
So the next speaker for the day, we are honored to introduce Mr. Edwin Nemesio, a distinguished international arbitration expert and business attorney based in Mexico City. As the founding partner and head of international arbitration practice at NR Law, Mr. Edwin brings extensive experience in investor, state, and commercial arbitration, contract law, and cross-border business transactions. He has served as counsel in complex arbitration proceedings under leading international rules and has advised major corporations such as Grupo Cinemex, Grupo Hedas, and Sony Pictures Televisions Latin America. A dual LLM graduate in international arbitration and human rights, he is also recognized as a member of SIAB and has been featured in Who's Who in America 2023 to 2024. We warmly welcome you, sir, to share your perspectives on the ADR landscape in Mexico and to enrich today's proceedings with your global legal acumen. Over to you, sir.
Thank you. First of all, I want to thank you to Kovise Foundation Conflict Resolution International for this warm invitation, celebrating the Global South ADR THIRUNAAL. So it's a really big pleasure to be here. Now we are talking about the current affairs of international commercial arbitration in Mexico. As my predecessor said very well, Mexico stands out of the world's leading jurisdictions in arbitration. Over the last 5 years, Mexico has consistently ranked within the top 10 countries with the most parties participating in arbitration proceedings administered under the arbitration rules of International Chamber of Commerce. The prominence of Mexico in the field of domestic and international arbitration arises from multiple factors. The country's growing economic relevance on a global scale and its wealth in natural resources becomes Mexico as an attractive jurisdiction in terms of investment and development of extractive and production industries. This significantly contributes to its importance in the arbitration scene. We safely say that Mexico is a pro-arbitration jurisdiction. Mexico has adopted an arbitration legal framework that conforms with the highest international standards and has ratified a considerable number of treaties with investment protection provisions. Apart from having two growing local institutions, the National Chamber of Commerce of Mexico City and the Arbitration Center of Mexico, Mexicans are among the top users of the most renowned international arbitration institutions. The inclusion of arbitration agreements in government contracts is only one of the many factors that contribute to the extensive use of arbitration in Mexico. Let's move on to the Mexican legal framework. Arbitration holds a prominent position in Mexico's legal system because it's governed by provisions outlined in the Constitution, in international treaties, and federal law. The Mexican legal framework on international arbitration started with signing international instruments, in particular, the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the New York Convention. The next one is the Inter-American Convention on International Commercial Arbitration, the Panama Convention, and the Inter-American Convention on Extraterritorial Validity of Foreign Judgments and Arbitral Awards, the Uruguay Convention. Despite acceding to such international instruments, Mexico was neither an active nor an attractive market for the practice of international commercial arbitration. It wasn't until the 1990s when Mexico's economy further opened to foreign investment by signing the North America Free Trade Agreement, the NAFTA, alongside the United States of America and Canada. At the time of the NAFTA negotiations in 1993, Mexico decided to adopt the UNCITRAL model law on international commercial arbitration by integrating it into the commercial code by inserting a fourth title on commercial arbitration. The purpose of this legal reform was to consolidate Mexico's vision on the open market economy. It states that Mexico's internationalist project could not be disassociated from the new political and economic challenges that were already shaping international relations. Also, as part of this economic modernization, Mexico underwent an important process of legislative transformation that would facilitate its full integration into world trade. In 2008, Article 17 of the Federal Constitution was amended to include alternative dispute resolution mechanisms. So it must be considered, at the very least, that the possibility of resorting to such mechanisms, like arbitration, must be qualified as a constitutionally protected interest. More recently, in 2011, the Mexican Congress further amended the Commercial Code to update its arbitration system, and in particular, to regulate judicial intervention in arbitration proceedings. Now, let's move on to talk about the judicial precedents related to arbitration. The understanding of the Mexican lex arbitrii cannot be complete without considering judicial precedents issued by Mexican courts to interpret and apply it. The provisions of the Code of Commerce and the decisions of judges jointly are what truly represent Mexican arbitration practice. I will explain a few Mexican judicial precedents. The first topic will be limited extent of judicial intervention in arbitrations. Mexican courts have reaffirmed the principle of minimum judicial intervention in arbitration and invited judges to only intervene in arbitration in the limited circumstances allowed by the lex arbitrii. In addition, a Mexican court went even further by clarifying that Mexican courts had no jurisdiction to decide procedural aspects of arbitrations or review interim procedural decisions made by the arbitral tribunals. The court reasoned that arbitration proceedings should have no judicial intervention to guarantee the efficiency and autonomy of arbitration from court proceedings. The next theme is the discretion of Mexican courts to grant interim measures in support of arbitration. The court established that it has a broad discretion to grant interim measures in support of arbitration due to the diversity and unpredictability of situations that may require said kind of relief. Also, the court clarified that courts must conform to standards of reasonability and coherence when issuing these orders. The next subject is the ex parte interim measures issued by Mexican courts in support of arbitration. A Mexican court interpreted that interim measures issued by Mexican courts in support of arbitration could be initially issued ex parte to secure the effectiveness of the measure. The affected party by the interim measure will then be called to the interim measures proceeding, be heard, and have an opportunity to combat the initial interim measures, and then the judge will eventually issue a final interim measures decision. The next topic is the standard of judicial review of the existence and validity of an arbitration agreement when deciding a request for referral to arbitration. A Mexican court concluded that the threshold to determine that an arbitration agreement is null and void, inoperative, or incapable of being performed when decided not to refer a dispute to arbitration should be high. The judge ruled that said decision could only be reached if 1. There is evidence that the arbitration agreement was nullified by a judicial ruling or arbitration award, or 2, if the arbitration agreement notoriously meets any of the above-mentioned grounds. Another precedent related to this issue determined that the inability of one of the parties to pay the fees of the arbitration institution doesn't make the arbitration agreement impossible to perform. The next subject is the standard of judicial review of a jurisdiction determination made by an arbitral tribunal. A Mexican court determined that the judge must refrain from analyzing a jurisdiction decision from an arbitral tribunal as if it were analyzing an appeal. The court reasoned that the judicial review of said decision should have 2 steps. First, the judge must review the text of the arbitration agreement to determine if it is clearly valid. Second, if the agreement is not clearly valid, the judge must verify if the decision of the arbitral tribunal to deem it valid is reasonable. In the second step, the judge may only consider the arbitration clause invalid if it finds that the reasoning of the arbitral tribunal was arbitrary or insufficient. The next theme is the res judicata effects of the judicial review of the jurisdiction of an arbitral tribunal. Mexican courts have determined that any decision reached by a judge in the exercise of its judicial review of a jurisdiction decision by an arbitral tribunal has res judicata effects and cannot be revisited. This means that a judge has already ruled that an arbitral tribunal had jurisdiction when reviewing a jurisdiction award, then that decision cannot be revisited by a court in set-aside proceedings of the final award. The next topic is the standard of judicial review of awards by Mexican courts in set-aside proceedings. Mexican courts have reaffirmed that judges cannot revisit the merits on the case in set-aside proceedings and can only analyze if the award meets one of the grounds for set-aside provided by Article 1457 of the Code of Commerce, which is what, with all accounts, it is a verbatim of the grounds established in the New York Convention. Also, it concludes that the burden of proof of demonstrating that one of the grounds for set-aside is met is one of on the party that requires the annulment of the award, and that if that burden of proof is not met, then the award will be valid. In addition, the Mexican Supreme Court especially analyzed the standard judicial review of an award when a party argues that the arbitral tribunal violates due process because of an incorrect analysis of the relevance and weight of the evidence. The Supreme Court determined that the arbitral tribunal has the power to determine the admissibility and weight of evidence, and thereof, if a court reviews this issue, it will be revisiting the decision on the merits of the case, which is not a law. The next topic is the preclusion of filing several set-aside requests against the same award. A Mexican court reasoned that a party that wishes to set aside an award must include all the grounds it considers are met in its initial set-aside request. Then, the court considers that a party should not be allowed to file several set-aside requests against the same award invoking different grounds, even if it does so within the 3-month period provided for that purpose. The next theme is the motivation of an arbitral award. The jurisdictional guarantees of providing legal grounds and reasoning are public rights enforceable by the authorities exercising a jurisdictional function, but not private arbitrations. In that context, the Commercial Code is based on the general obligation to state reasons for arbitral awards, although it cannot be said that the ratio of the reason for arbitration is Articles 14 and 16 of the Federal Constitution, or their equivalence with the judicial function. Rather, the reasons for an arbitral award are based on practical and logical reasoning. The next subject is the duly authenticated or duly certified copy requirement. This requirement is established in Article 1461 of the Code of Commerce. This requirement cannot be understood as a requirement aimed at endorsing or demonstrating the formal and material validity of an arbitral award or its binding nature. This is because the authentication is only a mechanism purposed to provide greater certainty about authenticity and to reduce the probability of an eventual claim of falsity of the document itself, giving legal certainty to the procedure. By the same legal reasoning, the fact that an original award or a certified copy thereof is presented without having been authenticated through a notarial act that records the acknowledgement and ratification of the arbitrator's signature doesn't mean that the award is not authentic or that it should be presumed to be false or that it lacks in itself any probative value. The next subject is the due process and legality of an arbitral proceedings. Arbitral awards are not directly governed by Articles 14 and 16 of the Constitution, which regulate acts of public authorities. But, as the Supreme Court has held, this doesn't mean that there is no right of due process in arbitration, but only that protections are not directly based on those constitutional provisions. On the contrary, due process and legality of an arbitration proceeding is protected by Article 17 of the Constitution, Article 5, Section 1, and Subsection B, both of the New York Convention and the Panama Convention. The last topic is the appeal review of an arbitral award in the same arbitral system. The Commercial Code doesn't provide for an ordinary appeal against an arbitral award, or with the same effects as an appeal by the state jurisdiction. However, the Supreme Court established that there is no provision or legal impossibility for commercial arbitration parties to agree on an arbitral award. This may be reviewed in its legality by a different arbitral tribunal as a second level of review of the award within the same arbitral system. That is because it is within the scope of the parties' freedom to introduce into the arbitration agreement a review of this nature in the same arbitral system. Since the parties are not prohibited from agreeing to this kind of review in the arbitration agreement within the boundaries of the arbitral system. Now, we'll talk about the current trends in Mexico's arbitration practice. One factor that seems to have contributed to the increase in the use of arbitration in Mexico is the inclusion of arbitration clauses in contracts by foreign investors, government agencies, and state-owned companies. Another factor that may contribute to the strengthening arbitration in Mexico could be the efforts made by the Mexican arbitration institutions to adapt their rules and practices to international arbitration developments. In the past years, the number of commercial arbitration has increased due to the arrival of foreign investors who requested the inclusion of arbitration agreements as part of their negotiation strategy in their contracts. The increase in foreign investment may be attributed to the adoption of a comprehensive investment protection legal framework in Mexico. In addition, several government agencies, such as the Mexican Hydrocarbons Commission and state-owned entities, consistently include arbitration clauses in a significant number of contracts. The above-mentioned factors have contributed to Mexican private and state-owned companies becoming top users of international arbitration institutions, such as the ICC, ICDR, and the London Court of International Arbitration. Next, I will talk about the arbitration limitations in Mexico. While Mexican law doesn't specify a list of arbitrable subjects, certain laws do reserve specific matters for Mexican courts. For example, the Mexico City Civil Procedure Code provides that family law matters such as alimony, divorce, matrimonial property, and custody are reserved for Mexican courts. The Federal Civil Code provides that matters corresponding to an individual's legal capacity, criminal damages, and wills or estates are reserved for Mexican judicial tribunals. Mexican law prohibits parties from referring administrative recession or early termination of public contracts to arbitration. The public-private partnership law prohibits the revocation of concessions and action in which a state acts in its official capacity, as opposed to as a contracting private party. Currently, these matters are exclusively handled by administrative state tribunals, meaning that arbitration is not an option. Nevertheless, damages resulting from the illegal termination or administrative rescission of contracts can be resolved through arbitration. The next slide is about the challenges for arbitration in Mexico. Even if it may seem that Mexican arbitration is in its prime, that doesn't mean that this dispute resolution mechanism is not facing considerable challenges. As my predecessor said, in 2024, a constitutional reform transformed the basis and structure of the Mexican federal judiciary. The most debated and criticized aspect of the reform is the proposal to elect judges, magistrates, and justices through a secret and popular vote, rather than appointing them based on their judicial career. A fundamental criticism of the reform is the potential for politicization and reduced specialization within the judiciary. The reform is expected to increase the use of arbitration and other forms of ADR because of the potentially reduced specialization in the judiciary. Despite this promising shift, the involvement of state courts in arbitration process means that Mexico's status as a key arbitration hub relies heavily on a robust and competent judiciary. The judicial reforms could significantly influence this capability. My final remarks in this conversation is with the 30 years of arbitration legislation and experience, Mexico now boasts a strong legal framework and a thriving practice in commercial arbitration. The Commercial Code has consistently respected the UNCITRAL model law text. The Mexican judiciary has consistently supported arbitration, establishing consistent precedents, particularly when analyzing public policy as grounds for annulling an award or preventing its enforcement. In Mexico, public policy in arbitration is an extraordinary concept linked to the most fundamental principles and pillars of its legal order. As long as an award doesn't harm these pillars and principles, any challenge against it should fail. Local arbitration institutions and the Mexican chapters of international institutions play an important role in Mexican arbitration. They not only promote arbitration, but also advocate for additional rules and initiatives in areas such as gender, equality, transparency, best practices, and ethics. Thank you very much. I'm happy to receive any question for the audience.
Thank you, Edwin, for the insightful and even though it is a back-to-back about Mexico, it is a well-structured the information what you are given about particularly the limitations what you are facing in Mexico. We are very happy to have the very successful participation from Mexico, particularly from ENAR. I hope I am correctly identifying your law firm's very, very significant point. We all are very, very interested to have Mexico, particularly the practitioners and institutions in Mexico, to be actively involved in this alliance what we are proposing, likely to propose by end of this day. And this is going to be a long-term relationship. And Edwin, you are going to be part of this significant task as an arbitration practitioner as well as an arbitrator. Thank you, Edwin, once again for sharing the wonderful thought about the existing scenario of arbitration in Mexico in all perspective. That is very important as a practitioner who is going to be the end user of this particular ADR platform. We feel that it is going to be a long period to accept these reforms, what's happening in Mexico, and subject to the judicial precedents, it is going to be the ultimate growth of ADR in Mexico as well as global South countries. Thank you. Thank you for your valuable thoughts.
Thank you. I appreciate it. It's been a lovely experience. Thank you.
Moving forward, we are now having the inauguration session of this virtual gathering of the first Global South ADR THIRUNAAL. For the first speaker, now I welcome Mr. Vinod Solomon, the Secretary General of the Southern Indian Chamber of Commerce and Industries, where he leads the strategic and operational activities of one of the India's oldest and most prominent trade associations. With over 20 years of experience, he has held significant roles in Principal Consultant at Sri City Integrated Business City and Regional Director at ASSOCHAM. He begins his career as Pentas of Technologies and has worked in various leadership capacities in India and UK. Mr. Vinod holds a BE degree from Bharathiar University and an MBA in Statistics from the University of Leicester. He is also a certified insolvency professional and author of 2 books, Insolvency and Bankruptcy Code, A Quick Guide to and Mastering Insolvency, and bankruptcy code, and integrated approach. We are privileged to welcome Mr. Vinod Solomon to share his insights and contribute to the depth and diversity of today's discussion. Over to you, sir.
Thank you, Sippy. Am I audible?
Yes, sir. You're audible.
Yeah, sure. Thank you so much. I would just like to share a few words on what the Southern India Chamber is all about and what we do towards promoting arbitration and what we see as the way forward as we move on in this context. SICI is 115 years old. The chamber was formed under the inspiration of Gandhiji. So when Mahatma Gandhi was fighting for the political independence of the country, he encouraged Piti Tyagaraja Chettiar to fight for the economic independence of the country. And that's how the chamber came to be formed. And in one of his earliest addresses to the business community in Madras, Gandhiji exhorted organizations like SICI to bring awareness about the legal framework among the traders and business entities on one side, and also make the law simple for the entire industry to follow and comply. So right from the day one, the Southern India Chamber has been doing its best to focus on arbitration as a viable alternative to the courts. Of late, with the Supreme Court making a very concerted stand to promote arbitration as a means to kind of bring the litigations down and also promote ease of doing business, SICI has been pretty aggressive in helping create an ecosystem where arbitration and dispute resolution is effectively facilitated. So the chamber set up the SICI Center for Arbitration and Dispute Resolution with Mr. Inbavijayan as the chair and the champion for that. And we've been pretty active over the past few years in helping create a favorable ecosystem for arbitration in the southern part of India. Because SICI was the founding member of FICI, the Federation of Indian Chamber of Commerce and Industry, we've also been very actively involved in the Indian Council of Arbitration, the International Chamber of Commerce and Industry, and we've been really been effective in connecting with all the global arbitration bodies as well. So how does SICI promote arbitration? In addition to the center and the regular arbitration hearings, proceedings, and the services that we provide, the chamber also hosts several events, right from workshops to conferences to webinars. There are multiple events and activities that the chamber does to promote arbitration, to help the businesses explore arbitration and dispute resolution as a viable alternative. The chamber also comes out with several reports, knowledge reports. We do a lot of publications to really bring awareness about the arbitration process and encourage businesses to follow that. And third, we also have multiple engagements with the governments and other stakeholders. Especially, we have a good rapport with the MSME department, wherein we are promoting the MSMEs to look at arbitration because there are plenty of disputes that need to be resolved, and the MSMEs, for them to access courts and invest their time and resources, it is a very Herculean task for them to get that done. So we try to step in between and provide them solutions. We are also engaging with the Tamil Nadu Skill Development Corporation. The Skill Development Corporation is tasked with skilling, reskilling, and helping the youth of the state with finding career pathways. So we are working with the Tamil Nadu Skill Development Corporation to train the youth in pursuing arbitration as a career option. We also work with several international organizations, UN organizations, So when we talk about the international concept, international context, the chamber has been leading business delegations every quarter, and wherever we go, arbitration is a critical part of our outreach. So we had a delegation to France where we were able to visit ICC in Paris. In Mauritius, we had engagements with the arbitration setup in Mauritius. And even now, as we move to Taiwan and other countries, arbitration has always been a critical component of our international outreach. So even today, as we stand in, as we walk in exciting times for arbitration and the dispute resolution segment, we are still looking at new areas for growth. And this even today, it's a good platform for chambers like SICI to explore partnerships, sustainable relationships over the long term. And this Global South partnership is an excellent idea whose time has come, and we can forge new partnerships as we move forward. We also look at foraying into newer sectors. There are a lot of inquiries about and the need for arbitration in sectors like the southern region is pretty strong in the shipping and maritime sector. There is a good need for arbitration in the construction sector, in the movie industry. There are a huge number of arbitration happening in Bollywood. So we hope that we'll be able to offer similar services down south as well. So there are a lot of things that we can do. The chamber is a platform. So we are a good foundation for all the stakeholders, government, industry, academia, think tanks, research bodies, every stakeholder to come along and work with SICI. So at this juncture, I would like to invite all participants to feel free to drop into the chamber. Please engage with us. So we have a good a champion for us. Mr. Inbavijayan is there to continue to lead the chamber into newer areas. So please, this is an invitation, open invitation for every member to kindly walk with us, journey with us, and let's do our bit to build an even stronger ecosystem for arbitration and dispute resolution. So as I conclude, I would like to leave behind a quote from Alan Redfern. He says, arbitration doesn't just resolve disputes, it preserves relationships. End of the day, that's what matters. It's the relationship that helps us look at a long-term future. So let us focus on that, and all things will fall in place. Thank you so much. I wish you a good day.
Thank you, Mr. Vinod. The spirit and sentiment, what I can see from your inauguration talk, is most welcome. And being part of the initiative done by the century-old Southern India Chamber of Commerce Industry is going to be a history for all of us. And particularly when it comes to the Southern Indian business community, already SICI Center for ADR is doing the best what possible, and it will continue. And obviously, SICI Center for ADR is going to be the major player for this alliance, that is a Global South ADR Alliance, which we are planning to just work it out in a larger scale, wherein the traditional seat strongholds, which is considered to be the Global North, now it is looking the paradigm shift to the Global South. Thank you, Mr. Vinod, for joining us quite early in the morning, so that this will be a long-term development goal. Thank you.
Now, we are privileged to welcome Dr. Sundar Raju, a globally respected figure in the field of international arbitration and alternative dispute resolution, currently serving as the president of Asian Institute of Alternative Dispute Resolution, AIADR. Sir is also the former director of the Asian International Arbitration Center, AIAC, where he played a transformative role in elevating the institution's regional and global stature. Under his leadership, AIAC's caseload expanded dramatically, reflecting his visionary approach to institutional arbitration. A chartered arbitrator and certified international ADR practitioner, Dr. Sundar Raju has held numerous prestigious positions, including Global President of the Chartered Institute of Arbitrators and Deputy Chairman of the FIFA Adjudicatory Chamber. With over 310 appointments in international and domestic arbitration, he brings unparalleled expertise across sectors and jurisdiction. His academic contribution as a professor and author of seminal works on arbitration and construction law further underscore his influence in shaping legal discourse. We are honored to have Dr. Sundar Raju join us today to share his insights on the notion of ADR, drawing from his decades of leadership, scholarship, and practice. With great pleasure, I now invite you, sir, to address us today.
Professor, you have to unmute your audio.
Because I see my picture. Thank you so much for your kind words. It is, I must say, distinguished colleagues, esteemed members of the arbitral community, ladies and gentlemen. Thank you, Imba. It is both a privilege and a pleasure to address you all today on the Global South ADR Day. I believe that this is the first time this event is occurring from south of India, and it is actually giving an opportunity for voices from our region, that is Asia, to contribute meaningfully to the global discourse on ADR. My topic that I'm going to cover today is arbitration in Asia, an overview, but I must quickly say that Asia is very big. So I'm going to focus on some key areas, particularly Singapore. But other than that, you are aware that Asia now is home to the world's fastest growing economies and also population. It's no longer just a participant in the global arbitration landscape. Asia is actually starting to shape it. Over the last 2 decades, the region has undergone remarkable transformation. And there is so much legal reform that is going on. The frameworks are being reformed and innovated, and arbitral institutions are being set up and being modernized. There is considerable jurisprudence that is coming, and it is starting to affect international practice. So Asia is increasingly recognized not just as a venue for arbitration, but as one of the thought leaders leading arbitration. Now, let us step back and appreciate how we are seen in a global context. For many decades, international arbitration was perceived to be the dominant of Western institutions, and they are based in London, Paris, Geneva, and New York. To a large extent, these became default seats of arbitration because they have a mature legal system supported by reputable institutions. But today, the landscape is changing. Asia is no more peripheral. It is now pivotal, with Singapore, with Hong Kong, and ranked among the top arbitral seats, with institutions like SIAC, HKIC, and even CTEC in China, because consistently outperforming global competitors in terms of case numbers and user satisfaction. The center of gravity has shifted eastward. This shift is not simply geographical, it is structural. It is driven by Asia's economic growth and matured legal, as the legal and institutional framework are becoming more matured, and the deliberate cultivation of arbitration-friendly jurisdiction. Now, I think we can see the statistics in the annual Queen Mary, even this year, that they just came out, the University of London White and Case International Arbitration Survey. And I think now Singapore, Hong Kong, and China are ranked in the top list of, except for London. So in fact, they have taken Paris. So after London, Singapore, Hong Kong, now even CTEC is in China, has become popular institutions, and those regions have also become popular arbitral seats. So I think 3 or 4 of the most preferred arbitral institutions are now located in Asia. This is talking about international commercial arbitration. But all this is coming back to one thing that is happening in Asia. The foundation of Asia's arbitration rise lies in its embrace of legal harmonization and the rule of law. And most of the region's leading arbitral jurisdictions have adopted UNCITRAL model law. That includes India, very important jurisdiction, producing now a lot of disputes which are being settled not only in India but outside of India. And I think the commitment, particularly in Asia, to a uniform, predictable, and internationally recognized procedural framework is very, very important. And all the countries, I think, have adopted and embedded these principles into their domestic law. I think one major country that has not adopted model law in Asia is Indonesia. But I think it's a matter of time. I will be traveling to Indonesia next month, and I will be actually talking to people to see how the progress is going to be. But I think the best example for us to look at in Asia on how remarkable the change has become is that you must look at Singapore. Singapore's International Arbitration Act not only incorporates model law, but reflects a deep commitment to minimal judicial interference, party autonomy, and enforcement certainty. It has been amended several times to stay ahead with global trends. It has embraced third-party funding, conditional fee agreements, emergency arbitration recognition. Malaysia also has made quiet but important strides. So I think the more important thing is that the important jurisdictions that are in Asia are actually also moving incrementally. For example, both China and India. So I think the recent drafts concepts basically each reform may seem for many of us as technical in isolation, but when we put it all together, all these reforms that are going on in the region, you can see there is a movement and attunement to international standards. Therefore, we just not want to be participants, but rather we want to be norm shapers. Now, the role of the courts is showing jurisprudential maturity, and I think the courts are the guardians of legal coherence. And in Asia, judicial support for arbitration has become a defining feature of the region's credibility. And I think you can look at many jurisdictions in Asia, from Singapore to Hong Kong to India to even China, and I think various locations. For example, in Singapore, the case of Anupam Mittal versus Westbridge Ventures, where the Singapore Court of Appeal considered the delicate issue of subject matter arbitrability, where the law of the seat and the law of the arbitration agreement differed. So the court adopted a dual framework approach, balancing enforceability and policy coherence, but it is a nuanced position which reflects judicial sophistication rather than a simplistic deference to intervention. In other cases, CBX versus CBZ, Republic of India versus Vedanta, CVG versus CVH, the Singaporean courts have clarified fundamental issues like jurisdiction, interim measures, due process, and finality of awards. Importantly, they have consistently emphasized minimal curial intervention, only stepping in where the fairness of natural justice is generally compromised. Then, when we look at the Indian courts, it's a bit more complex. The picture is more complex. So, while decisions like Delhi Metro versus MEPL have drawn criticism for an expensive review under public policy, there have also been very strong pro-arbitration rulings from the Supreme Court, particularly in enforcing foreign-seated awards and affirming party autonomy. So I think this reflects not uniformity, but more of an evolving jurisprudence across Asia, which is slowly and surely converging towards best international practices. Now, I want to talk about institutions itself. The number of institutions in Asia is increasing. They are not only increasing, but they are also innovating, and this can be best seen, for example, in the 2025 SIAC rules, for example, streamlined procedure for lower value disputes. Unlike the earlier expedited procedure, the streamlined model mandates resolution within 3 months, caps the tribunal fees at 50%, and operates primarily on written submissions. So such kind of procedures will be ideal for small, medium-sized enterprises, startups, regional disputes where value is in cost efficiency. So I think it strengthens the framework eventually in coordinating proceedings, in emergency arbitration and preliminary determinations, reflecting, I think more importantly, reflecting a sensitivity to the needs of the modern commercial practice, both complex, fast-moving, and often multi-jurisdictional. So I want to move to other two key jurisdictions. One is in China. China appears to be moving towards harmonizing its arbitral framework with international standards, including the potential removal of its long-standing prohibition on ad hoc arbitrations. In fact, the theory at the present moment, or the rule of law at the present moment, only institutional arbitration is recognized in China. So it is completely opposite that of India. And the latest draft amendments to the arbitration law of the People's Republic of China suggest a more cautious and conservative approach than originally anticipated. So currently, ad hoc arbitration is permitted under Chinese law only in cases involving foreign-related element. And this includes situations where at least one party is a foreign citizen, a legal entity or organization, or at least one party habitually resides outside mainland China, or the subject matter of the dispute is located abroad, or the legal facts that create, modify, or terminate the civil relationship between the parties occurred outside of China. I think the Ministry of Justice have been releasing versions of the PRC arbitration law to actually try to elicit interests and also comment to allow ad hoc arbitrations between domestic parties. But I don't think so it's going to take off because I think they still want to actually keep it in China. But I think eventually the version of the act that I've seen introduces the concept of the seat of arbitration, which was previously not recognized in Chinese legislation or judicial practice. So in the absence of this concept, the nationality of arbitral awards in China have been traditionally determined on the location of the arbitral institution administering the the proceedings. I think the 24 in last year, they issued a draft, and there seemed to be a step back from some key reforms that were proposed earlier in 2021. So now I think they reinstate the requirement for the establishment of an arbitral commission. Their institutions are called commissions, and then reviving the uncertainty whether foreign arbitral institutions meet the strict qualifications under Chinese law. As a result, it remains unclear whether arbitration agreements that designate foreign institutions can be considered valid under Chinese law. Additionally, the last year's draft omits the previously proposed recognition of competence doctrine, which allowed the arbitral tribunal to rule on their own jurisdiction. Nevertheless, the proposed formal inclusion of ad hoc arbitration, for me, represents a positive development for the Chinese arbitration landscape. If adopted, it will significantly enhance the growth and appeal of arbitration in China, offering new opportunities for practitioners and parties seeking to resolve the disputes within their country. Now, India, I think there has been a number of proposals since 2015 and have been applied to amend the Arbitration and Conciliation Act 1996. The latest draft Arbitration and Conciliation Amendment Bill continues the reform path began in 2019. The bill's central goal is to curb excessive court involvement and to accelerate arbitration proceedings. It does so by imposing even stricter time limits, both on the courts and tribunals when they deal with arbitration-related matters, allowing parties to seek interim relief from an emergency arbitrator after request for arbitration is filed and before the arbitral tribunal is in place. Another innovation is the creation of an appellate arbitral tribunal empowered to hear challenges towards awards. This mechanism is modeled on systems used by institutions such as the European Court of Arbitration and the American Arbitral Institution, which let the party agree that any attempt to set aside an award would be heard by specialist appellate bodies rather than the court. Now, I think this bill is timely, particularly given the recent court decisions revealing gaps in the India's arbitral framework. The ongoing Anupam Mittal litigation highlights the difficulty which arises when the arbitral seat differs from the contract governing law. Amid anti-suit injunctions proceedings in Singapore, Mittal persuaded the Bombay High Court to restrain Westbridge from enforcing the Singapore order in India. The court had reasoned that any ICC award rendered in Singapore would be unenforceable in India because the dispute subject matter is non-arbitrable. So the National Company Law Tribunal later also issued on the case, the court issued a similar injunction, underscoring the tension between access to justice concerns and cross-border enforceability. I think another high-profile example is Delhi Metro Rail Corporation versus Delhi Airport Metro Express, where the Supreme Court annulled a 4 billion crore award for patent illegality. After re-examining patent illegality, that's what I want to emphasize. After re-examining the merits and the finding of the tribunal, the tribunal had ignored key evidence. I think we recently saw, I think it is partly because of this judgment, that the Ministry of Finance issued guidelines advising arbitral clauses should not be automatically put into domestic public procurement contracts above 100 million crores, and thus encouraging mediation instead of arbitration. Whether it's going to work or not, we don't know. But I think it is actually a reaction that is that we are seeing coming out from losing cases. So the reason, on the other hand, the reason rulings of the Supreme Court show a pro-arbitration trend, particularly like in Avital Post Studio versus HSBC PL Holdings. The Supreme Court refused to set aside a Singapore-seated award, dismissing allegations of arbitral bias. Similarly, in OPG Power Generation versus Inixio Power Cooling Solutions, the court held that award cannot be annulled merely by giving brief reasons. It must express a clear patent illegality or perverse error. Together, when we look at these cases and the proposed bill, 2024 bill, it just signals a continuing effort by India to try to balance judicial oversight with the autonomy and efficiency expected in modern arbitration. I would like to actually conclude by saying, despite the impressive growth that we have seen in Asia, our Asian arbitration ecosystem must still overcome some hurdles. The first hurdle is enforcement consistency. While countries are parties to the New York Convention, the enforcement practice varies, particularly when public policy is invoked as a reason to refuse recognition and enforcement. Another one is judicial unpredictability, especially in jurisdictions which are building up, do not have that background and that speciality in arbitration or specialized arbitration courts. But the opportunities are immense. Asia, I believe, and I can see, is undergoing a historical infrastructure, energy, and digital transformation. These developments are creating new kinds of disputes, new kinds of claims, data localization, blockchain infrastructure that require neutral-driven, expert-driven forums for resolution. As the economies mature, so will the domestic parties also demand for bespoke dispute mechanisms that reflect their commercial cultures, because there is this divide between international and domestic. And I believe that what is going to happen as we mature more, the domestic market itself will require a certain level that is higher from their arbitrators. So I think the most important thing now, there is a redefinition of the global arbitration order. Arbitration is no more the exclusive preserve of Western legal traditions. Legal harmonization, institutional modernization, jurisprudential depth are being generated, particularly from Asia. And Asia is not waiting for validation. It is setting its own standards, drawing from both civil and common law traditions, building a system that is robust, efficient, and regionally relevant. So as we gather here, we must remind ourselves that the arbitration story in Asia is a story that's still being written. But at the present moment, it's a story of confidence, of clarity, of capacity, moving forward and moving backwards. Thank you so much, Imba.
Thank you, Datu, Professor Sundararaju. Mikka Nandri. We are very happy at this juncture to forecast a quote about Datu Sundararaju. We all happen to be mentees of Datu Sundararaju, whether me or the other speakers from Asia who are part of multiple institutions and academic bodies. We wanted to say Datu to be the Asian face for international arbitration. We are very happy that we could have a nostalgic feeling that we are back to the classrooms. In the law school, when we are hearing the lectures, a wonderful lecture by Professor Sundararaju, even though it's an inauguration session, about the international arbitration in Asian region, particularly the two major democratic and the communist bloc, which is doing major reforms and contributing to international arbitration. Thank you. Thank you, Datu. Your support is always necessary for our task for building this Global South ADR Alliance.
Thank you so much. Thank you for the opportunity. God bless.
The next speaker is Mr. Deepak Narayanan. We are pleased to welcome you, sir. He's an accomplished legal professional with a distinguished track record in dispute resolution, particularly in domestic and international arbitration. A partner at BDN Chambers in Chennai, Mr. Deepak Narayanan is an Indian qualified lawyer with an LLM from Queen Mary University of London and a member of Chartered Institute of Arbitrators, CIAB. He serves on the core committee of CIAB YMG India and is also part of India Committee of International Center for Dispute Resolution, ICDR. With over a decade of experience, he regularly appears before the High Court of Madras and various tribunals representing clients in complex commercial disputes. His academic and professional journey reflects a deep commitment to advancing arbitration practices in India. We are honored to have him join us to share his insights on strengthening dispute resolution frameworks in this region. Over to you, sir.
Thank you for those wonderful words and introduction. Firstly, I would like to congratulate and thank Mr. Inbavijayan sir for organizing this Global South Alternate Dispute Resolution Thirunal Day. In our terms, Thirunal refers to auspicious day, which usually repeats annually. So we hope that this is an annual affair and the kind of the initiative that has been brought up is repeated annually, and we can definitely take this forward to greater heights. Thanks for inviting me as well for this session. Thank you, sir. Sir, it's extremely difficult to follow Mr. Sundara Raju, but I'll try my best to just fill in after his exceedingly illuminating speech on the Asian perspective of international arbitration. So India has a growing hub for international business here and has made significant strides in aligning its legal framework with international standards in arbitration, particularly through Arbitration and Conciliation Act 1996. In an increasingly globalized economy, arbitration has, of course, become the preferred method of dispute resolution for international commercial transaction. In that, the cornerstone of having a successful international arbitration dispute is enforcement of foreign arbitral awards, which is critical in ensuring the effectiveness of arbitral process. So at this stage, if I just do not want to start on a sad note, but it is still a thing that's to be noted. In 1872, the Privy Council has in fact slightly noted that the plight of a litigant starts when he obtains a decree. Decree is the arbitration award is also something like a decree of our Indian courts. So we are striving our best as judiciary practitioners, ADR practitioners, etc., to ensure that this is not true, that arbitration is moving forward in the right direction. The enforcement mechanisms are made easier, and the plight of the litigant is definitely does not start once he obtains a decree. The enforcement should seamlessly follow after obtaining a decree. That's where we are headed towards. And for India to be vested as a hub, global hub in international arbitration, it's absolutely necessary to make the enforcement process easier. There is also a saying that bad settlement is better than a successful litigation. Why is that? Because once a litigant succeeds in his matter, the enforcement of this particular foreign arbitration award is not easy in India, to be in a very practical sense. Because once you get an arbitration award, how do you enforce it? You need to go to courts and try to enforce it by way of an execution petition, which is very much similar to executing a decree of a civil court. So let's move to this to a small session that I'm just going to talk on the foreign arbitration award and its enforcement. So what is a foreign arbitral award, first of all? A foreign arbitral award refers to an arbitration decision or an award made in a country other than where the enforcement is sought. So in Indian perspective, any award that is made outside India is tendered to be a foreign arbitration award, and the enforcement of such in India will become enforcement of that particular foreign arbitration award. Let us have a quick look at the legal framework in India which governs the enforcement process. So there are primarily two international conventions which is embedded into the Arbitration and Conciliation Act 1996. The first is the New York Convention of 1958, which is recognized globally. This convention provides for enforcement of foreign arbitral awards among signatory countries. The other one is the Geneva Convention of 1927. Though less widely used today, it still applies to select cases where the award was made in a contracting state. But since almost most of the countries are signatory to the New York Convention of 1958, New York Convention is generally the norm in enforcing an arbitral award, not only in India, but also across various countries. So the part 2 of the Arbitration and Conciliation Act 1996 deals with the enforcement of foreign arbitral awards. Firstly, just a quick note on the domestic arbitration award. A domestic arbitration award in Indian Arbitration Conciliation Act 1996 is similar to a decree of a civil court and can be enforced in the same way, which I already mentioned about. To have in respect to international arbitration or foreign arbitral award here, there is one additional step of recognition and enforcement of this arbitral award. So if you have a look at section 47 of the Arbitration and Conciliation Act 1996, it specifies further additional things that needs to be done in case the award is a foreign arbitral award. This is that an original award or a copy thereof duly authenticated in the manner required by law of country in which it was made has to be produced before the court. This is the first step. Second is the original arbitration agreement or a duly certified copy thereof should also be produced. So first is the original arbitration award. Second is the original arbitration agreement or its duly certified copy as required in the respective jurisdiction where it was awarded. Finally, if there is some still further clarification that is needed, such evidence as may be necessary to prove that the award is a foreign award. So this is a 3-step process that the courts usually follow here. Just to add a practical scenario, how it is done is, for example, I recently dealt with a matter of an award that has been pronounced in Denmark. So what happens is, considering a foreign arbitration award is produced in Denmark, thanks to the fact that now that the concept of transmission of decree in foreign arbitration award is taken out, in India, you can directly bring this award and go and enforce it anywhere in India where you find the relevant property or any other account that needs to be attached, etc., which is the mode of execution. So in our case, we wanted to attach a property belonging to the judgment debtor, that is the person against whom the arbitration award was pronounced. So from Denmark, the award was directly taken to a district court situated in Ponneri, that is a court situated within Tiruvallur district in Tamil Nadu. So this is a very small district court situated in Tiruvallur. So directly the property is situated within the jurisdiction of this Ponneri court. So directly we took the foreign arbitration award, we put an execution petition before the Ponneri district court and got the award executed. So in practical sense, this is how you usually do. So for us to do this, what we did is we first produced the original foreign arbitration award that was given in Denmark, then the original arbitration agreement, which was submitted before the arbitral tribunal. And finally, no further evidence was required to show that this was a foreign arbitration award because it was evident. So directly the matter was enforced. So to get a practical sense, this is how you do it. Subsequently, I will also have to quickly catch on grounds for refusal of enforcement. So in section 48 of the Arbitration and Conciliation Act, it also provides a list upon which foreign arbitral awards enforcement can be challenged. The text is slightly similar to section 34, setting aside of arbitral award, but I'll still quickly run into what are the ingredients for challenging a foreign arbitration award. First is incapacity of parties. That is, if either party lacked the legal capacity to enter into the arbitration agreement. Second is invalid arbitration agreement. If the agreement itself was not valid under the law governing it. Then lack of proper notice. If the party against whom the enforcement is sought was not given a proper opportunity to present their case or was not given a proper notice. Next, exceeding scope of the arbitration. If the award contains decisions on matter beyond the scope of arbitration. So only these things are covered. If the award covers something beyond the scope, then that is also a ground. The next is procedural irregularities. If the arbitration did not conform to the procedure agreed upon by the parties, consider the contract as well as the arbitration clause ingrains certain procedures to be followed. If those procedures are not followed, that is also a ground for challenge. And also, finally, the widely used term that is contrary to public policy. If the enforcement of the award would be against the fundamental policy of Indian law. This concept of public policy has been subject to extensive judicial interpretation. Often, we as lawyers, we use it as a contentious ground to challenge foreign arbitral awards. Because unlike a court order or a decree, the arbitration award cannot be challenged generally on the merits of the award. That is, it is in an appeal against a decree. You can always say that the judge did not find this particular point correctly. The judge did not look into this particular document correctly. The judge awarded interest wrongly in such a fashion, etc. But generally in arbitration, the award is challenged only on procedural grounds, on the grounds that I just mentioned before. These are strictly procedural grounds. If you don't follow the procedure properly, then the award can be challenged, which of course quickly to do: incapacity of parties, invalid arbitration agreement, lack of proper notice, exceeding scope of arbitration, procedural irregularities, and finally contrary of public policy. On this public policy, since the interpretation sometimes can be slightly elaborated, a lot of merits are also sometimes challenged under this public policy. But the courts, Indian courts, have played a pivotal role in shaping arbitration jurisprudence, gradually moving towards minimal judicial intervention and also restricting the scope of public policy. For example, in the landmark decisions of Renusagar Power Company versus General Electric Company, Venture Global Engineering versus Satyam Computers, even the recent case of Vijay Karya versus Prismian Kavi, the scope of this public policy has been brought down to a very, very small extent. And the courts have held that the judicial intervention in respect to enforcement of foreign arbitral awards or challenging such foreign arbitral awards should be kept at a very, very minimum stage. This will further embolden foreign trade, foreign investments, etc. Seeing that the India is a hub for arbitration, which has very, very minimal judicial intervention, and therefore there will be more arbitrations, more trade. That's where the approach is going by the judiciary in India. So, despite all this, there are still challenges in enforcing a foreign arbitral award in India. I can quickly; these are very, very generic challenges that I can just quickly run through. So, first is, of course, the judicial delays that we have in Indian courts. While courts have moved towards a pro-arbitration approach, procedural delays in enforcement process remains a concern, discouraging international parties definitely from choosing India as an arbitration-friendly jurisdiction. Even though the courts have repeatedly said that there should be minimal intervention, there is still some intervention. There was also a recent, in fact, Supreme Court circular, which just came out last month, which actually repeated a previous circular saying that all execution petitions across all district courts should be finished within 6 months. Hopefully, such circulars, notifications, interferences by the apex court will help progress these execution petitions quickly and therefore quicken the enforcement process of all decrees, including domestic as well as foreign arbitral awards in India. Next is, of course, the uncertainty in public policy interpretation. So, as I said, the public policy interpretation slightly varies. The lawyers often tend to use this public policy ground to simply challenge certain awards where where it cannot be even challenged. So, the inconsistent application sometimes of this public policy exception has led to unpredictable enforcement outcomes. Some courts have expansively interpreted public policy, allowing review on the merits, contrary to international arbitration standards. Some courts have, of course, said that no, public policy's interpretation should be kept to the minimum. Next is the institutional arbitration challenges. So despite efforts to develop institutional arbitration in India, reliance on ad hoc arbitration still continues. Institutional arbitration mechanism can definitely help streamline the enforcement process and reduce unnecessary delays, because it's an institution who will run the arbitration process, and it is not left to the parties and arbitrator to run it in any way. So usually it's more streamlined, which results in effective arbitration process, and finally definitely a good arbitration award. For example, for one as a brownie point, for example, something like a SIAC, Singapore International Arbitration Court, also does something called review of the draft arbitral award. So they have a look at the secretariat of the institution, generally peruses the draft arbitral award and ensures that there is no procedural inconsistency. This will only make the enforcement process more even better, because there will be no procedural fallacies in such arbitration award. So these are some of the issues or problems that are prevalent in enforcing an arbitration award. So of course, while I have all listed this, just have a quick word on how to move forward in, that is, the future of arbitration and enforcement in India. Of course, with India's increasing integration into global markets, further legal reforms, policy measures, can enhance arbitration. Some key areas for improvement include, of course, as I said, reducing judicial intervention, that is strengthening the judicial consistency, or to ensure that there is minimal interference in enforcement proceedings, streamlining court procedures, implementing faster mechanisms to ensure that the arbitration related litigation to reduce delays, clarifying public policy interpretation, promoting institutional arbitration, and developing arbitration infrastructure. So these are the ways to move forward. Since there is some paucity of time, we are already overrunning our slots. I think I broadly covered the enforcement of foreign arbitral awards in India, and I'll without further ado, I think I can finish my small presentation, and I'll pass on the baton again to Mr. Inbavijayan, sir.
Thank you, Mr. Deepak Narayan, for a detailed analysis about the context of arbitration in India, particularly in Chennai. I'm very happy that being partnering with our institution, forming part of our institution, the work what you have contributed for the development of arbitration, both domestic and international, is much appreciated, and we wholeheartedly thank on behalf of the institution, the Global South ADR THIRUNAAL, as rightly pointed out. It will be going to be a regular annual event. It will be an auspicious day. Hopefully, it also might surpass the Tamil New Year, what we traditionally have it. And interestingly, this day is going to be a significant day to bring out a big alliance of all the arbitration institutions which are effectively doing the service of ADR in Global South. Thank you for this wonderful presentation quite early, even though it's on a vacation. You're spending your valuable time with us and sharing with the wonderful audience from Global South.
Thank you, sir.
Moving forward, we are delighted to welcome Mr. Ganesh Chandru, a highly respected legal expert with extensive experience in international and domestic arbitration, as well as commercial litigation. A partner in Dua Associate with offices in New Delhi and Chennai, Mr. Ganesh Chandru is admitted to practice in India, England and Wales, and Singapore. He is a fellow of both Chartered Institute of Arbitrators UK and Singapore Institute of Arbitrators, reflecting his deep commitment to excellence in dispute resolution. With advanced legal training from the National University of Singapore and University of Madras, Mr. Ganesh Chandru brings a rich blend of academic insights and practical expertise to the table. We are honored to have him join us to share his perspective on arbitration and commercial dispute resolution, and to contribute to the ongoing dialogue on strengthening ADR practice in the region. Over to you, sir.
Thank you. Can you hear me?
Yeah, it is perfect.
Fantastic. Thank you. Thank you very much to Kovise Foundation, KFCRI, Mr. Inbavijayan, the senior advisor, and Madam Surya for the kind invitation to be part of something which is very unique, I should say. I think this is the first time someone is, conducting something for the Global South insofar as ADR is concerned. I should congratulate Mr. Inbavijayan and his team for putting this together and for the thought. And, this I'm sure is just a first step. And I'm sure hopefully in due course, we'll have a mega Thirunal in person physically in Chennai and perhaps other parts of the diaspora in other countries as well. So firstly, congratulations to you on this great initiative, which I think is a fantastic start. ADR, as you all know, alternate dispute resolution. Some people call it appropriate dispute resolution. I've been given the task of speaking about institutional arbitration in India. We have Mr. Sundra Raju here, who was connected with an institution in Malaysia for several years. He was the director of AIAC for several years, and now, of course, he's also the president of AIADR. And I see a list of several participants early in the morning for us in India here and other time zones. Of course, it's vacation time, as Inba said, in Chennai for the courts here. But for arbitrators, there's no vacation. We work all the time, and for arbitration lawyers as well. I think Deepak did allude a bit into institutional arbitration at the end in terms of scrutiny of draft awards. But what I propose to do is, I think since the audience already kind of knows what institutional arbitration is, very quickly for those perhaps students and others who might not know the difference, I would say most of the arbitration in India is ad hoc. When we say ad hoc, it means that you don't have an institutional oversight. That doesn't mean ad hoc is free for all. You still have the courts which have supervisory jurisdiction. Supervisory jurisdiction in the sense they are there for any curial support that a party would require for the arbitration. Like, for example, interim measures of protection. And let's say if somebody in violation of the arbitration clause starts a civil suit, commences a civil suit in court, then you can go to Section 8 under our Arbitration Act and ask the court to stay these proceedings in favor of arbitration, as long as there's prima facie an arbitration clause. So the court will not do a merit-based hearing. If there's a prima facie clause, they have to refer it to arbitration. Then, of course, Section 9, you have interim measures of protection. Then you can, of course, go to court for setting aside an award after the award is made on very limited grounds. In India, we don't have an appeal on question of law. Unlike in the UK or in the domestic arbitration framework in Singapore, you can only limited grounds for an application to set aside. Similarly, when a foreign award comes in, you can resist enforcement on very limited grounds, which was dealt with by the earlier speaker. So what happens in India is, since we followed the common law English tradition, which was mostly ad hoc arbitration, our earlier legislation, the 1940 legislation, and the previous one, the 1899 Act, were all based on the then English arbitration legislations. But in 1995, by way of an ordinance, India adopted the UNCITRAL model law, and it was enacted as an Arbitration Conciliation Act in 1996. So this is the arbitral framework that we have today. Extensive amendments were made to this legislation in 2015, and further tweaks were made in 2019, and one more amendment was made in 2021. In fact, they have come up with further recommendations for amendments, and that's still pending consultation and is yet to be looked at by the Parliament. So there are some suggestions which have been made as well. But coming to now specifically institutional arbitration, what does an institution do? An institution oversees the entire arbitral process right from the time the notice of arbitration issued until the award is made. And some institutions are also empowered to certify copies of awards, like the SIAC and few other institutions around the world. In India, institutional arbitration is still picking up. I should say it's still very nascent. we are not used to the institutional arbitration culture yet, but I should say that it is very, very, prevalent in terms of the awareness is being created among all stakeholders about institutional arbitration. In fact, one of the oldest, if you look at all the chambers of commerce of Calcutta, Bombay, and Madras, which were the presidency towns, which had the modern, common law regime where the high courts were set up. Before that, there was a Supreme Court at Calcutta. So all these, when they came about, and this Arbitration Act of 1899 was enacted, all the chambers of commerce had a list of arbitrators. Even if you look at all these old chambers, they'll have a list of arbitrators who would decide, arbitration cases for the trade, especially shipping and, commodities dispute. These were all typically referred to arbitration. And there was no national institution as such in India till 1965 when the Indian Council of Arbitration was created under the FICCI, which is Federation of Indian Chamber of Commerce. And it was through the Ministry of Commerce support that the Indian Council of Arbitration was established in Delhi. It's one of the oldest institutions in India and has till date been doing a pretty good job in promoting institutional arbitration. They're headquartered in Delhi in the FICCI Bhavan. Then you have in Chennai, the Nani Palkiwala Arbitration Center, which was established in 2005 by the Nani Palkiwala Trust. And it's a very progressive institution, I say, and it's named after one of the finest jurists of India, Mr. Nani Palkiwala, who was a great lawyer and a fantastic jurist, and a person who shared his knowledge with the common man. In fact, after every budget in Bombay, he would give a speech to the common, the public, to explain what the nuances of the latest budget is. He was a great tax lawyer, and I'm sure in all the areas of commercial law, he's contributed quite a lot. And in his honor, we have an arbitration center in Chennai. Then you have the Mumbai Center for International Arbitration, which was established in 2016. It is a fantastic institution, and I think very progressive. It's located in Bombay. The offices are in Nariman Point in the commercial hub. And the Mumbai Center has been doing a fantastic job as well, though very young institution. Then you have an arbitration center in Hyderabad called the International Arbitration Mediation Center, which I think has taken off very well. They have a fantastic space, I understand, in Hyderabad. They've been doing a very good job. In Chennai, of course, apart from Nani Palkiwala Center, you have KFCRI, which is also, up and coming and, contributing in a big way to arbitration here. And we have the Southern Indian Chamber as well. I also see Southern Indian Chamber is supporting this initiative here today, and they have a fantastic arbitration center right next to the High Court. And it's a fantastic facility which I've had the opportunity to visit as well. And you have court annexed arbitral institutions in India. For example, the Delhi High Court, inside the campus is a separate building called the Delhi International Arbitration Center. Similarly, in Chennai, the court is still called the Madras High Court, because it was earlier Chennai was called Madras, and we have the Madras High Court Arbitration Center as well. While you may think, some foreigners may think, hey, why this centers inside the court? I think it's very useful when the court refers the matter to arbitration. It's easy for you to have the center in the premises or in the vicinity, so that these arbitrations are conducted in a seamless way. A very significant development in India happened in 2019 when the Parliament made an enactment called the India International Arbitration Center Act, or IIAC for short, which has been declared as an institution of national importance. You see, what's happened is when this this act was originally enacted, it was called the New Delhi International Arbitration Center. And later in 2023, this center was renamed as the India International Arbitration Center, so as not to confuse it with the Delhi International Arbitration Center, which is part of the Delhi High Court, and also to reflect the national identity of the center. So this is the aim of the center is to become something like an arbitration center for the whole country. It is India International Arbitration Center, which is headquartered in Delhi. And I'm not sure if there is any other country which has set up an arbitration center by an act of parliament. We have to be very happy that in India we have this center. And what I'll do is I'll just kind of give you certain nuances of this center, which is akin to many other rules like MCIA and all the other institutions I just mentioned. in terms of IIAC is concerned, it was to create an independent and autonomous regime for institutional arbitration in India. That was the whole aim. This, I think, gentlemen and ladies, it inspires confidence among parties, both domestic and international, because you're having a neutral dispute resolution platform for resolution of commercial disputes through a seamless arbitral process. That's the whole idea of why this institution was created. And you see, the composition of this center, while many people may view, I mean, may say that when there is an institution, it's best that is part of a chamber of commerce or it is neutral. Here, IIAC is, of course, is supported by the through the Ministry of Law, by the Government of India. But this is minimal support that they are giving for the start and for this institution to nurture and grow. I can tell you that it is there's absolutely no interference by the authorities of the government in any of the conduct of the institution. It is completely independent and neutral. I'm one of the 3 members appointed by the Government of India to this institution. I'm one of the part-time members. We have a chairperson who's a retired judge, Justice Hemant Gupta, and the law secretary and somebody from the finance ministry are the ex officio members. And there's one from recognized body of commerce and industry. We have a Director General and CEO of the Federation of Indian Export Organization, who is also one of the members. And of course, there's a CEO, there's a full-fledged secretariat headed by a registrar. And one interesting feature here is this IIAC has something called a Chamber of Arbitration. This Chamber of Arbitration consists of members who are eminent practitioners or retired judges or former bureaucrats. We also have 2 foreign lawyers on that chamber who are tasked with looking at applications coming for empanelment of arbitrators. Ladies and gentlemen, you will know that an arbitration is as good as the arbitrator, because at the end of the day, when you choose arbitration, you are ousting the court jurisdiction and you're going into the arbitral process. And when you have an institution, the role of the institution is to make sure that they have a quality arbitrators who will deal with your case in an expeditious manner and in a cost-efficient manner, so that you can get your award within a time frame that is provided for under the rules. And in India, of course, now for ad hoc arbitration also, we have a blessing of Section 29A, where an award has to be made within 1 year after close of pleadings, unless parties extend it by 6 months, waive agreement, or if the court extends the time beyond this, or beyond the 12 months, or beyond the time agreed to by the parties. So I think in the institutional framework in IIAC, you have this Chamber of Arbitration, which looks at these applications, even to put people on the panel. So there's a level of scrutiny. So those arbitrators who are there on the panel, their CVs have been looked at, their experience have been looked at. And if you look at the panel of the IIAC, you have it's a big range. You have not only legal practitioners, we have retired judges, we have former bureaucrats. We also have people who have experience from the industry, engineers, people from the maritime industry. And one thing IIAC is focusing on is young arbitrators. We want to give chance to people who are at least about 10 years of experience, maybe in their late 30s onwards, who can sit as arbitrators. Of course, in smaller matters for the start, and so that we increase the kind of pool of arbitrators that we have in the country, especially for institutional arbitration. And the panel of arbitrators, there is a regulation that deals with how they should be appointed, and it includes, as I said, experience as well as young professionals, which is very useful. There is something called the IIAC Conduct of Arbitration Regulations 2023. Of course, the rules, arbitral rules here is called Arbitral Regulations. It was notified on 31st of August 2023. It's been about a year and a half since it's been used, and I'm happy to report that we have about 16 cases, which is quite good for a young institution. And the key features of these regulations are efficient and time-bound process. There is a fast-track procedure. There is an emergency arbitrator procedure. There is also an advisory panel to advise the chairperson who makes appointment of arbitrators. So the chairperson doesn't make an appointment himself. I mean, there is an advisory panel which consists of the members of the IIAC as well as eminent persons who are appointed to this panel who will look at, kind of advising the chairperson on, of course, at the end of the day, it's the chairman's discretion. You put it up, the secretariat comes up with the names of the parties and a brief of the case. Then this advisory panel looks at the case and kind of advises like 3 to 5 names. And the chairman then looks at the CV and decides perhaps which person would be best suited for the case. And of course, secretariat writes to the prospective arbitrator for confirming conflict of interest. Because in India, perhaps it's the only regime where under our Arbitration Act, we have adopted the IBA, International Bar Association guidelines on conflict of interest, where we have a Schedule 5 and Schedule 7, which talks about different scenarios where declarations have to be made, where conflict of interest may be perceived. And if Schedule 7 applies, Schedule 7 is from the red list of the IBA guidelines, then you cannot appoint an arbitrator who kind of falls within one of the categories, unless, of course, parties agree in writing after the arbitration commences that, this arbitrator can be appointed. So I think like any other rules, it's you need to start with the request for arbitration, then there's a response filed, then the advisory panel recommends for appointment of arbitrators, unless of course parties are able to agree. The choice is given to the parties all the time. With the sole arbitrator, like the act, each party can nominate, and if they don't agree, then it goes before the IIAC for appointment. Similarly, 3 members, each party appoints an arbitrator, and of course the third arbitrator can be agreed to by the arbitrators unless the contract provides otherwise, or is appointed by IIAC. All the appointments are only nominations. So even if a party nominates an arbitrator, the IIAC has to confirm the appointment, after, talking to the arbitrators or getting them to clear conflict of interest. I guess, in terms of the arbitral appointment itself, though the chairperson is tasked with the task of appointing the arbitrator, it's a very seamless process where you also have an advisory panel. So there's a lot of check and balances there. And then, in terms of, especially, I think, my friends, the problem always arises when you have 3 arbitrators, when, people tend to appoint the same group of people who help each other to become arbitrators. By this institution, and where you have a panel, you kind of try to have a much more impartial situation here. A challenge, substitution of arbitrators is done very much, like the Act and other rules. As I told you, fast track procedure, emergency arbitrator is a topic in itself. And I'm glad that in India now, earlier there was some lacuna here, because we did not, in our earlier legislation, when we amended in 2015 and 2019, follow the recommendation of recognizing the emergency arbitrator as a tribunal. But by way of a judgment, the Supreme Court in the Amazon case has recognized an emergency arbitrator's order as an order that can be enforced under Section 17 of our Act, like any other arbitral tribunal. Of course, there was an arbitration seated in Delhi, so it was easy for the court to do that. But then there's a proposal for introduction of Section 9A to recognize emergency arbitrator and institutional arbitration in the draft, kind of proposals that have come for this. But under IIAC rules, within 3 days you can get an emergency arbitrator, and within 15 days there has to be an order made by the emergency arbitrator. Then there are pleadings similar to what Deepak mentioned about SIAC. There is a provision for looking at draft award by the Secretariat. One interesting feature I'll have to tell you, that under IIAC rules, the Secretariat has to complete this process of looking at the draft award within 3 weeks or 21 days, because in many institutions they don't have this provision. And while you have provision for the tribunal to give you the draft, here in IIAC, it's 60 days from close of proceedings, the draft award has to be given to IIAC, and then within 21 days they'll have to look at it, and then the award is published. There is an ad valorem schedule of fee for domestic. It is in Indian rupees, which follows Schedule 4 to a certain extent, but we have few more rows, kind of amounts in claim which are quite high. It's amount in dispute, it's claim plus counterclaim, because under Schedule 4 you calculate separately for claim and separately for counterclaim, because the clarification issued by Supreme Court in the ONGC case. But here it is all added together. and we have a fee which is a little more higher, so that it's fair to the arbitrators as well. For international arbitration, it is provided in US dollars, and we have special fee, a very nominal fee for appointment of arbitrators as well. Just you come to IASC for appointment of arbitrator, there's a schedule of fees. There's a schedule of fees for emergency arbitrator as well. So I think I just wanted to give you a flavor of this national institution which has come on board. All the other institutions have these fantastic rules as well. And I think very important for parties to adopt institutional rules so that you have a process which is very good. Especially one aspect before I finish, I see my time is up. Very important is the financial aspect of the arbitration. In an ad hoc arbitration, you would deal with the arbitrator directly on the financial aspect, which in my view is very not healthy at all. In an institution, the institution will take care of that aspect, and therefore the arbitrator just deals with the case and not the financial aspects of the matter. With that, I think I thank you so much it was such a pleasure to meet all of you early this Friday morning. Thank you, Mr. Inbavijayan and all the other team. Good luck for the rest of the day for this fantastic Thirunal. Thank you.
Thank you. Thank you, Mr. Ganesh Chandru. It was a really interesting story, we can say, how the evolution of institutional arbitration occurred in India, particularly starting from Madras and reaching to the destination of having a center for national prominence or importance. I could understand similarly in Tanzania, in their legislation, their recent legislation, they also ventured into this type of creating an institution within the legal framework. And India is one unique country which has adopted not only the IBA soft laws within that legal parameters of including 5th schedule, 7th schedule, and the way how IAAC, the India International Arbitration Center, and its chamber of arbitration, its panel, its provisions, and very interestingly adopting the latest development of emergency arbitrator provisions, all set together in the Global South with all the stakeholders in not only in India, in other Global South countries. We expect a rapid development. Anyway, India is very acceptable nation, wherein anything new which is really worth for the litigants to adopt, we will be there to adopt. And as institutions, whether it is going to be IAAC or KFCRI or NPAC or SICI Center for ADR, every institutions are on the same objective. And this objective is going to see the light as a Global South initiative. Mr. Ganesh, we expect your long-term support in this. Just as a beginning. As I was just mentioning the predecessor talk, it is going to be an annual event. This event is going to take it quite seriously, how it is going to be the 24/7, the institutional framework, as well as all the region in the Global South is going to be forming an alliance. That alliance is going to give the expected outcome and the mindset to be created for parties. Thank you, sir. Thank you once again for sparing your vacation time in the morning hours. Hope you will have a pleasant day.
Thank you. Thank you so much.
Moving on to the next speaker for the day, we are pleased to welcome Ms. Peng, a legal counsel at the Shenzhen Court of International Arbitration, SCIA, where she has been instrumental in advancing arbitration practices in China. With a Master of Laws in International Arbitration from City of Hong Kong and a strong foundation in both Chinese and international legal systems, Ms. Peng brings a wealth of experience from her roles in corporate legal management and cross-border legal consulting. Her work span equity structuring for startups, investment and financing projects, and legal advisory across Southeast Asia. She has also represented SCIA in international moot competitions and has published on key topics in environmental and investment law. We are honored to welcome Ms. Peng to share her insights on the ADR landscape in China and to contribute meaningfully to today's session. Over to you, ma'am.
Okay, thank you. Thank you so much. Hi, everyone. And it is my pleasure to be invited to today's event. So firstly, I want to say please forgive me. I look so tired because I just come from the Russian Arbitration Week. So I just finished a long business trip. And secondly, it is my honor to be invited today to speak, as a representative from the SCIA. Also, maybe I could share some experience based on my previously work experience to say something about the China's arbitration. So previously I received 3 questions from the organization, the KFCRI. So I'm gonna to answer the 3 questions, and after that, if you or during my speech, if you have any question, please feel free to let me know. So the first, by the way, I also want to take 1 minute to introduce the SCIA, the Central Court of International Arbitration. So usually you may know that in China there are more than 280 arbitration institutions in total. I know it's a so big number, but only some of them could and do have the ability to accept the international cases and manage that kind of cases. So why we say that only some of our institutions could do that? Because most arbitration institutions are established by the Justice Bureau or something, some kind of the government. But only like the SCIA, it is established by the law. There is a unique law which called the Ordinance on Shenzhen Court of International Arbitration. So according to that ordinance, all the major decision made should be by the international council member of the SCIA, not by SCIA internal management. So that's why we say the SCI is different, because it has the international council member who could help to do something. So that's the most different thing. And also we have some unique creations to be different from other institutions in China. But I won't take more time on that later. So if you have any question or you have interested in the SCI part, please feel free to contact me. And now return back to my speech today. The first question I want to address is about the Chinese role from the practitioner to co-architect of the global arbitration. So I would like to say, as the recent 20 years development, we could say 2 parts from the China to do something in changing the international arbitration. The first is about from the parties or from the China enterprise. As you may know, there are so many Chinese cross-border companies go abroad and go to the many countries to do the investigation. So as the parties, their requirements, their marketing needs also do some change to the international arbitration. And according to the Belt and Road Initiation, the BRI, over 60% of the BRI disputes in 2022 were solved by the arbitration. For example, the SCIA, we are like 3 years ago or 5 years ago, it only accepted like several thousand cases a year. But in the recent 3 years, it keeps a robust growing rate. Like last year, the SCI has accepted more than 14,000 cases a year, and most of them are from the Belt and Road countries. The parties are from that region. So that's what we can say is the change by the parties from China. And second is like the internationalization of the panels from the institution. For example, Dr. V from KFCRI, he is also the SCI arbitrator. So some institutions in China who try to invite and introduce more foreign arbitrators to into the into the Chinese institutions panel, it can make the foreign arbitrators who know better, who know more about the China's arbitration. Also, we know more things from our foreign arbitrators. So I think that's the two main parts of the change to changing the arbitration part. And second question I want to address about the trends, the digitalization, the third-party funding, and the IP arbitration. That's something new in China. First, it's about the digital things. Especially after the COVID-19, the digital using, like in the case filing part and the online hearing, we exchange submit for the parties who submitted their materials online, and all the things in China has been increased best. For example, in last year, SCI already finished that all the cases could be filed online. And we have more than 60% cases that the parties choose to finish the whole arbitration process online. Like they submitted their materials by SCI's virtual arbitration case system, and they could held the online hearing by that system. And also for the tribunal could finish their deliberation and also review all the documents submitted by the parties by that system, the case system. The case system is located in SAI inside, so which could keep the confidentiality of the cases. And also the parties could deliver their materials to both tribunal and the case manager at the same time by the system. So and that's not only SCI do, that's actually the most arbitration institutions in China do, and also for the court. And one more thing, we created a electronic link between the arbitration institution and the court to go through and to pass the electronic evidence. So which means usually if the parties, they want to enforce the arbitral award in the court, they could the only thing they need to submit is the arbitral award. The rest of the case materials, they could just use that link I just mentioned. So from the arbitration institution to court directly. So there's no more need for the arbitrator, for parties to, to submit the materials again. But that's only the link only exists between some courts of the institutions. So I think there's more room to enhance and to promote that kind of cooperation. And the second thing I want to mention is about the third-party funding. So according to the Chinese domestic arbitration law, there is no clear rule to talking about allow or forbidden the third-party funding. But usually in the practice of in China, usually we use the third funding party for the investment arbitration case rather than the private arbitration case. However, there are the different institutions make different choices. For example, by the CTAC and also by the Beijing Arbitration Commission, according to their rules, they submit the specific regulated that if there is any third party funding in the arbitration cases, the parties should disclose to the tribunal. That is necessary. That's already been written in the rules. But in SCIA, it hasn't been stipulated in the rules because according to our experience, we think maybe, it's necessary for both parties and the tribunal to disclose the necessary information. However, if there is, some other kind of situation may not appropriate to disclose the third funding party, the information, maybe the party has the right to, to say that. So what the SCIA do is we did not include such the clause in our rules. However, we written that into the guidebook for the arbitrators. We require all the arbitrators to disclose anything maybe related to the cases, and at the same time, we require the tribunal to consider whether it is important or whether it is necessary to ask the parties to disclose such things. So we think maybe it's more convenient and it's more flexible for tribunal to decide that part. So that's about the third party funding. Also, one more thing is, as you may know, the China is, we are updating the Chinese law. And according to the draft, we just saw the draft now about the arbitration law, there may be some new regulations related to the third party funding in the future. So let's see what we're going on. And the third thing I want to share is about the IP arbitration surgery, because as you may know, in China, for the IP dispute, I won't say most, but some kinds of IP dispute could only be resolved by the court, because that is an administrative issue, like the patents, like the trademarks. But so what could the institution accept it? It's only the IP dispute which could be written in the arbitration agreement in advance. I know most countries have the same issue. So what we trying to do is we trying to create more chance for parties to come back to the table and discuss about the way to resolve the dispute. Let me take a true example. So in China, in the SCIA, we create a mechanism which called the commitment mechanism. As you may know, in Shenzhen, right, the SCIA is based in Shenzhen, and there are so many high technology companies in Shenzhen, such as the Tencent, Huawei, DBJ, Dajiang, the BYD, BYD, and so many, and also another company which called Yushu, they doing the robots who can dancing and who can do many specific things. So such companies are, and also ZTE. So such big companies located in Shenzhen, what we do is we invited them to join SCIA's commitment mechanism. So once the company, they sign the agreement, which means if they will be pursued by the other party, and if there is no agreement between the two the companies, they could still resolve the dispute resolution dispute in the SCI for the IP dispute. What's that mean? For example, so if but party A has a cooperation with, let's say, Tencent. Okay, so if there is a cooperation with from my company with Tencent, but there is no agreement to say that if there's any dispute arise or related to the contract, we should submit the dispute to the SCIA. If there's no such agreement, and if there is IP dispute arise between the two companies, since the Tencent signed the agreement I just mentioned to commitment, they will accept it, the dispute, the IP dispute being resolved by the arbitration. So if I want to pursue some money from the Tencent, I could just go to the SCIA and to raise up the arbitration, and the Tencent should be informed, and they are by default to agree that our dispute related to the IP being resolved by China, by the SCIA. So that's one thing we try to create more trends to pull up both parties who resolve the IP dispute in SCIA by arbitration. So that's the three things I want to share. And thirdly, and also I think most people will take more importance on that, is about the judicial, the enforcement in China, especially the foreign arbitral awards enforced in China. So here I have three data I want to share. First, per the Superior People's Court, more than 85% of the foreign arbitral awards was recognized and enforced between 2018 to 2023. And aligned with the Singapore and Hong Kong's arbitral awards are the top two jurisdictions who have awards being enforced in China. And also one more thing is, in China, if a court if the court wants to, withdraw or deny to enforce an foreign arbitral award, the courts, they have no right to do that. They have to report it to the Superior Court, and the final decision will be made by the SPC, by the Superior Court. So, this double check system could ensure that the foreign arbitral awards are more safe to be enforced in China. And that's why we say this year China is becoming more pro-arbitration jurisdiction. And and another thing I want to share is the three cases related to the latest development in China. The first is one case in 2050. The 2050, this case is made by a court in a court in a city which called the Hangzhou. And this is important because, this case is important because, let me check, sorry. Yes. This because it is the court recognized the rules included in that case made by other foreign institutions, and the rules may a little bit conflict with the Chinese local law. But according to the court finally decided that even there is a little bit conflict, and the conflict could not be regarded as the violation of the public interest, the court should respect the award made by the tribunal. So in this case, the court finally enforced that award. And the second case is made in 2021. In Xintai case, the court enforced a Hong Kong stated emergency arbitration order. Oh, I know my time is already limited. I will be quick. So, according to Chinese arbitration law, although we support the interim religious, but it raised two cases. And now we have some, and one is I just mentioned from the Hong Kong, the Hong Kong tribunal who made an emergency arbitration order, and the third case is about the balance that the public policy expressions with the pre-enforcement principles. So according to the three cases, we could say that China are more prefer to enforce the foreign awards, and also there are more real cases that link the different mechanism, because the international arbitration practices are kind of different from the Chinese practice, like the emergency arbitrator. Usually we do not already, our rules support it, but usually we have no need for that. So now we have more cases about that one. And one more thing, oh, sorry, I know the time is limited. So is there any question? Please feel free to let me know. Thank you. I will just include it now.
Thank you, Peng, to the entire world, Sandra. We are very happy that after your busy participation in the Russian Arbitration Week, you have joined here. And your insight was a real interesting one for all of us to take how the institutional arbitrations, which is functioning so effectively in China, why can't it function in across the globe, across particularly on the global south countries? To add SCIA's role on the specialized arbitration, particularly the IP disputes, can be a good model. And this model, along with several People's Court judgments, also facilitating not only the promotion of institutional arbitration, the way how the draft Chinese arbitration law is proposed, there are some points to even accept the ad hoc arbitrations in future. But anyway, being the Chinese model of having the institutional arbitration as a prime mechanisms to resolve the disputes, which would be taken note as a serious outcome and as a contemporary development, we also are keen to just explore a long-term collaboration within this global south, particularly with Schengen Court of International Arbitration. Thank you. Thanks for your valuable contribution.
Thank you. Thank you so much.
For the next speaker, we are privileged to welcome Mr. Samir Shah, a seasoned advocate, arbitrator, mediator, and a visionary in the field of ADR with nearly 3 decades of legal practice. He is the founder of SU Shah and Associates in Ahmedabad and the ADR BAR, and serves on numerous prestigious panels, including the Court of Arbitration for Art in the Netherlands and the Gujarat International Maritime Arbitration Center. Mr. Shah is also a co-founder of NRAP India chapter and a faculty member for mediation training at IM Campus, Germany, actively promoting ADR practices both in India and internationally. His extensive cross-border advisory work and dedication to mediation education has made him a respected figure in the global ADR community. We are honored to welcome Mr. Samir Shah to share his perspectives on ADR recovery systems in the United States and to contribute richly to today's deliberations. Over to you, sir.
Thank you, Shakti, and thank you, Inba, for this kind invitation. I hope I'm audible enough.
Yes, sir.
All right. So, a very good morning to all of you, and it's almost good night for me here in the US. But yeah, thank you so much for this invitation and inviting me to speak on, of course, my passionate subject of ADR, and especially on a very, very developed jurisdiction, USA. I mean, I came here 2 years back, so I'm doing both India and US side. Though I'm not yet licensed in US, but I still do constantly for my Indian work here. Now, I just give you briefly an overview of the US arbitration scenario. Probably quite a few of you would be aware about it, but for a general understanding, so US, as I said, is a quite developed, very developed, I would say, jurisdiction so far as dispute resolution through arbitration is concerned. Arbitration here in US is very, very extensively, implemented, followed for dispute resolution in practically all major industries, you name it, be it technology, finance, consumer, construction, and so on and so forth. So it is very extensively being used for resolution of disputes. And the main legislation through which arbitration is governed is the FAA, which is the Federal Arbitration Act, and it governs the institutional arbitration. And now US has so many renowned arbitration institutions. So the majority of the arbitrations are done through institutional arbitration, and you name it, and they have the best of the institutions here, like AAA, ICDR, ICC, JAMS, CPR, NYIAC, and so on and so forth. And all of them have quite a robust system of dispensation of dispute resolution through arbitration and mediation as well. Now, apart from this federal legislation, each state has its own state legislation for arbitration, which of course supplements FAA. And the US courts have also been favorably implementing, and supporting FFA and dispensation of arbitration. Now, some of the recent trends so far as arbitration concerning the United States is, I would just mention a few of them which are very important. The first being summary adjudication. Now, there is an increasing trends towards summary adjudication of claims where the claims are devoid of any merit. And institutions like ICDAR AAA have extensive, rules provided under their provisions for summary adjudication. The next is, of course, a very important aspect is the diversity and inclusion, which is also gaining much popularity and increased attention across the arbitral world here in US. Of course, post-COVID, as is in other parts of the world as well, virtual hearings have been again given more importance, have been on increase in US as well. Then emergency arbitration, of course, many other jurisdictions also are focused on this, same in US. One aspect which is more, I would say, in my experience, which I've come across is, which is growing on a much larger scale and more focused way is AI in arbitration. It's a very interesting, concept of or the process, and I know there are debates going on about the pros and cons of using AI and to what extent one should be, implementing it. But if we take on a positive side, AI, of course, is very helpful, I would say, in large complex cases. So far as discovery, streamlining the case management is concerned. So if the AI is used in that manner, and which is actually being used here in US by institutions like James and the Silicon Valley Arbitration Mediation Center. So I think AI is I would say, a future of dispute resolution so far as in a facilitative mode. I would say not that we totally, depend on AI, but it definitely gives a much facilitative role play for effective dispute resolution mechanism through arbitration. As I said, the institutional arbitration definitely has been in focus and is the basis of dispute resolution through arbitration in US. And US being also party to many treaties and conventions like Inter-American Convention on International Commercial Arbitration, which is known as Panama Convention, Convention on Settlement of Investment Dispute, of course, ICSID, North America Free Trade Agreement, NAFTA, and so many such treaties which also provides for dispute resolution through arbitration. Another aspect is what is known as default awards under the US system, where if the respondent fails to appear in spite of court directions, then the tribunal can make a default award and which are enforceable. So that's a very important and aspect of arbitration in US. Considering the current geopolitical and international trade situation, which also has given much more focus to international arbitration in US. Now, as I was telling you about AI, now it is again being very extensively being used in US so far as our international arbitration is concerned. With generative AI and large language tools, which facilitates arbitration process, especially document review, e-discovery, search analysis, and summation of large database, indexing of exhibits, visualizing complex information sets. So as I said, this definitely is helpful so far as effective case management is concerned. And therefore, institution like AAA has introduced even what is called the Clause Builder AI, which is a tool which uses database of clauses and provide arbitration clause building services. Then it also has introduced triple AI panelist search, which helps the parties or the counsels to effectively or in a very better way search for the panel selection process. So, yeah, in a nutshell, I would say that things are definitely much advanced and developed in US. So far as arbitration is concerned, US of course is a common law jurisdiction. It follows the model law in most of the aspect, and the courts also have been very pro arbitration so far as dispute resolution is concerned. Over to you, Shakti. Sorry.
Yes.
Yeah.
Yes, Samir. Thank you. Thank you for sharing the perspective of arbitration, which is so well structured. That's what we can understand from your presentation in US. Here, at this point, we are very much interested to invite you. Why? Because the connect what you have, that is the India and US connect. For the information to most of the audience and co-panelists, Mr. Samisha is a very prominent lawyer, I can say, a litigating lawyer who has accepted, that's very important, who has accepted that ADR is going to be the future. Alternative dispute resolution, the mindset of a litigating lawyer, how it shifts from the traditional litigation to ADR, particularly the mediation front.
Yeah, I agree, completely agree with you.
Yeah, this is very much required. The very objective of the mindset, what we call, and as a former colleague with in the Chartered Institute of Arbitrators, where been long for more than a decade in the India branch as well as the Asian arena, the objective of this shift from litigation to ADR is very important, starts from the training point.
True.
The stakeholders, significantly the lawyers or legal representative appearing before the tribunals or the arbitrators or the mediators, the effective training makes a standard. If the standard is there, obviously this can be structured very well. And that is the takeaway what Mr. Shah wanted to share. Anyway, being a larger global North player, US, whether it is going to be the Federal Arbitration Act of US or the other state legislations on the ADR front, along with a very prominent institution that is AAA, American Arbitration Association's unit of International Center for Dispute, ICDR. I'm with that few informations, what I know personally and what has been given elaborately by Mr. Samisha, this Global South Alliance would need a lot of support from you, being the promoter or pioneer of the concept of ADR bar in India, which has now been evolved as the Arbitration Bar of India. You happen to be the front runner for this task, which is going to spread not only in the aspect of a very small jurisdiction, we had to larger make it as a global arbitration bar. With that point, I think there is a couple of expected questions, which.
But let me, Inba, let me just add one thing which you just mentioned, which is very important, which is the current US-India trade relationship. Now, it's really growing on a much larger scale than it was before. But as we all know, with the growth of trade, there are bound to be, disputes arising out of those relationships. But so it is very interesting to see how all this relation develops and what happens in future so far as trading relation is concerned. See, right now everything is going very positive, and we hope that it goes with that way. But you never know. I mean, trade, there's always all the chances of disputes coming up. So how those disputes are being tackled, resolved, attended to, that is, I think, a very important aspect which we need to look forward to. And secondly, again, what you very correctly mentioned is the aspect of mediation in ADR. And in my experience, what I've when I've been interacting with colleagues down here in US, I think in US also there is a big shift of focus from arbitration to mediation, so far as dispute resolution is concerned. And I have seen, and I've been even you've been part of many such programs, the trainings basically. So each state, state bar association is going through, especially New York, which is very active and prominent so far as ADR is concerned, and mediation for that matter. Down south is, of course, California bar is again very proactively involved in ADR and mediation. So mediation is, again, I think we need to also lay focus. Of course, there's a big change for a positive side. So while mediation does in India, with the act coming in play. So I think we need to focus also and give that importance to mediation for effective dispute resolution.
Yes, well said, Mr. Samir. With this note, I wanted to bring to the audience as well as the panelist, one of the global south country, obviously Singapore, which initiated this mediation to a larger scale in the 2018 dialogue, what I can personally look upon. And when in 2019, the Singapore Convention was signed by more than 40 countries, the initial introductory date itself, a global south country looking into this particular mediation in a serious note, much ahead from the other developed or the economies which are having a larger history on this ADR. The concept of mediation going along with international settlement agreements, which has been emanated out of those mediation, is in the pipeline of multiple jurisdictions, particularly whether it is going to be Qatar, whether it is going to be Iran, whether it is going to be Belarus, Ecuador, China, many countries, including India also. They have now started ratifying this particular convention, bringing in the mediation legislations, which is a shift from the traditional conciliation in most of the global south jurisdictions, now started adopting these mediation predominantly in all type of disputes. That's very important. As rightly pointed out, the traditional aspect of the dispute, which were trade disputes. Now moving to multiple other disputes, there might be exception. The Singapore Protocol, which avoids the personal disputes, the family disputes, the reservations on sometimes which has been recommended for a sovereign state's involvement. Other than these, this particular protocol, which if it has been taken in the manner how it was prepared, I think whatever the jurisdiction, they will be a valuable contribution for the growth of ADR. Mr. Samir, if you have some more thought on how this the present trade issues which is happening with the jurisdiction where you are right now practicing, to what extent, whether it is the tariff regimes, whether the aspects of relooking on various trade arrangements or negotiations or deals, or having an amendment or mutations in the free trade agreements, all sorts together, US with all the jurisdiction. It's a well-known fact that US having or acting as a major trading partner with all the developing or the developed economies. To what extent you feel, particularly on the context of applicability of mediation and arbitration in such dispute?
I think it's a very interesting question, and if we look at the current situation, what happened post the tariff levies by the US government, I would take that in a positive way of what happened thereafter between different governments having dialogue and conversation with US. So it's a sort of negotiation. What happens in mediation? Yeah, the negotiation is a very important part of mediation for that matter. So I would look this post-tariff situation as a sort of negotiation happening in a mediation, in a mediated dispute. Though there is no dispute per se as we see it, but of course there are differences, between different countries with the US outlook to tariffs. But what happened and what is happening when the government of different countries are coming along, sitting with the US government and trying to work around this tariff issue is nothing but, I would say, negotiation tactics, which of course is very important for a government to adopt that, maybe for its own benefit. There's nothing wrong. So you see, ultimately, every government works for its own benefit, for the benefit of the country, for that matter. But if this kind of a situation, this kind of a negotiation is being positively worked around, positively being taken into account, I think major trade issues across the globe could be very effectively resolved on a larger extent. And in fact, I was really thinking it's good that you came up with this suggestion. I would suggest that why mediation be not being used in the current Russia-Ukraine situation. Why? So what is happening? I mean, we have across so many renowned mediators, yeah, people who can influence, but why it is not happening? Either is it that there's something very, very wrong with the situation? But even if that, we know how to negotiate, how to come out of a difficult mediation. Of course, mediation cannot be successful every time. That's accepted. But has that been effectively being used in the current situation between Russia and Ukraine? So I think that could be a good test for promoting mediation in international disputes.
Yeah, well said, Mr. Samir. This makes me to get back to the history or epics about Mahabharat. Many of you, the audience, coming beyond the Indian diaspora, it is a very interesting epic, Mahabharat, wherein there was a god by name Lord Krishna. He tried this mediation technique, quite historical period, according to the historians. There also there was an effort, whether it is going to be the geopolitical issue or even the trade issues, there was a try. But that try reasonably made certain conclusions in a successful manner. Why not? It can be adopted in the present day civilized society. Mr. Samir, it's a valuable point what you mentioned, particularly the existing geopolitical issue happening in the Central European region. And not only that, here there were multiple other issues. Some half a decade back, there was a big issue on the economic embargo on a particular country, Kingdom of Qatar, wherein the other Arab nations had an economic embargo. And later there was a successful mediation. Even though it took some longer period, it was so effectively concluded without even escalating to a larger scale confrontation. That's very important. And this also we can see whether it is all the global south countries, whether it is going to be geopolitical or ethnic conflicts or whatever the rebel movements, all have been reasonably come to an effective conclusion without escalating with mediation. Whether it is going to be individuals mediating or whether it is the sovereign state mediating. Here, there were a great development of bringing in mediation within arbitration. There were some associations quite early, bodies, whether academic as well as arbitration institutions, which wanted to have a coexistence of both. That coexistence, I feel, US is promoting in the manner as a learner in ADR. US is the model from Global North that med-R clause has to be accepted. Start with mediation. If the mediation is successful, there ends. If it is unsuccessful, we can take it to arbitration. That the combination, a hybrid, which is being suggested predominantly in the US jurisdiction, which will be taken as a next step for the growth of ADR in Global South and making the Global South to be a future stronghold for arbitrations and mediations. Thank you, Mr. Samisha, for spending
Thank you so much.
a late night in US after an enjoyable time with your family, particularly with your daughter getting into her career in US. Thank you.
Yeah, thank you, Imad. Thank you so much. It was real pleasure to be here on this, large global level program on, on ADR, and I think this is the kind of the movement which is required at this stage to make ADR the future of dispute resolution. Thank you so much, Imad. Thank you so much. Bye.
Before we move on to the next speaker of the day, we at KFCRI would like to share a short video that highlights our institution's journey and gives you a better insight into who we are. Please sit back and enjoy this presentation.
Yes, before going into the next speaker, as a protocol, we are maintaining the avoid noise pollution, even though our voices won't be a noise pollution, but when it comes to the recordings, it's better to avoid. But as a interesting note, when you're looking into this video, it's going to be future also screened. We have to take it serious that to what extent we are going to be associated with ADR. That's very important, whether it's training or whether it is going to be the case management or whether it is going to be administration or monitoring of the traditional arbitrations and mediations. It has to be a serious note. Everything is leading to institution. Institutionalization of arbitration is very significant. Yes, I'll share it to Mr. Sippy.
Thanks for the participants to be remaining here. We are honored to welcome Mr. R.F. Edison, a seasoned legal professional with over 15 years of experience in litigation, non-litigation, and a specialized focus on capital markets and arbitration. He is a founder and chairman of Indonesian International Arbitration Center, INIAC, an institution inspired by his acclaimed book Twin Arbitration. Mr. Edison is also founding partner of Edison Law Group LLP and has provided legal counsel to over 200 clients, both domestic and international. His contributions extend to regulatory advocacy, mediation at the South Jakarta District Court, and legal innovations through his My Lawyer smartphone application. We are privileged to welcome Mr. R.F. Edison to share his insights on the ADR landscape in Indonesia and to enrich today's proceedings with his visionary leadership and global legal perspective. Over to you, sir.
Thank you very much for Kovise and also the founder, Mr. Inbavijayan. I'm gonna share a screen. Well, apparently, as a capital market lawyer, I do understand that the ADR is an integrated part with the capital market. We understand that all the users of ADR mostly are multinational companies coming across multiple jurisdiction and legal system, from common law system, civil law system, and also Islamic law. I'm gonna step forward to the similarities between India and Indonesia. We have a very close independence date. Even we have indeed the same month. And since our independence, India is forecasted to be the third largest economy, right after China in 2027 by the IMF, while Indonesia is also forecasted to be the fourth largest after India in 2030. We understand that both countries have a non-confrontational cultures, even far before their independence, under the same Asian culture. Moreover, India is the second most populous country in the world, right after China, while Indonesia is the fourth. And if you compare with China as the largest economy based on purchasing power parity and the fastest economic growth We understand China try to prevent any dispute at all. And they optimize the use of mediation to reach zero dispute. And their most reason is about the signatory of Convention on the Establishment of International Organization for Mediation, which will be held on the next 30 May 2025 as the first intergovernmental mediation organization with the backing of Beijing. And I think the facts say that Indonesia, India, and China, three of us, we promote ADR through mediation at our best. And mediation itself is not just a method. We understand mediation as the fastest dispute resolution, the cheapest, most effective, and the highest prospect, even the best, to be combined with arbitration, or as we know as med-arb, med-arb. In Indonesia, mediation is integrated in the law number 30 of 1999, where in the article 45, first one is found that if the parties appear on the determined day, the arbitrator or arbitration panel must first attempt to bring about an amicable settlement between the parties in dispute. And the obligation continue to explore amicable settlement until issues are joined regarding merits of proceedings. Next, we're gonna talk about the potentials. As the population of both countries, India and Indonesia, plus China, is already half of the world, and we are in the top 3 fastest developing countries. Moreover, 7,500 cases out of 10,000 cases annually, according to Global Arbitration Review, comes from Asia. And we need to optimize whatever way possible. As the world's largest users of ADR services, we need to be the masters of our own disputes. Not to mention that we are the ones who understand our own culture best. INIAC not just offering speedy and economical resolution, but we also offer reconnection for your business. Thank you. And that's all from my sharing today. And if there is anything I want to add is today is also our last day of our first international training for arbitration and mediation. And through this platform, we want to promote a 90 days proceedings. And I think the first construction adjudication from Indonesia. Because previously, Indonesia doesn't seem to have one. So we will grand launch our rules within the next month. And we hope for further collaboration, not just with Kovise, but also from all the stakeholders throughout the regions. From all the seasoned practitioners are welcome to join. I don't know if this Congress will include any discussion, or is there any panel will sit with me to discuss some issues or not?
Yeah. Just a few questions, Mr. Arif. Just since you've been into the capital markets in Indonesia and being an arbitration uh, enthusiastic, what do you think? Since it is a new concept in worldwide, I don't think most of the countries have it's a very rare combination of capital markets and arbitration. Where do you see the advantages of using arbitration instead of litigation in capital markets?
Yeah, I would say that the arbitration or ADR is actually the cure that has to be involved by any multinational companies in the capital market sector, because we understand that business growth is always depend on the smoothness, and any kind of conflict will absolutely be the obstacle that need to be overcome. Yeah.
Yeah. Anything else to add, Mr.
I think that's all from me.
All right. Sir, I think you're on mute. Yeah.
Thank you, Mr. Arif, for sharing an insightful thought about the capital markets. Before moving to the next speaker, I need to share an experience about capital markets in India. After the pandemic, the perspective of dealing with disputes, particularly the capital markets, there was a new system called Smart ODR was created. Securities market approach for resolution of disputes through online dispute resolution. And in that inbuilt, they structured 3 layers. The first layer is conciliation or mediation, traditionally called. Then the next layer is arbitration, and the other layer happens to be appellate arbitration. Then only it can go to the court. In that way, it was really acceptable and a welcome development, which can be adopted across the globe. Thank you, Mr. Arif, for representing Indonesia as well as INIAC in this initiative. And in our alliance, you will be a significant partner promoting this concept. Thank you.
It's been a pleasure, Inbavijayan, again for INIAC and the rest of Indonesia, because, however, we do know that the basis of Lex Arbitri is the Lex Mercatoria, right? So yeah, enjoy the session.
Thank you.
Over to you.
Thank you.
Have a great day.
Mr. Bivan,
Yes, we are honored to welcome Mr. Bevan, a distinguished legal and regulatory professional with over 24 years of experience in competition policy, corporate law, international trade, and project management. He currently serves as the Executive Director of the Fair Trading Commission of Trinidad and Tobago, where he leads efforts to promote fair and transparent markets. Mr. Trinidad holds multiple advanced degrees, including from the London School of Economics, the University of Arizona, and Harvard University, and is a certified project management professional. He is also an associate of the Chartered Institute of Arbitrators and a certified mediator with a strong background in commercial dispute resolution and international negotiation. We cordially invite Mr. Bevin to share his insights on ADR in Trinidad and Tobago and contribute to today's discussion.
Yeah.
Over to you, sir.
Yes, Soundarya, thanks for the brief introduction about Mr. Bivan. A humble request to Mr. Bivan. Mr. Bivan, you have been complimented with another 10 more minutes for your presentation so that in addition to what you have prepared or going to share, you can also talk about the perspective from the end users, depending upon your practical experience, not only in the Caribbean islands, but also you can just explore where you are right now. I think you are in Peru. And being the Latin American market as a large, as well as the Caribbean, which the connect, that also you can just share so that it will be very interesting for the participants and co-panelists.
Okay, well, I'll try my best for this additional thing you wanted me to do. So no problem. So would I be able to move the screen, or would you be doing that? The slides. So all right, okay. So okay, I will just say when to move the slides then. Okay. So thank you very much for the opportunity to speak today. It's 11:20 in Peru. As I had indicated to the organizers, I'm at a conference in Peru. I did a presentation at 5:30 this afternoon, and the presentation was actually on advocacy and the work that I have been doing every day in that respect. And I think this is very good as a good segue into what I have to speak to today. And I really appreciate the extra time, because persons who know me always say I need extra time to speak about different issues. And and I'll give different perspectives, practical perspectives from my experience. So, well, the focus would be initially on Trinidad, Tobago, and CARICOM to give participants a better understanding of where we are at. And I must say, I was listening to some of the previous presenters, and I think we are at a good stage. And I want to thank the Kovise for giving me the opportunity to speak to you all and to share my experiences. So next slide, please. So just to indicate, this is usual that because, as you all would know, I wear a lot of hats. I do a lot of stuff. And just to indicate that this presentation is mine and mine alone, and the views expressed are mine and not necessarily those of the organizations that I represent. But to just reiterate, these views I think are very relevant to the purposes of this meeting. Next slide. Next slide, please. So just to give persons a perspective, and I think this is very important because we have to speak about this. Trinidad and Tobago is part of the Caribbean community. Now, we're very small. I heard my colleague from Indonesia just speak, and he spoke about Indonesia, China, and India. We are much smaller than you all in terms of population. By the end of the day, we are 15 member states in the Caribbean community region, with our systems mainly being English-based, common law-based, because most of us were former British colonies. And we have relied on, but we are now trying to develop our own arbitration infrastructure now, because we recognize the the use of ADR and its effectiveness and its flexibility. And I think that is what we need to always stress. And because of that, our laws are now being amended to suit. And because we recognize, and that's very important because what the host had indicated just now was that the practical perspectives is that we want to encourage ADR. We want to encourage really investment in this region, right? We have certain advantages, we believe, in terms of the fact that we have a very educated workforce in Trinidad and Tobago and in the overall CARICOM. We have very good, I think, a very good geographic location. We are collectively we are located close to both South America and North America. But in order to attract that investment, it is very important that we have appropriate infrastructure, an appropriate legal structure, and to make and we believe a proper structure to settle disputes, whether it be through the courts or whether it be through ADR mechanisms, is essential. And we believe that once we have that, it gives investors the assurance that their investments can be protected. And that is one of the things that we are aiming for in the region. Next slide, please. So just to indicate the treaty that formed the Caribbean community was the revised Treaty of Chaguaramas. And even then, it was very important that they have systems in place for dispute settlement that not necessarily involves the courts. So even from then, we have various ways in which member states of the region, the 15 countries that make up the Caribbean community, settle their disputes. And as you can see, they go through good offices, they go through mediation, consultations, conciliation, arbitration, and only adjudication at the last level. So countries do not want to reach that level. When their member state disputes, in other words, we don't even want to be like how, for those who know about the European Union, when there are disputes between countries, sometimes it goes before the European Court of Justice. Now, we have a Caribbean Court of Justice, but the idea is for that dispute to only go there. If a member state, for instance, has a trade dispute with another member state, we're only going that level to that court only if we have to. We are looking at all other ways to solve the disputes as quickly and as peacefully as possible. So that is even embedded in the treaty that established the Caribbean community. Next slide, please. So Trinidad and Tobago, now just to indicate that we have a population of less than 1.5 million. That's where I live. But as I said, we consider ourselves to be very attractive for investment. We get a lot of investment from China, from India as well too, from the United States, as well as the European Union, mainly the United Kingdom. We have a relatively stable legal system. We have a very good geographic location, very educated workforce. We also have energy in Trinidad and Tobago, meaning we have natural gas as well as oil. So this has made energy costs very low, and this helps that we have a structure that could assist with that. And just to also indicate, we also are part of the various diasporas. As I went in my pre-meeting, I had indicated I am 5th generation Indian and proud of it as well too, with origins from Kolkata, but as well, I also have origins in Hong Kong as well too. And that also has a reflection in terms of the investments that we can get in the region. In terms of our and Trinidad and Tobago, there's also been a proactive approach to infrastructure development and economic diversification. There are various industries and sectors that the government has targeted for there to be greater investment. Major industries other than oil is tourism as well. Mainly in the case of Trinidad and Tobago has a lot of very picturesque beaches and things like that. We also have a very vibrant manufacturing sector where a lot of products are exported mainly throughout the Caribbean region. But we are also trying to access new markets, and we also have a good financial structure and a financial system where we have an international finance center where entities do come to look at possible investment opportunities. But as with all regions, we have some issues as well too. Red tape has been identified as a major issue. The ease of doing business index, the World Bank ease of doing business, we tend to not score too high at that at times because of the red tape and bureaucracy that is involved in getting approvals and getting things done. We also have some foreign exchange problems as well too at times, and there are some security concerns. But we think that at Trinidad and Tobago, at least, we as a people think we can overcome these challenges and become even more attractive for investment. Next slide, please. So in terms of international arbitration agreements, well, most CARICOM countries, including Trinidad and Tobago, we are a part of the New York Convention for the enforcement of judgments, and this has been reflected in the work that we are doing. Some states haven't ratified, and efforts are being made to improve that level as well too. Most of the arbitration laws that we have are outdated, based on old legislation. However, a growing number of CARICOM states now have recognized the importance of having modern arbitration legislation. And this is mainly based, three countries, notably Barbados, Jamaica, and Trinidad and Tobago, very recent. We have amended our legislation, and our legislation has been based on or greatly influenced by the ancestral model law and arbitration. I must say as well, I have a very good knowledge of that model law because of the work I did when I worked in the Caribbean community. I did actually work there prior to this present appointment, and so have a very good understanding of the model law. And we try to encourage other states in the region to adopt that law in terms of getting amending the legislation to make sure that they were in accordance with that, because we recognize how old and archaic the present arbitration laws are. So we are trying now to encourage more of that, and hopefully that could happen soon. Trinidad and Tobago, that was a major effort on the part of the Trinidad and Tobago government in 2023 to have new arbitration legislation that would be based on a modern system, such as the ancestral arbitration law. So next slide, please. So just specifically with Trinidad and Tobago, we are have been party to the New York Convention since 1966. We're also a party to the long-standing to the ICSID Convention. We, in fact, some of the work that I did that was with respect to disputes that would have been settled through ICSID as well too, where some investor state arbitral rewards were enforceable in the jurisdiction, and we are a long-standing member. As I said, the new legislation was that is in line with the ancestral model law, because at the end of the day, we recognize the need to foster a conducive environment for international trade and investment. I was previously a member of the board of directors for the Trinidad and Tobago Trade and Investment Promotion Agency, and when we reached out to investors, they would have spoken to us about the need for a predictable regime, and this included a good regime for alternative dispute resolution, and which we took that into account and encouraged the government to have that legislation in line with the ancestral model law. And right now, the courts have recognized the need and the importance of ADR, and now they are expressly required to stay court proceedings in favor of arbitration where a valid, and I must say valid, a valid arbitration agreement exists unless the agreement is null and void, inoperative, or incapable of being performed. And I will mention in a later slide some relevant cases on that issue. So basically, this new law is expected to improve the trade and investment climate, and that has it's very early still. It's only 2023 the legislation was enacted, but the idea is to improve the ease of doing business, and it emphasizes the need, and I think that is very important with ADR, the efficiency and flexibility that ADR and in particular arbitration offers. So we recognize the need for a reliable and predictable environment for investors who are looking for efficiency and cost effectiveness. And it also, of course, strengthens the finality of war awards that are made by arbitration as well too. And again, the confidence of actual and potential investors are key, because they need to recognize and know that their dispute potential or otherwise could be settled through a modern, efficient, and internationally recognized arbitration procedure. So we think that this new law can bring that about. Next slide, please. And in doing so, what I would like to also emphasize is that Trinidad and Tobago is not only looking at the fact that we have this law, we also are looking at the fact that Trinidad and Tobago, because of our educated workforce, we have very well-trained judges, we have very good institutional systems in place. We also look at ourselves as being a seat for arbitration. You know, you always hear about London as a seat and some other jurisdictions. Trinidad and Tobago is not, at least for the region. Other countries close in this region may think otherwise, but we are looking at Trinidad and Tobago as a place where we can become a seat of arbitration at least for the CARICOM region. And we have various structures, institutional structures, some of which I have received training from. I received training from the Dispute Resolution Center. When I was being introduced, I'm a certified mediator, and that was through efforts training from the Dispute Resolution Center because they have this arbitration mediation service plus training as well too. The Law Association of Trinidad and Tobago also offers that kind of service as well as private ADR firms. So ADR has been existing in Trinidad and Tobago for a considerable amount of time, and now with the new law, we believe that this could also help enhance the work of our local ADR experts, with Trinidad and Tobago becoming a seat for arbitration in the region. Next slide, please. So in terms of how arbitration is used in Trinidad and Tobago, a more practical element is that arbitration is used particularly for large contracts because we understand how these things are negotiated, and the need to have these disputes settled as soon as possible. As I said, oil and gas is a big sector in Trinidad and Tobago. Well, anytime you are doing contracts in that sector, there's always an arbitration clause. There's also in construction. Construction is a big industry as well in terms of fixing, building highways and other major roadworks as well too, as well as major building infrastructure. So these often include arbitration clauses because the need for flexibility and efficiency to get these things settled, because when these disputes arise, and they do just, that such is the vagaries of life. And when these disputes happen, they often take a while to settle if they have to go through the courts. The court system has a lot of cases right now. So that's why arbitration is so important, right? And many that are adopted use the various ICC, LCI rules, and sometimes hearings are in Trinidad or sometimes elsewhere. The local judiciary also recognizes the importance of in a case from 2015, and which also emphasized the need for clear legislative guidance. And going forward, it's expected that our local judges, because we have civil proceeding rules that also emphasize that, to follow a pro-arbitration mandate, limiting court interference and facilitating speedy enforcement of awards. So that has been what we're trying to do. Next slide, please. So we also have a Caribbean Court of Justice. I mentioned the European Court of Justice in passing, and this is the final court of appeal for 4 CARICOM member states: Barbados, Belize, Dominica, and Guyana, but not Trinidad and Tobago. Trinidad and Tobago still goes to the Privy Council in the United Kingdom for final appeals. But in terms of the CCJ has also been encouraging the use of arbitration for disputes among member states. And this is recognized because they also recognize that we need a robust arbitration regime to improve the ease of doing business in Trinidad and Tobago. So, and in the region as a whole. So arbitration is being recognized, the ADR is being recognized at all levels in Trinidad, in the region, and in Trinidad and Tobago as well too. So that's why I think what we're doing today is very insightful, and it really speaks to what is going on all over the world, even in countries that you may not be looking at immediately. Next slide, please. So moving forward, the culture of arbitration is in fact growing in Trinidad and Tobago. Businesses and lawyers are increasingly becoming aware of that. In fact, arbitration has also been a major part of the various trade agreements we have been doing as well too. Trinidad and Tobago has a number of agreements. I would have been negotiating earlier in my career bilateral investment treaties with a number of countries, and we also have free trade agreements where there are clauses to settle disputes mainly through the arbitration route, the mediation route, conciliation route, as opposed to going to courts. And we believe that we have a number of arbitrators here, very well experienced, who can assist with that. And we want to leverage our stable legal system and our trained legal fraternity, as well as this new law, to market ourselves as a arbitration-friendly jurisdiction. Next slide. So in terms of other CARICOM jurisdictions, I just would mention that, as I said, other countries in the region may not think like us, in that both Jamaica and Barbados, they have set up systems. Jamaica has the Jamaica International Arbitration Center. A friend of mine was the one who launched that. And Barbados has also been doing some initiatives with that, because both of them are also, and they share some of the similarities with Trinidad and Tobago in terms of having very well-trained legal staff, a well-trained legal fraternity. So everyone is looking at ways in which they can be a seat for potential arbitration matters as well too. Guyana and St. Lucia, two other countries in the region, they are considering setting up arbitration centers. And there's been a general investment in this ADR in the region, and the importance of training the legal fraternity, because this alternative way of settling disputes and the flexibility that it does bring with it, and the effectiveness, are being recognized. And this will hopefully encourage more businesses to choose arbitration as a way to ensure that the process is fair, efficient, and enforceable globally. Next slide. So in terms of cases, what I would mention in these cases is that generally courts have been enforcing foreign awards under the New York Convention throughout the region. But what these cases would have indicated, particularly, was that arbitration clauses, arbitration decisions are not always enforced. And that's a little unfortunate, but I'd just like to highlight that some of these cases involve the government, and where the courts have made the decision not to enforce certain arbitral awards on public policy grounds. That was why in CB Holdings and Belize Bank versus the government of Belize, the agreement was not enforced because it was felt that it would have conflicted with the Belizean constitution. Then there was a case that has been in the public scrutiny a lot in Trinidad and Tobago, the National Infrastructure Development Company Limited case against OAS. OAS is a Brazilian company where they did some road work, and there was an arbitration award for the government canceling a contract with OAS, and OAS brought the action for wrongful termination of the contract. And the High Court felt that, and the award was considerable. We're talking about over $100 million US. And the court set aside that award. But it distinguished, although it recognized the finality of arbitration judgments or decisions, it was felt that the court was not acting as an appeal court here, but as in its supervisory jurisdiction. So that is where the distinction the court chose, and it felt that with the supervisory jurisdiction and not as an appellate court, it ruled that it was against public policy to enforce that case. So the judgment by the arbitrator in that case. So that speaks to what is going on in the region. I think it's something that we need to, because the OS has appealed. The case is now before the Court of Appeal, and it might go to the Privy Council. And it does speak to the fact that sometimes the finality of arbitration awards are not necessarily being enforced by the courts for public policy grounds. And sometimes the court is not acting as an appellate court in any respect, but as a supervisory jurisdiction with certain powers it believes it has. Next slide, please. So there is indeed some challenges. I said this doesn't really mean the Caribbean region, Trinidad and Tobago, but we still need in order to make ourselves more, and that's why associate organizations like Kovise is very good. We still have to continue the training of professionals, and also we have to increase the awareness of the use of ADR, particularly for small and medium enterprises, because it's a way for them to get disputes settled as well too very quickly. There's also a culture of resistance. I think a lot of persons prefer the finality of a court ruling, but they don't understand many times that ADR could give them that same benefit, that same advantage, that same assurance as well too. Also the fact that enforceability and neutrality, there's some concern sometimes that the arbitrator will rule in front of in favor of the more powerful party. We have to at least clear that and make sure that arbitrators are are seen at least as being much more judicious in their views, much fairer and impartial. And there's also the fact that the cost of arbitration could be prohibitive for small enterprises. So the idea is to do some work to ensure that that doesn't deter persons from coming to using arbitration. Next slide, please. Next slide. Oh, coming to the end. Next slide. So key takeaways is that we still have to always look at the public policy considerations, but there has been judicial progress, and that would have been quite clear from the other slides that judges are in fact recognizing and supporting arbitration. But at the same time, we have to there is the public policy consideration that sometimes supersedes in their mind that there's also the need for clear legislation. Some other countries in the region need to adopt this model law. At least their laws, the arbitration laws based on that and international best practices. We still have to do some more work to increase awareness as well too, and training has to continue as well too. Next slide. So areas for improvement, and again, we have to do this as a region, and there has to be a thrust for that, updating laws, encouraging more persons to join the jurisdictions to join the New York Convention. Probably a CARICOM model arbitration bill could help with that and to help the updating of the laws to give the guidance. Court procedures for the arbitration needs to be streamlined, more public education and awareness, and more certification and training as well too. As an example for me, as indicated, I'm an associate at the Chartered Institute of Arbitration. Nothing was holding me back from becoming a FCI ARB, but I guess people like me need to be encouraged to go the extra route because we already have the interest in arbitration, so just go the extra route. But I guess it needs to be, I guess it's somewhat a little commercially viable for me, especially given what I do as well too. Next slide. I think coming to the end. Next slide, please. So going forward, I think that Trinidad and Tobago is, and I will leave it at that here, and then I'll add some of my perspectives. Trinidad and Tobago is positioned to be a leading arbitration venue, and that is where the reforms have indicated. We have adopted the ancestral model law, and that has signified a commitment to improving our arbitration system. And again, we need to, as a region though, reinforce the principles of fairness, transparency, and efficiency in dispute resolution, as this inspires greater confidence, reduce commercial risk, and increase support for sustainable growth. Now, just to add for a minute or two with respect to the work that I do. Now, as indicated, I am the Executive Director of the Fair Trading Commission. We have had disputes, we have had issues with various stakeholders, and when we have these disputes, we also always try to use the ADR method instead of bringing actions to court. We try to, if we see some potential violations, we tell them to stop. We have identified this, to give you a time period to cut this out, or at least have some kind of mediation to ensure that that does not that stops at the beginning and doesn't go further. And so we even use ADR in regular work as well too when there are some disputes. Even if we make certain decisions and entities want to purposely bring us before the court, we use the particularly mediation though to ensure that that doesn't happen. Well, I'm in Peru as well too. I'm given an international perspective. One of the things that it's an international competition meeting that I'm at, And a major issue we had discussed in terms of our advocacy work would be to encourage coming to us, more entities to come to the commissions, but to also know that we will be able to try and settle things without necessarily going to court as well too if there are potential disputes. And as a former trade negotiator as well too, this has been very important when we negotiate trade agreements. I have negotiated trade agreements with part of teams. I negotiated trade agreements with Nicaragua, with El Salvador, with the United States, with Canada, with the European Union as well too. And a major part of these negotiations has been the dispute settlement clause. In fact, sometimes the dispute settlement clause is what holds back agreements from being signed. And we have always at times emphasized the need for there to be proper ADR systems in place. And both sides have been in favor of that because we know that we don't want our trade disputes to hold back the success, the potential success and market access that you can get from international trade agreements. And we know that we want increased investment, and investors really do not have, I think, much trust in the court systems here. Not because of the decision making, I think, but because of the time. And time is money. And that's why you need to have proper ADR systems in place in order to attract. So all the work you're doing in terms of trade negotiations, in terms of investment negotiations, to get investors. I think of equal importance is to ensure that they know that whatever disputes they have will be settled in a fair, amicable manner in a as efficient a time as possible. So I think that would be my contribution right now. Next slide, please. I think that would have been the end. And I'm available to answer any questions that any person may have and to try and address them to the best of my ability. So again, thank you very much for the opportunity to speak to you. It's 11:50 Peru, so tonight. Okay, thank you very much.
Yeah, thank you, Mr. Bivan. It was a really, really new, an eye-opener, what I can say, for many of the practitioners in Asia to understand the developments of TNT arbitration legislation. In a personal career prospect, when I was just divulging into the Caribbean islands, or the traditionally we call the East Indies, the act, that is the 2023 Arbitration Act of TNT, which is considered to be like a keeping pace with the international development, particularly on the counterparts, the Caribbean, like Bermuda, which is a tax haven, the British Virgin Islands, and Jamaica, as you highlighted about Jamaica Center for International Arbitration, Jamaica International Arbitration Center, whether it is in the 1993 or during 1996 or during 2017. All these development, whether these development had any significant impact on TNT to come with this 2023 amendment. Additionally, to what extent this particular law or the legal reform happened in TNT has taken it forward for parties, not only in domestic front, but in international front, opting TNT to be a effective seat for arbitration. What is your view on these two?
Okay. I think very good questions. The first I would say is that I think we needed, sometimes it's the leadership, and our Attorney General in 2023 was a senior counsel who I think was very much involved in private practice in arbitration. And so he would have, a lot of the major practitioners in Trinidad and Tobago, they practice throughout the region. They practice in other jurisdictions. And he may have seen now, I didn't mention these countries because both Bermuda, U.S. Virgin Islands, they do have their laws are based on the ancestral model law as well too. So they would have preceded Trinidad and Tobago in 2023. And in fact, I think it was a major, I don't know if it was not getting investment, but I think when investors have to tick the boxes, they would realize that, hey, Trinidad and Tobago has not ratified Trinidad and Tobago, even though we have that ancestral model law, which is really the model law on arbitration. We have not done that yet. And Trinidad and Tobago, all this training we are doing, and and I think he would have identified that. And that I think gave it the impetus to go ahead with it. And so that was what the idea was. So he would have been looking at other countries, and I think, but it would have been his leadership as Attorney General, and as a practitioner who would have worked in arbitration, and probably worked in jurisdictions that had already adopted the modern legislation. So he saw the need for Trinidad and Tobago to have that. In terms of your second question, well, the idea is for Trinidad and Tobago to become this seat. There is no big evidence of that yet. But what I would say is that investors who are ticking the boxes would look at the fact that Trinidad and Tobago offers a lot of advantages compared to the rest of the region, at least in my view. Other colleagues mightn't think so, but I think that our location is very convenient for that. We have a very large profession as well too, and we have these structures in place where there have been a lot of training already taking place in terms of the Dispute Resolution Center as well as the Law Association of Trinidad and Tobago. Now, we haven't developed like that nice name like how Jamaica has, the Jamaica Arbitration Center, but I figure these are in the works, and once we get the drive to do it, I think that we will establish formal things like that, even though we believe that the systems that we have could deal effectively with arbitration.
Yeah, so nice, Mr. Biven, for the clarification and honest views and opinion as a lawyer, looking into why the 2023 Act was brought in, the reason behind, and the other components.
Yes.
One more with subject to you're not disturbing your sleep. Wonderful.
No.
I also happened to understand in one of the case recently opinion what I gave. There was one opt-in, opt-out provisions in the 2023 Act, which eventually distinguishes the domestic and international arbitration by providing different default rules. One such, what I could see, certain provisions relating to ordering or granting or refusing interim measures or recognitions and enforcement of award only applicable to arbitration with the place of arbitration outside Trinidad and Tobago. I think, if I am not wrong, Section 4 of the 2023 Act. I look into this as a distinction which might potentially lead to difficulties when determining the applicable rules in a specific arbitration. What is your say on this?
Well, you see, that's sometimes, because I saw it too, and I'm glad an expert like you has identified that. But I think that one of the legislation was actually, before it was passed, was sent to UNCITRAL. And UNCITRAL did indicate that the legislation is in line with their thinking, with the law. So it's not it's why I would say it's based on the law, the UNCITRAL model law, but it's not the UNCITRAL model law, because certain modifications have been done with it. And what I would say is that the issue what you identified there, we'll have to see in practice how that operates, because the law is only 2023. I think that the law is not being applied I think that the case I mentioned there, the OS NIPTEC case, NIPCO case, it's very important to hear what the Court of Appeal says about the enforcement of that judgment, because it's quite clear that certain judgments aren't being enforced for public policy considerations and things like that. But even though that case predates this model law, I still think it will guide the court in terms of the practicality of some of the provisions, such as that Section 4, and how, in fact, if that could really hinge the proper application of the law. But so I think it's a work in progress, and we will need to see a court probably making some ruling or interpretation based on that, because it really could lead to some problems if in fact this interim thing, opt-out thing, if that is something that really could create some practical unworkability. And one of the things I say, what happens with that is when an investor comes in and once the dispute settled, and if they see something like that holding back out, they will in fact raise the issue. And plenty of these investors who we're talking about are large multinationals. Like in the oil and gas sector, it will be BP or Shell or one of these companies as well too. So they will want to ensure, and if they find issues with that, bet your bottom dollar, that's a saying in Trinidad and Tobago, they will bring that to the attention of the various policymakers.
Oh, thank you, Bivan. I hope you'll be a fellow in the coming period in the Chartered Institute of Arbitrators. But overall, what we can understand from this, your wonderful presentation, is that even though the Act is largely adhering to the model of framework, this Act represents a significant milestone in modernizing the arbitration landscape in this, what we, the Global South countries look into Trinidad and Tobago as a twin island state. Hope I am right on the term, what I'm using.
Yes.
This introduction or the introducing provisions like strengthening judicial respect for the arbitration agreement or the clause, enhancing the role of courts in supporting the arbitrations. It's a very unique phenomenon, because normally we see less court intervention. But here, what we can use is that the enhancing the role of courts in supporting arbitration. It's good. And anyway, the streamlining the enforcement of award, the Act which brings TNT. We always think about TNT when it comes to cricket, and a very, very popular destination wherein India was the first country to just break that monopoly of cricket from West Indies after getting the
1983. I remember that very well.
Yeah.
It was in fact a very strange day, because I remember I was 8 years old on that day in June of 1983, and I cried, and my father and grandmother were very happy.
Yeah.
So that speaks to them still being very much part of the diaspora.
Yes.
And in fact, my father's greatest moment, most memorable moment, was in 1970, when he took a train to watch a test match where Sunil Gavaskar had made 2 centuries. So that was in fact one of his childhood heroes. And just another side, my uncle, he's a writer, has written a book about Sunil Gavaskar. And yeah, Clifford Narayan Singh. He has written a book, and I met Sunil, well, Mr. Gavaskar, on a few occasions. So he's a family friend. And 1983 was in fact a very great day for my father. It was not a great day for me.
Anyway,
Still love West Indies. I support West Indies throughout. Sorry, even we played India.
It's interesting. It's interesting.
Yes.
As a later comment, even sports disputes are now being arbitrated. The Court of Arbitration Sports and all the Olympic Association and federations we do have. And anyway, as a add-on, hope I was also on the same age in 1983. 1970 was the first World Cup where the West Indies won. I was just born. I'm now exactly 50 year today, May 23rd, 1975. I was born. A very happy moment. And with this momentum, our relationship should start. And Trinidad and Tobago and the Caribbean community as such, with the institutions other in the Global South, we all have to align ourselves and just make this, whatever the efforts made by the sovereign states when it comes to arbitration laws, we have to make it in line with the best international practice and hope this model law would be structured the way how it was expected. Thank you. Thank you, Mr. Bivan, for spending your valuable time from Peru. Thank you.
Okay, great. Take care. Thank you very much.
So for our next speaker, we are privileged to welcome Ms. Begum, an international arbitrator, technological entrepreneur, and a leading voice at the intersection of law and artificial intelligence. She currently serves as CEO of Business Soft and iGlobe, pioneering digital transformation and legal tech innovation across Central Asia. Ms. Begum holds appointments as an arbitrator with several prestigious institutions, including LCIA, SEC Arbitration Institute, and arbitration courts across Central Asia. Her multifaceted expertise in ADR, technology, and cross-border dispute resolution makes her a truly global thought leader. We invite Ms. Begum to share her insights on the ADR landscape in Kyrgyzstan and enrich today's discussions. I now hand over the floor to you, ma'am.
Dear ladies and gentlemen, thank you for the kind invitation. It's a pleasure and honor for me to take part in this insightful event, and I specialize in the intersection of law and technology with a focus on legal tech, cybersecurity, and ethical AI. Implementation in alternative dispute resolution. Today, I will be sharing my perspective on a vital and timely topic, data privacy and cybersecurity in AI-driven ADR. As we automate dispute resolution processes and increasingly rely on AI, we must remember that data is the new currency, and with data comes great responsibility. Why data privacy and cybersecurity matter in AI ADR? Nowadays, ADR inherently involves sensitive data. This includes confidential contracts, trade secrets, and communications between parties, and even personal data. AI systems
Extremely sorry to disturb in between, ma'am, but if in case you are presenting your slides, I just wanted to inform that the same is not visible. It's just the taskbar that is being visible, like the 10 slides. The slide that you're presenting is not visible. If you want, we would be more than happy to facilitate it from our end, where we could, like present it for you.
Oh. Could you please repeat? Is it for me?
Yes, ma'am, it is for you, ma'am. If in case you are presenting your slide, sharing your screen, the slide that you're currently presenting is not visible. It's just the taskbar that's visible, ma'am.
Okay.
We would be more than happy to facilitate it from our end by sharing the screen from our end.
Okay. And maybe later I will resend my presentation.
Sure. No, ma'am, it's already there with us.
Okay. And AI systems are now used to process this information, analyze contracts, extract patterns, draft predictions, and where is this data stored? Often it is stored in the cloud or on external platforms, sometimes managed by third-party providers. And this creates risks. What if the data is hacked, leaked, or misused? And let me illustrate with a few examples. In 2023, a data breach affecting the ODR platform used by multiple chambers of commerce in Asia exposed confidential records from over 200 arbitration proceedings. This incident raised urgent questions on accountability and vendor trust. In China, a cloud-based arbitration court used AI to process legacy case files. AI models were trained to read and anonymize documents, cutting human workload by 90%. However, this demanded very strict controls on data access and anonymization. And also GEMS, a global dispute resolution provider, introduced specific arbitration rules for AI-related disputes, including provisions for protecting sensitive data via expert supervised review. And Columbia Law's Arbitration Journal analyzed how AI-driven tools in arbitration are capable of legal prediction and document automation, and yet require strong ethical standards to ensure data security. We've already seen examples of deepfake technologies being used to spread disinformation. The legal field is not immune to such risks, especially when AI is integrated without safeguards. And about another side, legal and ethical uncertainties. The reality is that there are currently no unified global standards for protecting data in AI-based ADR platforms. This creates ambiguity, particularly in cross-border disputes where legal systems differ. And what about liability? Who is liable if there is a breach? Arbitrator, AI developer, or platform provider? And without clear regulation and ethical guidelines, we risk exposing sensitive legal processes to serious vulnerabilities. And we must also understand that many AI tools are built on data sets that are opaque and difficult to audit. And when platforms host sensitive information without clear governance, the door is open to cyber attacks or regulatory violations. And another concern is the use of public data or surveillance-based data sets in AI training, which can be resulted in the unintended bias or discrimination during automated arbitration steps. And ethical frameworks such as the European Union's General Data Protection Regulation and emerging acts like the European Union AI Act are beginning to address this, but adoption is uneven. Practical recommendations from my side that so what we can do. I share 5 practical and actionable steps. First, conduct thorough risk assessments before implementing any AI solution in ADR and understand who handles the data, what data is involved, and how it is processed. And ensure encryption and data integrity by using end-to-end encrypted channels for communications and cloud storage, especially during online hearings. And also adopt ethical and legal AI models, and also require transparency and oversight for high-risk models. This approach is recommended on the procedure. Apply the principle of data minimization. Only collect data that is necessary for the dispute. Avoid overreliance on biometric location-based identifiers. Engage dedicated cybersecurity advisors or officers to review platforms and workflows in AI-assisted arbitration. And looking ahead, what institutions can do. Nowadays, international arbitration institutions like SIAC, ICC, and FIAC are now reviewing their protocols to integrate AI ethics and cybersecurity clauses. As members of the global ADR community, we should advocate for regional cooperation and the development of shared audit standards for AI in dispute resolution. Respecting data means respecting trust, and in ADR, trust is everything. AI may improve efficiency, but it should never replace human judgment or ethical oversight. And I think that be proactive, conduct compliance checks on the tools and platforms you use. Never outsource decisions blindly to algorithms, especially without transparency. And to conclude, I believe that AI can help us solve disputes faster and more efficiently. But it is our duty to ensure that technology works for justice, not against it. We are not against new technologies. We are for responsible innovation. And as I'm a resident of the Central Asian Association for Artificial Intelligence, I would like to recommend use AI tools for daily works and to foster our working processes. But we should be more attentive and more responsible for using and working with different kinds of instruments for our workflow. Thank you for your attention. And I would like to share my best wishes and thank you for invitation.
Thank you, Ms. Begum. It was a really wonderful insight on how AI is going to look into this particular ADR platform. At this juncture, I, on behalf of KFCRI, before sharing the thanks note, I wanted to just supplement what ma'am you have just mentioned about the very significant thing. AI should not replace, but AI is going to facilitate the dispute resolution. Yes. Yeah, that is very, very important point. Why I look upon is that coming from a country, Kyrgyzstan, it's a Central Asian country, as a information to many people, audience and practitioners. Historically, this particular country for a long period happened to be part of the Soviet Union. And it is now one among the CIS countries after the 1991 breakaway of the Soviet Union bloc. Kyrgyzstan, which is identified as Kyrgyz Republic, is one of the least studied in Central Asia. As a history student, many would be happy about Genghis Khan, who had a great time administering that particular region for a longer period, and his descendant also has just had the same say. But what is significant, in addition to the technological impact in Kyrgyzstan, particularly for ADR, which is across the globe on ODR, also online dispute resolution, we do have the prominent aspects of dealing with these disputes. As a supplement to Ms. Begum, what we can see is that one of the very interesting book about law and practice of international arbitration in the CIS region, it is somewhat wholly neglecting some countries while giving sufficient attentions to the other, the former Soviet republics, such as the very prominent one of Russia, Ukraine, Kazakhstan, and other states in Commonwealth independence. When you look on the Central Asia, beyond Kazakhstan, there are countries like Kyrgyzstan, Uzbekistan, Tajikistan, Turkmenistan, Azerbaijan, Armenia, Georgia. All these independent states are somehow happening to be neighbors contributing, particularly the arbitration arena. Here, the research done by KFCRI and the team found that the legal foundation of Kyrgyzstan, particularly the arbitration regime in Kyrgyzstan has been literally inherited from the Soviet Union. The USSR arbitration, wherein as private dispute settlement mechanism, which was based on consent of the parties, which happened to be alternative to state judicial system, was limited. But still, when we look on the Soviet Union constitutional articles for Kyrgyz Soviet Socialist Republic in 1978, it guaranteed the citizens of Kyrgyz Republic to settle commercial disputes between enterprises, institutions, as well as organization, but through state-run arbitration courts. The arbitration institutions were identified as arbitration courts, and all these arbitration courts were operated by the sovereign state itself. The system of arbitration courts, which happened to be an integral part of the judicial system. That is a very interesting thing when KFCRI and the team had a good research, particularly the research done by Mr. Sipi Wist, Ms. Soundarya, Ms. Sakti Priya, Mr. Pranav, Mr. Devdattan, Mr. Kirti Vasan, and other prominent founding members of KFCRI. All the outcome ultimately found that it is all a constitutional right which has been given in the Kyrgyz jurisdiction. It also runs through several of these articles. There was another interesting article also for the good information for the Global South countries and the institutions, as well as Global North institutions who are going to share their success story here. This jurisdiction of Kyrgyz Republic, the arbitration clause, which was recommended in a chapter of the article itself, it quotes, for extrajudicial settlement of disputes arising from civil legal relations, citizens of Kyrgyz Republic are entitled to establish arbitration courts. Full stop. The order of establishment and functioning of arbitration courts shall be determined by law. It's a very unique clause, what we found. And this clearly gives the parties the right, when dealing with civil disputes, particularly emanating from a legal relationship, to establish arbitration courts. They are not mentioning about what the present day rule of law recommends about constituting arbitral tribunal. Here it is the parties creating the arbitration court. It's a very masterpiece, we can say, of promoting arbitration. But this, after the later stage, when the breakaway of the Soviet Union, however, had a different perspective. There are a lot of change happened. We, as the Global South countries, now looking into Kyrgyzstan, we are of the opinion that further development of arbitration in Kyrgyzstan should not be in expanding competencies of arbitral tribunal, which beyond the inherent functions they were designed for or contrary to the constitutional provision. It's a wonderful piece. The development, what's going to happen, I think the note given by the Ministry of Economy of Kyrgyzstan also had a comparative study wherein the existing mechanism, the new one which is likely to be brought in, is going to be quick. Why? Because it will allow disputes to be settled with recourse to a single legal authority with no possibility of appealing the decision. No doubt, like an ancestral model law, the development, the reforms, what's happening, it makes that Kyrgyzstan's arbitration would be more efficient, confidential, and will allow choice of applicable law, including place and language of the proceedings. All taken from the Article 7 of the Unsettled Model Law for International Commercial Arbitration. It is also going to expand arbitrable disputes arising from states' exercise of its administrative functions, even stretching to the level of tax and customs. Some developments which are happening, but still it should not be contrary to the constitutional provisions which has been well structured much earlier itself. Next step ahead should be in a global south perspective, looking into Kyrgyzstan, even though it's a less studied jurisdiction or a country. The focus has to be on improving the cooperation between the judicial and the arbitration institutions or bodies. For the information to the participants, panelists, Ms. Begum was happy to share that the arbitration court, even now, which is titled as such, is the prominent arbitration body that is called the International Arbitration Court, attached to the Kyrgyz Chamber of Commerce and Industry. It is the arbitral body where the solution would be given for the parties in a one-stop manner. One way to achieve this, anyway, this would be to analyze the judicial practice, how the courts, as well as how Ms. Begum was mentioning about the AI's role. AI also is very, very rapidly developing. Not only all the global south jurisdiction, Kyrgyzstan is one good example wherein there are abundant number of associations, as rightly pointed out in the last slide of Ms. Begum, particularly on the recommendation what she gave. It is going to support the arbitral bodies and thereafter providing trainings for judges based on the best international practice would give a proper clarifications of the disputes which emanates in that particular jurisdiction. As concluding remarks, hope I have not penetrated too much into the presentation of Ms. Begum on the AI part of Kyrgyzstan. As a better understanding from a legal practitioner's perspective, Kyrgyzstan, from its establishment, I think, if I'm not wrong, from 1993 to present day, the institutions of arbitration in Kyrgyzstan has gone through many changes. It has developed from being part of a judicial system into an institution of civil self-governance. That's what we look into from the Global South. However, the proposed changes by Kyrgyzstan government not only clashes the judicial system of the country based on the constitutional provisions, as well as with arbitration, but also creates a high degree of certainty to some extent as far the institutional identity of the Institute of Arbitration in Kyrgyzstan. These are some points what I could derive from the AI tool which has been facilitated by Ms. Begum. Thank you, Ms. Begum, for spending your valuable time
Thank you.
sharing about AI in arbitration, particularly focusing Kyrgyzstan. Thank you.
Thank you.
Ms. Dilba, we have a couple of minutes. We have some formalities to be done, and we can start in 3 minutes.
Sure.
At this point, we are very happy that this particular event is happening because of multiple global partners or collaborators in the form of knowledge partners, venue partners, and media partners. And we have to take this time to thank each and every one for sharing their the valuable partnership for us. And so that whatever the objective of this particular event, which is just the first edition, and this edition is going to take forward multiple other new alliances, consortiums, as well as collaborations or groups, particularly from the global South countries, which eventually would be coexisting with the global North institutions, which are doing wonders. If you can see the speakers, the successful speakers who are going to come down for another 1 hour, are coming from the global North jurisdictions, where the success story which would be shared by all of them, so that this success story is going to facilitate the global South jurisdictions initially by their partnership, and this is going to be long-standing collaborations. And we are, once again, I'm taking this opportunity to thank, depending upon the time zone, whether it is going to be the early morning. I think Dilba has been disturbed morning hours to come and share her points. But interestingly, it is the community, the arbitration community across the globe, who are there to provide the essential services which are expected by the parties. That's very important. Whether the parties are individuals or entities or MNCs or the sovereign states, we are there. And particularly institutions like KFCRI, institutions like SICI Center for ADR, other institution knowledge partners, including the prominent one of Arbitration Institute of SEC, the Swedish Arbitration Association, and many, many institutions, including Chartered Institute of Arbitrators, all the global South institutions which have supported us till now and in future and present also. We are grateful to all of them. And I think now the time has reached so that I will share the platform to my colleagues so that we can start with the success stories.
All right, moving on to the global North, we would very happy to welcome Ms. Dilba Devitri, accomplished international arbitration lawyer, currently practicing as an associate at Hamburger in Switzerland. A French qualified lawyer of Indian nationality, Ms. Devitri specializes both in commercial and investment arbitration and has served as a secretary to arbitral tribunals in numerous high-stake proceedings. She advises clients under major institutional frameworks, including ICC, UNCITRAL, and Swiss Chambers Arbitration Institution rules. With academic credentials from the University of Paris, Pantheon-Sorbonne, Sciences Po Paris, and Columbia Law School, she brings a rich blend of global legal insights. We are honored to welcome Ms. Dilba Devitri to share her perspective on the ADR landscape in Switzerland and to contribute to the depth of today's discussion. It's over to you.
Thank you so much. I had shared a presentation. Perfect. It's on the screen. Everyone can see it. So good morning, everybody. As Inbavijayan just said, it's very early here in Switzerland, but it's still a pleasure to start this day with all of you. I'm just going to give you a broad overview of arbitration in Switzerland, and I was asked to share, as mentioned earlier, sort of the success story and what lessons can be learned. But I just want to say right from the outset that I'm happy to share the landscape about arbitration in Switzerland, but I don't think that we can take any one country's success story and apply it per se to another country. So we would discuss, and we have to see what fits within the context of the global north and the global south is being discussed within this conference. But before we get into those discussions, let's just look at what's happened in Switzerland and why Switzerland is where it is today and why it is such a popular choice of as an arbitration destination and otherwise. So I just started off this presentation with a few statistics just to show you where Switzerland lies today in the arbitration landscape. Most of these statistics are based on the statistics that have been published by the ICC and the Swiss Arbitration Center. As you can see, Switzerland has consistently been, my chart starts in 2005, but I think it also predates this, consistently been one of the top choices as a seat for arbitration. So Switzerland is the big red line there. You see that, just seems to follow the global trend, but always been amongst the top 5 choices. Same if we move to the next slide for Swiss law, which is one of the most commonly applicable civil law choices in international arbitration cases. And we look a bit later why. But Swiss law is also very consistently chosen by parties as the applicable law to their proceedings. Swiss arbitrators also have seemed to enjoy a lot of popularity. If we go to the next slide, they're always amongst 3 top nationalities, again, as per the statistics of the ICC. So the question really, I guess, that we are going to look at today in this presentation is why? What makes Switzerland such a popular choice in all these aspects? To begin with, I think, if we move to the next slide, I'm not here to give any geographical lessons, but everybody knows that Switzerland is found in the heart of Europe. It's at the crossroads of Europe. It is not a part of the EU, which also gives it a unique legal distinction from EU states. For example, I'm sure a lot of you all have heard about the recent EU decisions, particularly investment arbitration, like Achmea and Fomstroy, etc., which seem to put into question the validity of investment arbitration clauses in intra-EU PITs. For example, those sort of considerations would not apply if an arbitration was seated in Switzerland, because Switzerland is not in the EU. And at the same time, it benefits from very favorable bilateral treaties with the EU. It is party to numerous international conventions, of course, the New York Convention, a lot of other conventions, all the conventions on international arbitration. So it's got this unique position within, geographically situated within the EU, but not part of the European Union legally. And one of the reasons, one of the real fundamental pillars of Swiss arbitration law, and I think a huge reason of why Switzerland is so popular and such a sought after arbitration destination, lies in the core of Swiss arbitration law, which is the Swiss International Arbitration Law, which is the equivalent, I'd say, of the 1996 Indian Arbitration Act. This is the act that sets out the basis and the fundamental principles of arbitration in Switzerland. And if you look at this act, the first thing that would strike you about this act is its brevity. The Swiss Private International Law, actually, it's only Chapter 12 of this act that deals with arbitration. And Chapter 12 of this, or international arbitration, I should say. Chapter 12 of this act is only, up to 2021, it was only 18 articles. That is it. That's it. It like fits into 2 pages of a PDF. The center of this entire act is party autonomy. So if you read the act, almost every sentence would start with, unless the parties have otherwise agreed, blah, blah, blah. So it's just default rules in the absence of another agreement by the parties. So party autonomy is hugely important to arbitration in Switzerland. It forms the basis of this. Of course, at the same time, you have all the other common, generally applicable principles of arbitration. You have competence, which is very strictly applied, but the tribunal will be the first one to decide on its own competence, except in exceptional circumstances, of course, where, for example, a party invokes the complete invalidity or absence of an arbitration clause. Broad arbitrability applications. So any private dispute, including involving a financial dispute, can be resolved by arbitration in Switzerland. In a recent amendment to the Swiss Arbitration Act, which happened in 2021, which I will speak a little bit about, now even validity of arbitration clauses found in unilateral legal documents like wills or trust documents or bylaws of companies, etc., are valid under Swiss law. So this also extends the scope of arbitrability of disputes in Switzerland. Strong protection, of course, of due process, right to be heard, and equal treatment of the parties, which really form the most extensive, I would say, framework within which any arbitration has to be conducted. Those are the outer limits, and within those outer limits, the parties are entirely free to conduct and decide on their arbitration proceedings as they wish. Something else we'll also talk about more is there is very, very minimal intervention by the courts, also during the arbitration proceedings, but at the review stage as well. All arbitration annulment proceedings are made directly to the Swiss Federal Tribunal, which is only one court. There are no several instances of appeal against an arbitral award in Switzerland, and we will see how that significantly expedites the annulment process. As I mentioned, there was a very light review of this Private International Law Act that was undertaken in 2021. And the only reason this was done, actually, or not only, but one of the reasons it was done is to make this act more readable and accessible to foreign arbitration practitioners. So all the case law that had evolved over the years, which was, of course, found in the case law, was then put specifically into the Act in 2021. So it became more clear to foreign arbitration practitioners who may have not been so well versed with the jurisprudence of the Swiss Federal Tribunal on the rules applicable to international arbitration in Switzerland. So one feature that was added during this 2021 amendment is also now the ability to make challenges to the Swiss Federal Supreme Court in English. So earlier it had to be in one of the local Swiss languages, which is the four official Swiss languages. Now this can also be done in English, which is a huge benefit to foreign arbitration practitioners who can draft the appeal proceedings in English. So, just to summarize, as I said, this extremely pro-arbitration friendly stance of Switzerland is found in 18 or now 21 articles of the Private International Law. Compare that to the amount of articles you have in the Indian Arbitration Act, IMCITRAL, even the Model Law, or the English Arbitration Act. I think, this is also something that's very Swiss, the brevity and being able to put in the essence of what is needed into a very brief document. Just quickly again, the next slide, as I already mentioned, we can get the full slide on the screen if you could just click again to get the other, all of them. As I already mentioned, one key feature of arbitration in Switzerland, if the seat is in Switzerland, annulment proceedings will be made directly to the Swiss Federal Tribunal. You don't have to go to the district courts. You don't have to then go to the appellate court. You go straight. There's only one instance for setting aside proceedings directly to the Swiss Federal Tribunal. The Swiss Federal Tribunal is very pro-arbitration, but at the same time, it's a very, very good balance between pro-arbitration and reasoned, sensible decisions, also preserving the integrity and efficiency of arbitration. So as I said, always within the framework of due process, equal treatment, right to be heard of the parties. Within this framework, there are very low chances of getting an award annulled in Switzerland. As I put on the screen here, up to date, if you analyze, about 7% chances of successful annulments, and those were really egregious cases where everyone agreed that the award did need to be annulled. So a very good system of checks and balances while preserving party autonomy and efficiency of arbitral awards. The median duration of proceedings before the Swiss Federal Tribunal is 6 months. So you have your arbitral award. Let's say one party loses and wants to take it to the Swiss Federal Tribunal, a decision which again is never made likely, at least when these proceedings come to us. We clearly inform the client of the chances of success because they're so low. You really need a good cause to annul a decision. Within 6 months or so, average, some cases take longer, maximum maybe a year, you have a decision on your annulment. So you're not spending another 5 years on your annulment proceedings after your entire arbitration process. I think that's yeah. So to conclude, I've spoken about the Arbitration Act, I've spoken about how proceedings are conducted in Switzerland. Just to give a summary of all of this, based on my experience, arbitration proceedings in Switzerland are really a good blend, or take sort of the best traditions from both the civil law and the common law jurisdictions. You can tailor your proceedings to the needs and expectations of the parties. Depends entirely. The parties are in the driving seat along with the arbitral tribunal if the parties do not agree. The proceedings tend to be more front-loaded civil style proceedings which follow a strict procedural timetable. So right at the outset, you have a procedural timetable that is set. The tribunal sticks to it, the party sticks to it, unless there's some exceptional circumstances that arise. So you also have a good idea of when your proceedings will end, when your arbitration is scheduled to end. Contrary to sometimes what I've seen happen in India, there are no phases or, let's have an award on this part. I mean, of course, proceedings can be bifurcated, but again, there the bifurcations are very clearly set out. But you tend to have one final hearing, evidentiary hearing on the entire proceedings, following which within 3 or 6 months, depending on the arbitral rules, the tribunal will render an award. So it's not a long, drawn-out process and can, extend over years without any clear end in sight. We do have, of course, witness statements and cross-examination, which comes from a bit more from the common law jurisdiction side, but in Switzerland it tends to be a bit limited and much shorter. The rule tends to be, at least the way the practice, I don't know if I could say the rule, but the practice tends to be reliance more on written documentation supplemented by witness evidence if needed. There is document production as well. Of course, that's built into the arbitration timetable, but it's also not the extensive US-style discovery of any and all documents, even remotely relating to something. Swiss arbitrators and arbitrations in Switzerland generally tend to follow the IBA guidelines, and you really have to show the relevance and the materiality of the documents you are requesting. They have to be limited, they have to be well defined, they have to be a subset or a category of documents as well if you want to define it. So there are limitations on the document request process as well that apply. Switzerland is, as you know, very mediation and negotiation friendly. So mediation is encouraged. It's encouraged in the Swiss court system for sure, and I think that has also infiltrated the arbitration system a bit. At any point in time, if the parties so wish, they can stop the arbitration proceedings, even ask the arbitral tribunal to conduct mediation proceedings and try and amicably settle their dispute. And if that fails, then get back into arbitration. So it's a very flexible process between mediation and arbitration. And generally, as I said, this tends to be, short evidentiary hearings focused really on the issues that are still in dispute after the entire written phase of the arbitration has concluded. The idea is really to present evidence on what could not have been presented with written documentation, or to clarify written documentation if that is needed. So just to go to the next slide, just to give you an overview of institutional rules that we have. Sorry, no, the slide before it was on the Swiss rules of international arbitration. We have. So can we move to the previous slide, please? Thank you so much. So we have institutional rules in Switzerland. The ICC is present for sure. We have ICC Switzerland. We also have the Swiss rules of international arbitration of the Swiss Arbitration Center, which are sort of the homegrown. It's a homegrown institution with the homegrown arbitration rules. Again, very competitive rules for cost efficiency, very efficient, very light-touched. A light administration of the arbitration proceedings. So the institution is there, but again does not intervene per se in the arbitration proceedings. Extremely cost efficient. There's a supervision of the International Arbitration Court, which is the court of the Swiss Arbitration Center, that supervises the proceedings and intervenes if needed. For example, if the parties fail to appoint their arbitrators or the arbitral tribunal, etc. But otherwise, no intervention. And the Swiss arbitration rules also have the most common features that you see in other rules, such as expedited procedures with an opt-out option if needed. Ex parte interim relief, which now would go before an emergency arbitrator if needed. The Swiss arbitration rules generally, and arbitration in Switzerland generally, tend to follow the principle of the losers pay. So if you win in your arbitration, you tend to recover your costs, both your legal fees and all the institutional fees. It's the loser that pays for the arbitration. Of course, this principle is applied, depending on the circumstances of the case. Sometimes the tribunal may split it if they deem that the circumstances so require, or if the procedural conduct of one of the parties was not optimal or in bad faith, then they could take these considerations into account when determining the costs of the arbitration. And I mentioned earlier as well, very easy to combine with other ADR methods such as mediation, etc. My last few words that I wanted to spend on was on Swiss contract law, which we very often see combined with Swiss arbitration. So you would have SEAT in Switzerland, Swiss applicable law, very, very common in a lot of the international contracts that we see, particularly, trading contracts, banking contracts. Swiss law is a very pragmatic law, commercial law, if I can say so. You find, so all the codes or Swiss codes, so whether it's the civil code, the code of obligations, which is mostly the one applicable, all of them are found in English on the internet. The official translations are, sorry, I should not say official translations. There are translations. English is not an official language of the Swiss Confederation. There are only 4 official languages, but all these codes are translated in their entirety on the internet, and that makes Swiss law extremely accessible also to sort of non-German or French or Italian speakers. A very pragmatic law, very commercially minded law. The Swiss law solutions generally tend to, again, favor commercial reasonableness, at least in commercial international arbitration disputes, like we see. So in my experience, not always, but very often Swiss law is chosen as the lex quasi, particularly if there is a connection to Switzerland or the seat of the arbitration is in Switzerland. And then last, I just wanted to speak quickly about other aspects. Sorry, if we just go to the next slide. Can we move to the next slide? Yeah, the next slide. Okay. Yeah, so, a summary of a bit of a summary of all the things that I've spoken about, a bit like the Swiss NAMI knife, the multi-purpose tool. You have a politically stable and a neutral jurisdiction like Switzerland that combines efficiently civil law and common law practices and tendencies. You have a very pragmatic contract law that could be applicable to your case. And at the same time, you have what we call Swiss Arbitration Hub, the Swiss Arbitration, the website, swissarbitration.org, where you find, in a nutshell, everything that I have spoken about and everything related to arbitration in Switzerland. This is the website of the Swiss Arbitration Center and the ASA, the Association Suisse de l'Arbitrage. If you visit this website, you'll find everything about the law and the rules, arbitration rules, etc., that I just spoke about, but also far more practical information about, conducting hearings in Switzerland, any information you need about how to find venues or court reporters. I mean, information from that to information about how arbitration proceedings are conducted in Switzerland. So this website is really sort of a one-stop shop for anything that you would need relating to arbitration in Switzerland. Under the ASA, the Swiss Arbitration Center, there are also two very, very interesting tools that I just want to mention over here since we are talking about arbitration in Switzerland. That is the Tribunal Secretary platform and the Toolbox. If you go to the website, you will see that the arbitration toolbox is a how should I say? It's a flow chart that summarizes the entire arbitration proceedings from start to finish and gives you practical information on every step of the arbitration that you could need. It's a practical tool that has to be interacted with, so I encourage a lot of you to go and see it. It's on the website of the Swiss Arbitration Center. And likewise, the Tribunal Secretary platform is a platform that has been recently launched for independent tribunal secretaries that want to connect with independent or other arbitrators or arbitrators that are looking for tribunal secretaries that have experience, etc. You can put your profile up there, and it's a connecting platform for arbitrators and tribunal secretaries. And the only last thing I would mention, and I request, since I'm running out of time a bit, I would request you to just go to slide 14, which is about the Asia chapter of Swiss arbitration, but that might interest a lot of people on this call. These are the things I just mentioned. Yeah, I just wanted to briefly mention the Asia chapter of the Swiss Arbitration Association. It's always very interested in dialogue and collaboration and meeting with parties in Asia. So please feel to reach out to any of the people mentioned on the slide or myself, and we're happy to discuss further. And that brings me to the end of my presentation. I think I'm just in time. So thank you very much for your attention. Thank you very much to the organizers for giving me this platform to speak about arbitration in Switzerland. I hope I've given you a sufficient overview, and I'm happy to take any questions that there may be.
Yeah, thank you, Dilba.
Can we just put the last slide on so it's
Yes, yes.
take it off? Yeah, that's fine. That's good.
Thank you, Dilba, for insight on the success story, what we have. Anyway, the slide is shared. Yes, just the earliest line. Yeah, Dilber, it is the final slide is shared. I think it's a very unique culture what we have to take from the Swiss arbitration. As rightly highlighted, it is a tool which every practitioners have to seriously take upon. And at this point, we from KFCRI wanted to mention that we are very much interested to have a collaboration, particularly on these ASA Asia chapter, depending upon the possibilities, and we can just take it forward. This is going to be a real success story, but as an interesting fact, we wanted to share that we in KFCRI, particularly strengthening young minds, law students, who as parties getting involved in arbitration as interns to start with. Even this particular GSADR Thirunal or the day is outcome of the research of the research associates and the interns of KFCRI. They did the work as interns. They got involved as tribunal secretaries, the erstwhile administrative secretaries, and they are also involving in cases where KFCRI is trying to act as appointing authority wherever possible. And the very objective of KFCRI, particularly if you can see the organizing committee people who eventually happened to be in the arbitration arena as a success story to begin with, as law students interning, then getting graduated, bar admission, getting involving as tribunal secretaries, later as counsel. Now they have started even acting as arbitrators. Quite a young age, they have been facilitated. And this happened to be because of the legislation, the institutions, and the perspective how people like us, who are the stakeholders in this particular arena, have to seriously look upon. Hope, Dilber, I think the points what you have highlighted, as expected, the success story and the bridge between North and South, we have reasonably reached that level. Particularly, we can see the good example of the kids. Eventually, they are kids, but they are experts now in arbitration. And these type of development should happen across the global South. Each and every country in the global South, and people like you taking the initiative to support institutions in global South in whatever possible manner, whether it's a training or whether it is the research platform or whether it is going to be the largest scale of institutional arbitration. Your support has to be the most welcome one from KFCRI. I think these are some valuable intakes what we felt from your presentation, and hope this also been carried to all the participants and registrants for this very interesting auspicious day, Thirunal, for us. Thank you, Dilber.
Thank you very much. Thank you very much for having me.
So for the next speakers of the day, we have Mr. Jake Lothar and Rolf from SEC Arbitration Institute. We're pleased to welcome Mr. Jake Lothar, representing the SEC Arbitration Institute, one of the world's most respected forum for international dispute resolution since 1917. Mr. Lothar, a specialist counsel at the SEC, brings a wealth of experience from his legal practice across Australia, Korea, Germany, and Sweden, with a strong background in dispute resolution. His expertise reflects the SEC's commitment to neutrality, innovation, and global engagement in arbitration. We cordially invite Ms. Jake Lothar to share the insights on the realm of ADR in Sweden and contribute to today's dialogue. Raul Sievers is a PhD candidate specializing in international arbitration at Humboldt University in Berlin. He is enrolled in the LLM program in International Commercial Arbitration Law at Stockholm University and serves as a visiting professional at the SEC. His academic work focuses on collective arbitration as well as on issues of arbitrability and public policy in arbitration proceedings. Prior to joining the SEC, Raul worked with the international arbitration team at Freshfields in Berlin and Frankfurt. Raul began his legal career at Brian Cave Lighton Pesner, where he worked as in the M&A restructuring team. Over to you, gentlemen.
Thank you very much for those kind introductions, and also to the organizers for this excellent event. We're very, very thrilled to be here. So good morning from Stockholm, and good afternoon, good evening, wherever you might be in your time zones. This is very exciting to be part of such a global event. If we go to the next slide, please, we can probably skip to slide 3, actually. I'm here and delighted to be able to talk about one of our favorite topics, which is the SEC Arbitration Institute. Exactly. So here we are in Stockholm. We are an independent part of the Stockholm Chamber of Commerce, which is a members-based organization, independent of the government, and there to act in the interests of its members. And we have, since 1917, provided a neutral platform and an impartial process for the resolution of disputes around the world. Now, the next point I have on my slide is in inverted commas, the world's most modern arbitration institute. We in Sweden try and be quite humble about this, and so we therefore put this in quotes rather than just saying it directly. But I dare to say that this is true, and we will talk a little bit about why in a second. Next slide, please. Yeah, so as an organization, you can see that for us, from up in the top of the map there in Sweden, we have an extraordinary global reach. And last year, we had parties hailing from all of the inhabited continents of the world coming to the SEC for dispute resolution services. So it's truly an impressive reach. We also had over 200 cases last year, and we are on track to have a similarly good year this year. We are very proud of the fact that it is a very international organization and an international caseload. And we are very pleased that parties from all around the world have entrusted us to administer their disputes, which is, of course, one of probably the worst times for a business to have to be engaged in. Next slide, please. So as I mentioned, the SEC was established in 1917. This was essentially based on the needs of the members of the time who needed a neutral forum outside of the courts for the resolution of their disputes. As you can imagine, in 1917, the disputes looked a little bit different to how they look today. And we have seen from that history disputes in relation to agricultural goods and commodities, and then moving up from horses to cars to green technology today. But what really made us so international, you might wonder? Well, during the Cold War, Stockholm was a bit of an outlier in a way. We were not entirely in the Western sphere. The Swedish position on the Vietnam War meant that there was no US ambassador to Sweden for some years in the 1970s. But Sweden was not behind the Iron Curtain either. So we were not in the Soviet sphere of influence in that respect either. So the two sides, when confronted with difficulties, were able to choose and decided to choose Stockholm as a neutral place for their dispute resolution. And in 1977, this was actually agreed, put into writing between the two sides in what is known as the optional clause agreement. This was then followed in China when the cooperation agreement with the China Council for Promotion of International Trade specifically referred to the SCC and Stockholm. And this position, in fact, led to what we will also talk about today, and that is Stockholm and the SCC's role in the arbitration and in the administration of investment disputes. So in a number of bilateral and multilateral investment agreements, they refer, in fact, in some way or form to Stockholm and the SCC. And since the early 1990s, the SCC has administered these disputes between investors and states. Next slide, please. Thank you. Yes. So as you can see, our modernness, if you will, it's really, I think you could go back to the mid-90s, staying in the 90s, when the SCC was among the first institutions to introduce an expedited procedure. One of the criticisms that isn't, in fact, terribly recent about arbitration is that at times it's not sufficiently efficient in terms of time or cost. And in response to these criticisms, even in the 90s, for those disputes that perhaps don't warrant a three-member tribunal, don't warrant the full proceeding, you could have an expedited procedure instead. And the SCC was one of the leading institutions in introducing this system. Under the SCC rules, and I will talk about that later, it's an opt-in. So the parties must choose from the beginning an expedited procedure. However, we have made available to the parties also a number of model clauses where they can choose essentially the best of both worlds, where you start as a default with the expedited rules, but then if the case so warrants, it can be moved to the arbitration rules instead. We were also one of the first major institutions to introduce an emergency arbitrator mechanism. So essentially where the parties prior to the referral of the case to an arbitral tribunal could obtain interim relief from an emergency arbitrator. Our modernity also extends into the actual case management. So we have a number of digital solutions. In fact, since 2013, we have essentially been entirely paperless, apart from two things. And that is the notification of the case to the respondent to ensure that they have every opportunity to take part in the case, but also the final award. Very important that we have this in writing, a physical copy as well. But all of the case management is also conducted online on the platforms that we offer. And it is not just restricted to SCC cases. We also have an ad hoc platform available to parties, whether to an ad hoc arbitration or to an arbitration under other rules. They can use our ad hoc platform for the administration of their case. And then if we go to the next slide, please. So this is an overview of the different rules at the SCC and the different services. And as you can see, the majority of our cases, which probably will not be surprising, are arbitrations under the arbitration rules. But a very large number, over a third, are under the expedited rules. So we can see a range of different cases in terms of size, complexity, value, being administered under the various different rules that we offer. Next slide, please. Last year, we administered cases with a total value of 13.5 billion euros. So to put this into context, I think the ICC, how much was that actually? Now that I've mentioned that one, I think SCIAC was about 14 billion USD.
And HKAC was right below.
Right. So this definitely puts us amongst the top arbitration institutions in the world. Next slide, please. And just to put this into the context of each of those cases, so that gives us an average amount in dispute of approximately 100 million euros for the arbitration rules, and then 672,000 for the expedited rules. So what we show with this is that the expedited rules are very much available to all parties, and the idea is to ensure the broadest access to justice possible for those perhaps smaller disputes that otherwise maybe would be priced out of going to arbitration. Next slide, please. Yes, for an overview of the actual cases and what kinds of disputes are coming to the SEC, as you can see, a lot of M&A disputes, over a quarter, and then we have delivery and transportation agreements, purchase agreements, and even employment agreements that are coming to the SEC. We would say that there is a trend of an increasing number of M&A disputes. I think last year was one of the highest number in recent years. But I think certainly since the pandemic, we've seen an increased amount of M&A activity, which does tend to result in a few additional disputes as well. Next slide, please. So one of our, in Stockholm, USPs, if you will, is our efficiency. So we are very proud of the fact that the majority of our cases are resolved within 12 months of the referral of the case to the arbitral tribunal. So over 60% of cases within 12 months under the arbitration rules. Next slide, please. And then almost 100% are resolved under the expedited rules within 6 months. Yes, thank you. Next slide. Why is Sweden preferred? Well, in addition to its neutrality, the Swedish courts are very pro-arbitration, very well respected. We have the Nordics have historically had one of the lowest levels of corruption in the world, which makes us, I suppose, an ideal neutral venue if you need to seek redress from the courts. They are, of course, well, maybe perhaps, of course, is no longer a given these days, but they remain an independent, it remains an independent judiciary. And of course, we dare to say that the fact that there is a renowned international arbitration institute in Stockholm gives a lot of parties comfort in coming to Stockholm as the seat of their arbitration, whether it's an SEC arbitration or an ad hoc. And as mentioned, we provide a very modern and digital service here, and Sweden is a very modern and digital economy. And this allows us to be quite quick and efficient. Also worth noting is when it comes to arbitration-related matters, the first instance in such cases is in general going to be the Court of Appeal. So you bypass what would ordinarily be the district court and can have a faster track to a final resolution if, for example, your award, there's an application to set aside. The statistics that we see is, of course, parties do try to set aside awards. And this is an important legal security, if you will. But in general, the success rate is incredibly low. I think, the cases challenged, approximately 6% are successful. And perhaps my colleague Hazibas will be talking about one of the reasons why some of those cases were set aside shortly. This takes me to the SEC and our position. Even though we are independent of the state has recognized the importance in Sweden of arbitration and our profession. So the Ministry for Foreign Affairs specifically refers to the SEC and international arbitration in its strategy for Sweden's foreign trade, investment, and global competitiveness. And according to some figures, arbitration in Sweden accounts for approximately 0.25% of our annual GDP. So it's a very important profession and field in Sweden. And next slide, please. So I mentioned the ISDS, or the investment arbitrations, and the Stockholm position as one of the leading fora for the resolution of ISDS disputes. So the trust that many parties, and including states, have put in Stockholm and the SEC is something we do not take for granted, and are very much, the word escapes me at this point, but it is something that we really do value very much, this role that we have been given in this particular field. And historically, the SEC has been the second largest institute for investment disputes. And we are also often acting as the appointing authority under the UNCITRAL arbitration rules in ad hoc cases. So, for example, if there is an application coming to us for an appointment of an arbitrator, or perhaps even to challenge an arbitrator, we are one of the appointing authorities often selected by the parties for these matters. Now, last count that there are 96 international investment agreements that actually refer, currently in force, that actually refer to the SEC or Stockholm. And this is somewhat lower than it used to be, and we'll also mention why that is shortly. And to date, we have had 129 ISDS cases. I think in the interest of time, if we could move now to discussing some of the recent developments in Sweden, which is from slide 24, please, then I will hand over the word to my colleague.
Thank you so much. Also, good morning from me, or good afternoon or good evening, wherever you may be. Yes, very pleased to be speaking here today. I will briefly just cover two recent developments we've seen in Sweden and Europe lately. The first one is what we refer to as the seat policy. As Jake has mentioned, the SEC is quite involved in ISDS. And we're also one of two institutions mentioned in the Energy Charter Treaty next to ICSID. And this has, in Europe at least, given rise to what we now refer to as the seat policy. I am not sure how much European law and the European arbitration scene is part of everyone's professional life on a daily basis. So I'll just briefly recap what happened in Comstroy and the CJU's decision in Comstroy. So essentially in Europe, what we have, the EU is founded on three fundamental treaties, and one of them is the Treaty on the Functioning of the European Union. And in this treaty, which is referred to as the TFEU, we have the so-called fundamental freedoms, which essentially protect exercises of commercial freedoms by individuals in certain cross-border EU commerce. So overly simplified, if I am a German distributor, I can sell a product with a certain packaging in Germany. These freedoms tell me I can, in principle, also sell the same product with the same packaging in France. And then if we go to the next slide, we have in Article 344 of the TFEU. Could we go to the next slide quickly? Thank you so much. We have a provision that essentially states that member states undertake not to submit a dispute concerning the interpretation or application of the treaties, so also of these fundamental freedoms, to any method of settlement other than those provided for therein. Now, there is a bit of dispute whether arbitration is provided for therein, but the majority opinion is that it's not. So essentially, the problem that we now have, if we have a relationship that concerns cross-border economic interests in the EU, this article tells us maybe these may not be submitted to arbitration. Now, if we look at the ECT, it will set out certain obligations and freedoms, such as fair and equitable treatment and so on. And these freedoms are quite close and quite similar, obviously, to what is protected by the TFEU. So if we go to the next slide, that was sort of the problem that the CJU then had, because there was a case that came from Paris to the CJU, where essentially the court asked, well, when you interpret provisions under the ECT, don't you really, in circumstances where you have two EU parties, don't you really interpret the TFEU as a tribunal, which would be in breach of Article 344? Now, I think the majority of the arbitration community said, no, actually, you're not interpreting the TFEU, but the ECT, because that's where the claim is brought. The CJU did not see it that way. They said you're interpreting the TFEU, and essentially in this decision in Comstroy thereby said this is in breach of Article 344, and so you cannot have ISDS essentially between in treaty-based arbitration between parties from the EU. Now, as mentioned, we are one of two institutions mentioned under the ECT, so we have a certain responsibility to ensure that the cases that come to us will be enforceable, or even before, will not be set aside at the seat. So what can we do? What we can do is we can say we see the issue, we see Comstroy, we see these decisions, and we will make sure that your award is enforceable. And we do that by setting the seat outside of the EU, so that the award will essentially not be set aside. And we've seen decisions from Switzerland, for example, which might be one of the seats where these cases will then be seated, that have rejected the decision and Comstroy and have said these awards are to be upheld. So this is something that works very well, and obviously this is something that we've done before. We released the seat policy in October last year. The seat policy was much more to clarify to the market that this is the practice of the SEC. That is the first current development, the seat policy. The second very current development is something that we just see unfolding now. We don't even have the decision of the CJEU yet. If we could go to the next, or maybe the slide even after that. And that is the case of Rival v. Stanko Import. That is a case that was referred to the CJEU for preliminary ruling, and that comes from Sweden originally, from the Svea Court of Appeal that Jake has just mentioned. Now, if we go one slide further, the factual background is quite quickly explained. As you all are aware, recently there are obviously a lot of sanctions against Russian parties under multiple sanctions regimes. And these sanctions regimes often cover things like exports that should not be granted to Russia, or payments that should not be made to Russian parties. And one of the provisions is Article 11 of Regulation 833/2014. That's one of the big sanctions regulation. And it essentially says you shall not satisfy any claims to a Russian party. Now, in this case, what happened was Rival was a Belgian party, Stanko Import is a Russian party. They concluded a supply contract, and Stanko Import, expecting delivery, made an advance payment of 2.6 million. Under the sanctions regime, the Belgian party was then not granted the export license, so could never export, could never perform. And Stanko Import then requested back their 2.6 million euros. This is obviously a bit on the edge, because you shall not satisfy any claims. On the other hand, it was only an advance payment for a performance that was ultimately not rendered. So Stanko Import went to a tribunal and actually got an award saying, yes, you will be getting these 2.6 million back. Rival appealed, or moved to set aside the award here in Stockholm. And the court, the Svea Court of Appeal, before even going into the thing itself, then asked, are these claims even arbitrable? Because we've seen that the closer we get to EU primary law, the closer we get to the treaties, the more likely it is that the CJEU will say, no, it's actually not arbitrable. This is something that should not be discussed by a tribunal. The second question they asked was, if these claims are arbitrable, are they covered by public policies? So will we have a full review of sanctions-related issues in the court proceedings? And these questions obviously go to the very core of what is sanctions-related arbitration currently in Europe, because if the CJEU says these claims are not even arbitrable, we will see a lot of case law obviously erupt also in Europe on these claims. So this is maybe a brief summary of two very recent developments. First, the seat policy, where we set the seat in intra-EU disputes outside of the EU to ensure the enforceability of the award. And the second one is something where we expect the ruling in spring 26 from the CJEU on the arbitrability and public policy dimension of sanctions-related claims. That would be it for me for now. Thank you so much.
Yes, thank you. And do please feel free to keep in touch or ask us questions also offline if you have any.
Yes, thank you, Jake. I think there is one question put here. I'll just read it out. Yeah, my colleague is there. Yes.
Yes, sir. I think one of the question the participant has asked is, I'm to understand that verbal contracts are binding in Sweden. Have you come across any dispute arising out of such a contract in your experience there?
It's an excellent question, and it is true that oral agreements are binding, and this extends also to arbitration agreements in a domestic arbitration. Of course, it wouldn't probably be in conformity purely orally under the New York Convention, but what then becomes the question, of course, is one of evidence. How do we demonstrate that there was indeed a verbal contract if one of the parties is disputing that it ever did occur? I haven't personally seen any such agreement coming to the SCC, although it's not to say that there aren't questions that are perhaps orally understood or interpretations that we do see in our cases as well, where one party perhaps had one particular understanding that the other didn't, and maybe there were oral discussions behind that. But again, it comes to an evidentiary question. At the SEC, what we do is, with administering the case, we make sure that as soon as possible, the case goes to an arbitrator or an arbitral tribunal. We don't take any material decisions in the cases, apart from, and even these are more the procedure. So, for example, the selection, the decision on the seat in the absence of party agreement. So for us, the more important thing is to get the party's matter as soon as possible to the decision maker, who can actually determine whether there was indeed a verbal contract.
Thank you, Jake, for the clarification about verbal contract. And takeaway, what I can see when the institutions were developing in the Global South, we were looking into SEC Institute as a center for East-West. It's a combination, a bridge between East and West, particularly the former the Eastern blocs were doing the arbitration, considering Sweden to be a neutral venue. And now the shift to a new interesting thing, seat policy, very, very interesting. And it is a valuable point to be taken by the institutions and the sovereign states, in particularly from the Global South. It is excellent for sharing these, Jake and your colleague researcher. And it's a very interesting point, and this should be a good beginning for Global South to take this and move forward with your continuous support.
Thank you very much, sir.
Thank you so much.
Thank you. At this point, I think I need to share some nuances, what we have as part of our founding members. Anyway, it's going to be shared here. It will be interesting for Jake also, because one of the founding members happened to be an alumni of Stockholm University Masters. You can see the interesting personalities who are behind the creation of this particular institute in quite a long years back, more than around 9 years. All happen to be people interested in arbitration. I happened to be a practitioner at that point of time. Mrs. Surya Narma was dealing with agriculture arbitration research. And interestingly, the three gentlemen and one gentlewoman happen to be lawyers who are now into different arenas of law. If you can see Mr. Shanmudev, he's leading tax lawyer. Mr. Swetan, an alumni of Stockholm University, who's now in the Linklaters doing his staff lawyership. Ms. Sri Nikila, who is a practicing lawyer and now an academician associated with the law school in India. And Mr. Shahrukh Kumar, who is into litigation, commercial litigation. A wide arena of tax lawyer, arbitration lawyer, academician, and litigating lawyer. All the four happen to be an actual background of creating this institute. And more interestingly, at this point of time, I need to share and I have to compliment their efforts, what they have done. And we are reaching to this level. And interestingly, this level is going to be the level which is going to see the 360 degrees of arbitration development. Thank you, Mr. Jake and your colleague. And the Stockholm obviously is facilitating one side the commercial arbitration as well as the investment arbitration through the another very prominent institution of Uppsala. These two are going to be a good takeaway for Global South jurisdictions, particularly arbitration institutions, practitioners, as well as academicians. Thank you, Mr. Jake.
So for the next speaker, we have with us Mr. Justice Priyanta Jayawardene. We are deeply honored to welcome Justice Priyanta Jayawardene, President's Counsel, a distinguished jurist with a remarkable career spanning over 3 decades. Having served as a judge of Supreme Courts of both Sri Lanka and Fiji, he brings unparalleled expertise in commercial law, arbitration, and judicial reform. Justice Jayawardene has held numerous influential roles, including state counsel, legal consultant, and academic, and was also instrumental in shaping key legislative frameworks such as Consumer Affairs Authority Act and the Electronic Transactions Act in Sri Lanka. Now, serving as an arbitrator, his continued contributions to the legal and ADR communities remain invaluable. We cordially invite Justice Jayawardene to share his insights on ADR landscape in Sri Lanka and grace this occasion with his presence. Over to you, sir.
Thank you very much. Good afternoon, everyone. I hope you all can hear me, right? Can you hear
Yes, sir,
me?
you are audible. Yes, sir.
Right. It is a great honor to address you today on dispute resolution. Before I commence my presentation, may I take this opportunity to thank Kovise Foundation Conflict Resolution, the organizing committee of the webinar, Sri Lanka National Arbitration Center, and its Chief Executive Officer for giving me this opportunity to address the webinar. As society becomes more connected and complex, the traditional means of resolving disputes have often struggled to keep pace with the demands of our digital age. Today, we will explore how alternative dispute resolution can be more efficient, accessible, and transparent in resolving disputes. Dispute resolution refers to the process of resolving conflicts between parties. And it comes in various forms, such as litigation, alternative dispute resolution mechanism, such as negotiation, mediation, conciliation, and arbitration. Negotiation is a simple form of dispute resolution, as it does not require the involvement of a third party, and the dispute can be resolved between parties among themselves. On the other hand, mediation is conducted by a mediator who facilitates the discussion between the parties in order to resolve their dispute. Conciliation, which is similar to a mediation, involves a counselor who enables the parties to reach a mutually agreed settlement. The difference between conciliation and mediation is that the conciliator provides solution for the dispute, whereas the mediator merely facilitates the parties to reach a settlement among themselves. Arbitration is a form of resolution in which the parties avoid court proceedings and instead decide to resolve their dispute by appointing a third party who is named as an arbitrator. In arbitration, the arbitration or the tribunal evaluates all the evidence presented by the parties and arrives at a decision called the award, which is binding on the parties. Traditionally, these procedures have been human-centric, requiring extensive manual labor and face-to-face interaction. Alternative dispute resolution is almost as old as civilization itself. Traditionally and historically, depending on the type of dispute and the parties involved, family elders, members of the community, or local leaders would often help resolve any issues or disputes. The formal recognition of the traditional alternative dispute resolution mechanisms by the modern legal systems can be traced back to British era legislations. It is same in India and also in Sri Lanka. We started the alternative dispute resolution arbitration provisions in the Civil Procedure Code. Actually, the Sri Lankan Civil Procedure Code is almost similar to the Indian Civil Procedure Code enacted at that time. Of course, now the Indian Civil Procedure Code has developed and changed. But we are still using the same Civil Procedure Code with certain amendments. However, in Sri Lanka, we have repealed the arbitration provisions in the Civil Procedure Code and introduced a new act in 1995. Advantages of alternative dispute resolution are faster, less expensive. Of course, now it's becoming more expensive and we need to come up with some kind of solution for that. But in Sri Lanka, certain institutions, arbitration institutions have come up with a fee structure so that the arbitrator is entitled to claim only that amount, even if the arbitration proceedings get prolonged. So as a result of that, everyone would try to finish it within the stipulated time, that is within a year maximum. Then it's confidential, informal, may involve significantly less procedural complexity than that of court proceedings. It helps the parties to maintain their commercial or personal relationships even after the dispute is resolved. Now, in Sri Lanka, there are instances where there will be one agreement with an arbitration clause, but several activities take place under the same agreement. It's like an umbrella agreement. So even if there is a dispute in one aspect of the agreement, but while the matter is being arbitrated, the rest of the agreement and the functions will continue as if nothing happened with regard to those issues. So that's the biggest advantage in the Sri Lankan perspective. I think it's the same in other jurisdictions as well. However, there are certain instances where the council have thought it's prudent to seek the assistance of court instead of coming to the arbitration, taking into consideration of the complex legal situations and the practical problems. The basic prerequisite for arbitration is that it must be parties must agree in advance or after the dispute arose to refer the dispute to arbitration. That is something unique. That's a unique provision because it is not necessary, but in certain jurisdictions, you need to have an arbitration agreement to refer a dispute to arbitration. But in terms of the Sri Lankan Act, even after a dispute arises, notwithstanding the fact that there was no arbitration agreement, the parties can agree to refer a dispute to arbitration. Of course, you need to have a written agreement to refer the matter to arbitration. The arbitration agreement is like any other contract, which needs to fulfill certain requirements. For an example, the capacity to enter into the arbitration agreement. In this regard, I like to share my experience as a judge. There was a case which came before me where at the time the parties entered into agreement, they have not named the proper parties to the agreement. Technically, both parties were companies, that is with regard to road construction, but the person who drafted the agreement referred to one party as a sole proprietorship, notwithstanding the fact that it was an incorporated company in Sri Lanka. That's a Chinese company, but incorporated in Sri Lanka. Majority shares were with them. Then, when this Chinese company initiated arbitration proceedings, the respondent took up the position that there was no valid arbitration agreement because the party who signed that was not a legally recognized person, not a juridic person, namely. So the arbitral tribunal held with them, and finally it came before the Supreme Court, and the Supreme Court affirmed the decision of the arbitral tribunal. Now, how long I have? May I know how long I can go on? How long I can go on?
Sir, you have 5 to 7 minutes, sir.
How long I can go on? All right. Then, like in India, we have the appointment. It's actually in Sri Lanka, there is no need to have any qualifications to be an arbitrator. But as a result of that, retired judges, accountants, engineers, and various other people are appointed. But it's always better to have a legally trained person to chair the panel for the reason that it involves evaluation of evidence and also the procedural aspects. And quite often certain legal issues will also arise. like in India, of course, not by the Chief Justice. In Sri Lanka, if a party doesn't appoint an arbitrator, the other party can go to the High Court and ask the court to appoint an arbitrator. The other important thing is, a lot of people, it is very important that at the time the agreements are drafted, the agreements should be drafted very carefully. What a lot of people do is they just copy it from someone else. And when a dispute arises only, they will see the problems. Now, one has to be very careful when they decide the seat and the place of arbitration, because they have two different meanings. Due to time constraints, I don't want to go into those ones. I will just go by, I will only refer to the relevant points only. And also, if there is a arbitration agreement under our act, the courts have no jurisdiction if the other side goes and object to the jurisdiction of court. I think it's same in India also. But the difference is, under our law, it's the courts have no power to refer the matter to arbitration. All what they can do is they can dismiss the case. It's up to the parties to go to arbitration. But at present, we are considering, Sri Lanka is considering to introduce a system where the courts on its own, whether there is arbitration agreement or otherwise, will have to give power to courts to refer matters to arbitration or mediation like in Singapore. Also, it's the same in America. And those have been very result-oriented. Then, like in India and the region or any other country, we have the doctrine of competence. Competence is applied in Sri Lanka with regard to the jurisdiction of the tribunal, where the jurisdiction can decide. Unfortunately, under Sri Lankan law, if the tribunal decides that it has no jurisdiction to hear the matter, there is no right of appeal. So that's the end of the matter. So I have written a judgment in this regard. We have a similar provision like in other jurisdiction, where it says that if the award is final and binding on the parties. So therefore, we have considered that aspect and held that it's almost similar to the doctrine of res judicata. So thereafter, if somebody takes up, if recently there was arbitration which I did, the respondents, it was an insurance matter with regard to the refusal to pay a claim. Of course, there was arbitration agreement, but that refers only to the disputes with regard to the quantum. So this was a case where they have refused to entertain the claim. So when the other side took up that position, objection, the claimant withdrew the proceedings, reserving their right to refer the matter to institute action in courts, which was allowed, and so then that helped them to overcome the difficulties with regard to res judicata. Now, the latest thing is when it comes to international arbitration, we use new technology. The issue is with using technology is mainly to have video conferencing and like that. So there are various problems arising from that. The speed, the honesty of the parties, whether they are being coached during the cross-examination or evidence in chief, and how. So in that context, I think it's better if the international community get together and come up with a set of rules which will help or a model law or model rules which will help the other countries to enact corresponding legislation or the rules with regard to using technology for arbitration. It could be local arbitration or international arbitration. When it comes to mainly our local arbitrations are done based on ad hoc procedures, but when it comes to international arbitration, we follow ancestral arbitration rules or the other various international procedures and rules. Now when it comes to, since there is now I have almost come to the end of my time, I will try to wind up. Enforcement, our arbitration agreement act recognizes foreign awards. So it can be enforced in Sri Lanka, any foreign award. We have not specified what is an award. One can get a broad interpretation to any award, whether it's commercial or otherwise. It can be enforced in Sri Lanka. And our Section 31 specifies the procedure for enforcement of the arbitral award, and Section 32 specifies how to set aside an award. Now, enforcement, the claimant has 1 year and 1 day to file enforcement applications. But the respondent who wants to get the award set aside, he should file it within 2 weeks. For late Justice Prasanna Jayawardena and I have written a judgment which says that if a person doesn't exercise their right to set aside an award within 2 weeks, is not entitled to resist the award at the time when it is enforced. Of course, it is subject to certain restrictions which are set out. The main distinction is that Sri Lankan Arbitration Act is set out basically the main points, unlike the Indian one or the other jurisdictions. I think, in my opinion, the Indian Arbitration Act is better compared to the Sri Lankan one because it is more comprehensive and the positions are more certain. We go by mainly the jurisdiction, the jurisprudence of previous cases, how the courts have interpreted these agreements. But the other thing is, in Sri Lanka, we don't apply the Civil Procedure Code or the Limitation Act, which is in Sri Lanka, we call it prescription ordinance. But we have a similar provision which allows, which says that one should come to arbitration within a reasonable time. So in such circumstances, the tribunal can see why, if there is a delay, whether that delay is justified. Now, the Sri Lankan courts facilitate the arbitrations and the enforcement procedure. It doesn't take a restrictive view. We take a broader perspective and try to facilitate arbitrations. And the government also try to encourage arbitration. In fact, the Port City Act, the Colombo Port City Act says by law, if there is a dispute, it should be referred to the port city and an investor, it should be referred to arbitration. And also we have said our law does you need to file the arbitration agreement, but it's not necessary to have the file the original agreement, but filing a certified copy is sufficient. Because as I earlier mentioned, we have different types of different disputes can arise under the same agreement, and those disputes can come up at different times. So therefore, it's not practically possible to file the original in court at the time of enforcement or to set it aside. So therefore, actually, I have written a judgment where it says a certified copies would fulfill the requirement of the Sri Lankan law when it comes to enforcement or to set aside an application. Our main issue, I will conclude with this, my personal opinions, few suggestions. My personal experience is that, thank you, is that, excuse me, is that we lack an institution which trains arbitrators and counsel. I've seen instances where counsel, actually I myself has appeared as a counsel in arbitrations before I joined the judiciary. Counsel present his case as if he is presenting a case in court. There's a vast difference in the appearing in court and in arbitration. So sometimes in arbitration, the counsel can be very aggressive like in court, or take up various technical objections. So those are things, so I think those are real issues that needs to be addressed, and there has to be an institution or a process where we train arbitrators and the counsel both. So that's the main thing, in my opinion, that requires to promote arbitration, because there is a trend in Sri Lanka. The people are now trying to go away from arbitrations because of the long delays and the fact that sometimes the tribunals are being converted to courts. So those are the main things that I have to say. Thank you very much for giving this opportunity. If there are any questions, I should be able to take one or two questions.
Just as now, we have a question from Sebastian Kiels, which is as follows. Your opinion on the political, economic, and potential economic and political risks in Sri Lanka being a stifle for the country's development in international arbitration, and how it can be overcome.
I think as far as when it comes to commercial matters, international commercial matters, to overcome the problem of claiming sovereignty, we have included, because when I was serving in the Attorney General's Department also, we included a clause which says that the agreement would be considered as a commercial agreement. Or there are certain instances where we have specifically said we will not plead sovereignty when it goes to arbitration. And also, as far as I can see, the main object of the successive government in Sri Lanka is to promote commercial activities and to attract foreign investment. So in that context, I think we leave politics from and the arbitrations or the litigation will be handled in a different perspective. So there won't be any interference with regard to those matters. And also, even the government contracts, certain instances we have agreed to go to have Singapore or England, UK, as the seat of arbitration.
Thank you, Honorable Judge of Sri Lanka and Fiji. It's a very insightful session what you had now, and we are very, very happy on behalf of KFCRI. We thank you once again for sparing your valuable time, particularly facilitated through the Sri Lankan National Arbitration Center and the registry. Thank you, sir.
Thank you very much. It's really appreciated. Thank you. Video conference.
Hello.
Yeah. Moving on with the next speaker, we are honored to welcome Mr. Elias, an accomplished lawyer, lecturer, and international arbitrator with over 2 decades of distinguished legal practice. As founder of Gehem Law Firm in Beirut, Lebanon, Mr. Gehem has built a premier legal institution known for its excellence in advising both local and international clients. He serves as on the Arbitration Committee of the Beirut Bar Association and the Executive Board of the Lebanese International Arbitration Center, and plays a key role in global arbitration policy through his work with the Chartered Institute of Arbitrators in London. His expertise span international business law, banking and finance, corporate and commercial law, privacy law, and international dispute resolution. A certified integrated risk management and artificial intelligence professional, Mr. Gehem also advises multinational corporations on GDPR compliance, data governance, and AI-related legal frameworks. He has served as an arbitrator in numerous institutional and ad hoc proceedings and is affiliated with leading arbitration centers including SIAB, CPIANI, LAAC, BBA, LAMC, TIAC, and CAMC. In addition to his legal practice, he lectures on AI, ethics, and principles at the American University of Beirut. We are delighted to welcome him today as he elucidates the realm of ADR in Lebanon, offering the valuable perspective shaped in his extensive experience and leadership in this field. It's over to you, sir.
Hello. Good morning. Thank you so much for your introduction. Good morning for distinguished colleagues and arbitrators and friends all over the world who are listening to us today. Firstly, it is an honor to address you today at this prestigious forum. Lebanon is an arbitration-friendly jurisdiction. Its arbitration legislation is modern and embraces well-established principles of international arbitration. Investors and business actors in Lebanon increasingly include arbitration clauses in their agreements to benefit from the ability to choose their arbitrators, the speed and the flexibility that is offered by arbitration, and the confidential nature of arbitral proceedings. We are now also adding to the arbitration scope the regulating oil and gas investment in Lebanon, among other things, of course. Because we have oil and gas in Lebanon, and it has been regulated during the 5 past years. So I will try in this session to explore 4 main points regarding first the legal safeguards protecting international investors, key trends shaping commercial arbitration, the role of Lebanese courts in supporting arbitration, and of course, if there is some critical reforms needed to modernize our framework. So what is a legal framework that protects international investors in Lebanon? Lebanon offers a dual shield for investors: international treaties and domestic legislation. For the international treaties, we have 52 bilateral investment treaties, and 43 of which are still in force. So we have more than enough to have a good protection for investors through those treaties and conventions. And we have to add that Lebanon is signatory to the GSADRT Convention and the New York Conventions. The GSADRT, which means the Washington Conventions, and the New York Conventions in the recognition and enforcement of arbitration award. So Lebanon signed also many other treaties, regional and multilateral agreements. So for the investors, it's the main point here. There is a big issue in the matter of protection. He is very much protected by those multilateral and bilateral agreements and treaties. The other shield or protection for investor is not only the treaties and convention. We are going to the Lebanese investment law itself. We have in the 2001 a new law based on investment to encourage all investors from all around the world to come and invest in Lebanon to benefit from its provisions of this law, of course, because all Lebanese bilateral investment treaties contain arbitration clauses. So this law created a public authority named IDAL, Investment Development Authority of Lebanon, a legal entity enjoying administrative and financial autonomy. This new body has promote and he can sign agreements with any investor regarding matters regarding to agriculture, agri-food, tourism, information technology, telecommunication technology, and media sectors. So it is a wide scope to invest in Lebanon, and it could be regulated and under the supervision of the government, the Lebanese government. So we have, for this matter, it's very important to know that we have an arbitration clause that refer to arbitration on all investors' case. Any case in Lebanon with investor must be under arbitration to protect them from any problems in the futures. So Lebanon has been subject of a few investor-state investment disputes. Recently, after the economic crisis in Lebanon, we have been five recorded cases in which Lebanon has acted as a respondent under the GSADRT and one under the Cairo Regional Center. So we have some dispute regarding the investment in Lebanon. One of those disputes, the tribunal dismissed the a Greek company claim under GSADRT. Under GSADRT in 2024, and we have still other dispute which is very important to mention. We have a big investor in Lebanon, an Emirati investor, which is Haptour Group, issue a notice of dispute under the UAE Lebanon bilateral investment treaty against the Lebanese public. So we have precedents in Lebanon. We have many cases regarding the issue of investment in Lebanon. So the investors can recourse to the GSADRT or the Cairo or any other place where you have the favorable place for arbitration for them. They can choose a seat, they can choose the institutions as well during the drafting of the contract with the Lebanese government or through the EDAL, which represent the Lebanese government. So this issue, I'd like to highlight on it because it promotes for investors to come to Lebanon to look into its regulations for new investments during this new laws in Lebanon. The second subject, which is important to highlight on it, it's the key trend and development in commercial arbitration. You know, it's not only in Lebanon, in most places in the world, you find that we have a growth of institutional arbitration. The main thing in Lebanon that we don't have a lot of arbitration institutions, which is primarily looking in commercial arbitration. We have 3 or 4 institutions, but the most important or the primary one is the Lebanese Arbitration Center of the Chamber of Commerce, LAMC, which was founded in 1995. So this center is important to look into it and to discuss some matter regarding its rules. We have a new rules in 2024. They look into to align with the need and practice of modern arbitration, such as procedures for complex disputes, shorter time limit for challenges, interim measures, place of arbitration. It should be done or determined by the tribunal, not the court, if not agreed by the party. Emergency and expedited arbitration, which is very important. We look into it on many international arbitration institutions all over the world. You find that we are looking to minimize the cost and fees on any parties that are looking to settle their dispute in arbitration. So the emergency is important to expedite the proceeding as well. For the expedited arbitration, it is important to have a limit short time to settle dispute without paying a lot of money. So we have such centers in Lebanon. We have as well for the ICC, we don't have a place for arbitration, but we have a national committee that look in appointments of local arbitrators. We have the Chartered Institute of Arbitrator London, which I'm honored to be part of it, which is looking for education and training only in Lebanon. She doesn't look into settling any dispute in Lebanon in this matter. We have a new important center, which is the LIAC BBA, which under the paramount of the Beirut Bar Association. I've been honored to be one of the founder and executive board member. For more than 6 years, I work on drafting the rules of the center and promoting for arbitration in Lebanon. So it is an important center looking for arbitration as well. The important thing that has to be highlighted as well is the digitalization and remote hearings. It's not only for Lebanon. We know it's a new practice in arbitration that it depends to the tribunal to decide how to have a video conference and remote hearings. And the digitalization has been more and more implemented on the proceedings of arbitrations in Lebanon and elsewhere. So the parties to the contract should not hesitate to use this ODR out of fear of non-admissibility and or they are a fear of unenforceability of the arbitral proceedings at all. It will be enforced and the award shall be recognized by Lebanese courts. So this matter is very important regarding the trend and development in commercial arbitration. I will shift to the third point, which is the influential ruling by local courts impacting arbitration. It's not only Lebanon who have impact from local courts, which depends on certain degrees. And of course, we have many kind of intervention by the local courts. The main issue that courts play a vital, yet sometimes contentious role. First of all, the domestic courts support to the arbitral proceedings. The second issue is the intervention in case of forgery allegation. The third, the provisional relief, and the fourth, the recognition, which is very important to recognize and enforce the award. So in this matter, we have to highlight on many things in the matter of intervention of domestic courts in Lebanon. In supporting the arbitral proceedings, the president of the court of first instance may act as the judge in support of arbitration. Regarding appointment of arbitrators where parties have failed to designate an arbitrator, or where there is absence of an agreed set of institutional rules containing a default mechanism. So the domestic courts had the role to support the arbitral tribunal. And on the second point, it could intervene. The arbitrator shall suspend on domestic arbitration, the arbitrator shall suspend the proceeding in matter of forgery allegation. This matter is very important to highlight. We have international arbitration and domestic arbitration in Lebanon. Regarding the domestic arbitration, any allegation regarding forgery, the tribunal shall suspend his proceedings till we have a settlement on, not settlement, we have a final decision on this matter. So it is important to highlight on it because it is different than the international arbitration. If there is a forgery allegation before an international tribunal or international arbitration, the principle applies in international arbitration unless there is an agreement to the contrary. If the party mentioned that in case of forgery, then the tribunal shall continue to go through the proceedings, then it will not be pending at all, and we continue till we receive an award. So it is important to mention for legal practitioners, once we have a draft in Lebanon, to mention this exception to limit any guerrilla tactic regarding forgery allegation. So on this matter, we have a domestic court as well to provide provisional relief. We have two kinds. The tribunal, if is not yet constituted, so they can give relief in support of the arbitral tribunal before the judge of summary proceedings, which can be done on ex parte basis. You know, we don't have to notify the other party. After the constitution, maybe the tribunal will ask the local judge to sanction witness who fail to appear at hearing, or those who refuse to testify, or interim attachment order to freeze assets. So there is many things that can be included in this matter and supported by the local Lebanese court. So we have another recognition and enforcement award, which is very important as well. This point is a matter of the recognition of the domestic award and the international award, international arbitration. So we have both of that. To have a international arbitration award recognized in Lebanon, it records against, you can have an exequatur from the judge in Lebanon in order to execute or to enforce this award. Of course, we have many challenges of this matter. It could be I will not go through it now, but in matter of enforcement, it could be enforced. And in matter of annulment as well, if there is a challenge of arbitral awards, when is conducted, if the arbitration is conducted on ex equo et bono, the arbitral award cannot be appealed. But we have to highlight on other issue that in international arbitration, appeal is not an available recourse, and the arbitral award can only be subject to a setting aside action, which is very important on this matter, because the setting aside action are considered public policy and cannot be excluded by the parties' agreement. If the party can include in their during drafting of the arbitration agreement or arbitration clause that there will be no appeal on the decision of the judge, the award of the tribunal, then you don't have to go to appeal. But if they don't say that, maybe one of the party will go to the appeal. So, and the most important thing is that you cannot agree at all, internationally or domestic arbitration, to insert a clause where you say that an award, you cannot refer to the objection or the challenge to set aside an arbitration award. Always you have the option as one of the party to challenge the arbitral award. This matter for awards rendered in foreign jurisdiction, there is a matter of granting an exequatur, as I mentioned, and the appeal against the decision granting exequatur if someone didn't have the option to execute it because the court refused to give him an exequatur, he can challenge it and appeal before the court. So all is regulated regarding the challenge and the enforcement in Lebanon of those of the awards. But the main issue that I would like to highlight on it is that we don't have a lot of grounds to object or to challenge. It is limited in the international aspect on 6 only. If it was rendered, the first one, if the award was not rendered, it was rendered without an arbitration agreement. This is a ground for challenge, or on the basis of an agreement that is null or void. Let's say we have one of the arbitrator didn't take an extension of time during the proceedings, and this will happen many times if someone is not aware for the time limit to finalize the award. So this matter will be subject to setting aside the award. So it's very important to highlight on this issue and to take the time limit in consideration. If the award, if it was rendered by arbitrator not appointed in accordance with the law, and if the arbitrators ruled without complying with the mission conferred upon them, if it was issued without due respect to right of defense, so due process and equal treatment between parties is very important in arbitration. Otherwise, it will be subject to setting aside the award. If it violates a rule of international public policy, it's very important when we are talking about international arbitration. International arbitration is subject to international public policy, not to local public policy, which means a friendly, arbitration-friendly concept in Lebanon. Any award, if it is against local subject policy, it couldn't be challenged. It must be against international public policy. That means international standard regarding public policy, which is very good on this matter. So we have many examples of Lebanese courts that have set aside awards for procedural irregularities or violation of public policy. We have many precedents under the Court of Cassation. Every year, I think we have a new jurisprudence on this matter. The fourth point that I would like to explore it with you is the current challenges and the critical issues in arbitration landscape. So it's not the matter only what we have, it is the matter as well what we have to do, because we have a new situation now. We are in a new era of AI, so how to look into the future, how to correct if we have some things to make it better. As a member of and the reporter of the Special Committee of Arbitration in Lebanon, tasked with crafting a proposal to the parliament to enhance the current Lebanese law on arbitrator. It is an honor for me to be part of this special committee. Many concerns and challenges is facing arbitration and must be considered in a new amendment of a new law. The arbitration landscape faces several challenges and critical issues, particularly with our country's economic crisis, political instabilities, and outdated legal framework. So we know, all of us, that our law is based on French law as well on the ancestral model law. But there is many things that had been amended in the new model law and is still outdated in our law. So if I have to highlight on such many points that has to need reforms, first, lack of sufficient judicial support for arbitration. I mentioned that we have support, but it's not enough for our future. There is delays in court interventions. We have excessive judicial interference, maybe in reviewing the merits of dispute when deciding on annulments. So it's a matter that has to be regulated because it has to be looked only on matter on the 6 grounds that I mentioned it, not on the full merits, because it will be excessive judicial interference. Another matter is the recognition of arbitration agreement. So not all Lebanese courts is agreeing to accept all kinds of arbitration agreement. So it is a violation for the competence principles. There is outdated ground as well for annulment. It is broader than those under the ancestral model law and include vague standards, how to explain a violation of public policy. So we need to amend this matter as well to be more consistent with the new model law. So the needed reform will narrow the annulment ground to align with international standard. And it will be examples only for procedural defects, lack of jurisdiction, or serious public policy, international public policy, not local public policy. So we have another point regarding the enforcement challenges, difficulties in enforcing awards, because we have bureaucracy, inefficiency, and political interference sometimes that maybe is affecting the arbitration's outcome. For foreign awards, sometimes delayed due to judicial reluctance to improper application of the New York Conventions. So we need as well a reform on matter of enforcement. Clarifies that court should not review the merits of awards when enforcing them. So it is very important only to look at it on prima facie. And another issue is the arbitration independence and challenge proceedings. We have it in the articles of the CCP, which is the Arbitration Act in Lebanon. The current rules on arbitration challenges are vague. We don't follow the IBA guidelines on conflicts. So we need a reform that adopt clearer standards for arbitrator impartiality. And we need as well, I recommend it not only for Lebanon, but for every practitioners and for every government in the worldwide, the lack of specialized local arbitration institutions on the new science like blockchain and fintech. You know, we have more than tens of centers on every country, but we don't have specialized institutions that look into the new science of fintech, blockchain, or AI. So all those things must be specialized within special institutions. So I will look forward to have it in Lebanon, and I would like to see it in other places in the world. We have another issue which is important, the matter of the impact of economic crisis on arbitration in Lebanon, because we had a banking restrictions and an informal capital control. Parties had struggled to pay arbitration fees in foreign currency, hindering the proceedings. But now this solution is more and more simplified, and we can say we passed this critical moments. Finally, and as a conclusion, Lebanon has long recognized as an arbitration-friendly jurisdiction, and with targeted modernizing of its legal framework, and it can reclaim its status as leading regional hub for arbitration by limiting judicial interference, streamlining enforcement proceedings, and aligning with international best practice. Lebanon can strengthen confidence in its arbitration system. With the right updates, Lebanon is poised to become a premier destination for arbitration, reinforcing its legacy as a progressive and trusted legal jurisdiction. Thank you so much for your time.
Thank you, Mr. Elias, for quite informative, unique features about the Lebanese arbitration jurisdiction. And congratulations for being part of the committee which is working on the international arbitration proposed amendments in Lebanon. And it will be a really wonderful opportunity for KFCRI, the other knowledge partners, to have you in this platform and sharing a unique quality about less intervention of courts in arbitration. Thank you. Thank you, Mr. Elias.
Thank you. It's an honor. Thank you so much for your kind invitation. And I'll be more than glad to assist with you on any other panels. Thank you so much.
Moving on to today's next speaker, we have Mr. Henklo from South Africa. We are honored to welcome Mr. Henklo, Advocate, High Court of South Africa, and an esteemed figure in the international arbitration community. He holds fellowships with the Chartered Institute of Arbitrators, UK, and the Association of Arbitrators from Southern Africa, and serves as a chairperson of the SIAP South African branch. Mr. Lu is a seasoned arbitrator, mediator, adjudicator, with appointments across leading arbitration institutions, including AFSA, SIAC, LCIA, and Shanghai International Arbitration Center. He also serves as an active judge of the High Court of South Africa, Gauteng Local Division. We cordially invite Mr. Low to share his expertise on ADR in South Africa and contribute to the richness of today's discussion. Over to you, sir.
Morning. Thank you very much for the invitation. And welcome to all the panelists, to all the participants, arbitrators, mediators, and adjudicators from all over the world. It is indeed an honor to address you today. What I would like to do today is give you a quick overview of where we sit in our arbitral environment within South Africa. And as a starting point, I was reminded last night in a discussion with a colleague from London with reference to the arbitrations and the perceptions on appeals and reviews of the words and the wisdoms of Michael Mustiel, one of the greatest commercial judges and authorities on arbitration in the United Kingdom and probably internationally. And it was the following. Arbitration is a process in which the parties voluntarily agree to pay a lot of money to get the wrong result and live with it. Now, of course, that is opposed to what we find in our environment of civil litigation, where we eventually have the right of appeal. Now, let's go back to South Africa. Within South Africa, we perceive ourselves currently to find arbitration as something which is friendly within our jurisdiction domestically and also internationally. Arbitrations are currently chosen as the process of dispute resolution, it seems, in circumstances where it is legitimately and constitutionally permissible. It is enforced by the courts and dealt with by the courts and recognized by the courts, unless, of course, there are exceptional reasons for not doing so. Now, our arbitration system is based upon the general three pillars, of course. Firstly, the common law and developments, international jurisdiction, international trends. And our common law is mainly based upon the Roman Dutch law and adopted with principles of the English law and English law of arbitration. And of course, where there is conflict between legislation and our common law, our legislation would take precedence. Now, the question then is, what is the basis of our arbitral environment statutorily? Firstly, we have the Domestic Arbitration Act, Act number 42 of 1965, which was created way back when, and there is currently a process with the Department of Justice and the arbitral environment in society and leading academics and participants in the system to rewrite this Arbitration Act to bring it within the current environment of where we are and need to be internationally. Now, our High Court, in terms of domestic arbitrations, do, of course, have a role to play, and that we sit with the powers of assistance, powers of supervision, and powers of intervention. And in very many instances, the Arbitration Act does not direct what is to be done, but creates an environment of various provisions in circumstances where the parties can then also contract out of those in terms of the provisions of the arbitration agreement in existence between them. Currently, we do have a bit of a judicial crisis in South Africa, in that we have a extremely overworked High Court with judges taking a massive workload, and that seems currently to be creating a catalyst for matters to be referred to arbitration and mediation, to which I will refer a little later. However, the judiciary, and specifically the South Gauteng division of the High Court, which is, in terms of the International Arbitration Act, the division looking after international matters, is supported by an array of acting judges. Now, what we generally do is we make ourselves available for a specific period of time, and then we go in and we assist the judges to allow them to deal with their important case role and very important issues, also arbitral issues. And if they, of course, can't deal with it, then we have experts in our fields that we can make available to assist. Now, our current Domestic Arbitration Act has also been adopted in 3 sub-Saharan Africas, neighboring countries. So we have a wonderful situation where we have a feed across of information from one country to the other. Now, in 2017, on the 20th of December, our International Arbitration Act was promulgated and brought into life. Unfortunately, that act took some 12 years to come to fruition, but it is there now. And since it's been there, South Africa, as an international arbitration venue, has grown and developed exponentially. Initially, there was very little happening, but I understand that currently the caseload dealt with in terms of arbitration, both ad hoc and ministered on the African continent, is to a great degree dealt with by us. The objects of our International Act is of interest. It facilitates arbitration as a method of resolving international disputes. And more importantly, we've adopted the model law, UNCITRAL, as a schedule into our Act. And it has proper acceptance and people deal with it. It's international accepted standard for the resolving of commercial disputes. And we, of course, follow the reports of INCITRAL and also its secretariat, and that is in the Act. We've also adopted the INCITRAL conciliation rules, also as a schedule to our Act, and we facilitate the recognition and enforcement of arbitral awards. And for that purposes, we've also adopted the New York Convention on the recognition and enforcement of arbitral awards 1958 as amended and adopted in Schedule 3 of our Arbitration Act. What we have is a Protection of Investments Act in South Africa of 2015, and that is also the subject to be read with the International Arbitration Act. And our International Arbitration Act, of course, binds our public policies, public bodies within South Africa. Within this environment, South Africa is also a signatory to the New York Convention, but of course, our legislation does not require the being a signatory or a participant in exit, unfortunately. Now, again, I've mentioned earlier that our High Court does have problems in its caseloads, specifically the South Gauteng Division in Johannesburg, which is the biggest and the fastest growing commercial court in the country. And that commercial court is tasked in terms of the International Arbitration Act to be the default court in dealing with international arbitral disputes in circumstances where the parties have not agreed to another division and the matters are not by agreement referred to other divisions as such. As indicated before, because of the advent of this act, we have developed in leaps and bounds. Now, the question is, do we then have the necessary arbitral institutions to facilitate this process that we have and the development of this process? Now, the answer is an absolute and resounding yes. I'll refer you to 3 arbitral institutions, but in addition to them, there are various other appointing bodies. There's the SAICI appointing body, there's appointing bodies in terms of FIDIC, in terms of JBCC, construction industry, etc. So everything is catered for, but it falls generally under the umbrella of the 3 bodies, and the 3 body rules are used. The first is the Association of Arbitrators. Now, that's our oldest arbitral institution. It was formed in 1979. And initially, it developed into a line where it had to do a lot with construction type disputes, but it is now a general body dealing with all matters to resolve disputes with reference to arbitration, mediation, and appointment of adjudicators. And as such, it deals with matters on an ad hoc basis, and it appoints dispute resolvers from its panel of fellows. Now, in order for you to be a fellow, you have to do the courses of the association, properly pass the courses, and I think it's on a 70 or 75% pass rate. You then get invited onto the panel, and of course, depending on your speciality, you are appointed with reference to your panel experience to deal with matters. The association also has adopted various guidelines in the use of artificial intelligence in the arbitration and adjudication environment, and as such, it has also provided very many of its own rules. Now, it has adopted and it uses the International Bar Association rules on the taking of evidence, also with the conflict provisions. It has its own mediation rules, which is something which is of growing importance currently in our environment. And then it has its own rules on the conduct of the arbitrations, the 2021 edition rules, and that's based upon the INCITRAL model law. And it is a very good, very workable international set of rules applied domestically. And of course, it also follows the INCITRAL rules. In addition to its very important function as an appointing body, the Association of Arbitrators also fulfills the role of a training institution, both with reference to domestic and international construction arbitrations, and also deals with the training of mediators and adjudicators, mediation training taking place in conjunction with the Society of Mediators in London. And the web address is on the slide if anybody wishes to have a look at them. The second body is a very exciting body. That is the Arbitration Foundation of Southern Africa, AFSA, generally known, which was established later in 1996. and it was established because of a need in the environment and as a joint venture between business and legal resources and legal individuals and firms and practices to ensure that there's an administered process of confidential dispute resolution, both with reference to domestic and current international disputes, and that goes across the range of mediation, arbitration, adjudication, and related processes. Now, AFSA has a wonderful headquarters in Sandton, Johannesburg, with 4 world-class arbitration facilities, and it has branches in Cape Town, Pretoria, Durban, Mabatu, and also in the Garden Route in South Africa. Now, if one looks at the web address of AFSA and consider what they provide, it provides full domestic arbitration services, both as an ad hoc appointing body, but mostly, more acceptedly, as an administered institution. Then they have a division, AFSA International, created and dealing specifically with reference to issues in terms of the International Arbitration Act, incorporating the Instral model law on commercial international arbitration. As such, it administers its caseload in Sandton through Svetlana Vasilina, the Secretary General of the International Court, and that is an indication, of course, that the International Court is a body created within the environment to ensure that there are compliances with procedural issues, issues within the arbitration, etc. Now, within the AFSA international workload, their participation on a dollar value has grown exponentially, and I think it's now probably the second or the biggest facility in South Africa. And we currently sit, I think, in excess of $50 million a year that's being dealt with. And of interest, a general arbitration of an international nature in 2023 took some 8.2 months from commencement to finalization. And an interesting statistic also is that one matter to the value of 169 million was dealt with and resolved in a period of some 18 months, which I think, considering the litigation process through the High Court system, is marvelous. AFSA, of course, has its own 2021 international rules. It has its court. It has very many court members, some 21 members, and they supervise and administer the resolution of disputes by tribunals and ensuring the performance of the various functions in terms of the rules. Now, the 21 members include Justice Inbavijayan Veeraraghavan, and he was elevated to the Supreme Court of India in 2016, and there he served as a judge for a period of 6 years. Very valuable, great member of our court, and has at all times a great assistance, knowledge base, and experience that he provides to us. Of course, we have in our region, in the Southern Africa region, a thing called the Southern African Development Community. Now, that community consists of 16 countries, and it's a regional socio-economic cooperation and integration area, taking into consideration political and security cooperations in the 16 countries. In alphabetical order are Angola, Botswana, Comoros, the Democratic Republic of Congo, Eswatini, Lesotho, Madagascar, Malawi, Mauritius, Mozambique, Namibia, Seychelles, South Africa, Tanzania, Zambia, and Zimbabwe. Now, this development community that we sit in assists and deals with very many issues and has a extremely big dollar ratio trade zone. I think it's some $600 billion at some point in time. And of course, within this area, we have a free trade zone, free trade area, and we have implementation of the protocol of trade in 2000. Seems to me the slides on the screen may just be a little bit behind mine. Then AFSA also has what they call AFSA construction. dealing with the construction industry, and there they have both administered and ad hoc rules. It has also a thing called AFSA Business Rescue, AFSA Mediation, AFSA Training in association with the University of Victoria. There's also AFSA Municipal Division, and I'll get to the next one now. Now, in terms of AFSA mediation, the important issue there is our current environment in the High Court litigation and matters in the High Court not progressing. And therefore, we have the mediation facility, and I'll refer your attention to that now. AFSA training, of course, from the University of Victoria. And once you've done the AFSA courses, you have something akin to a university diploma. Then we have the China-Africa Joint Arbitration Center in Johannesburg. Now, the interesting thing about this is the need for arbitration because of the increase in trade between South Africa and China, and the forum on the China-Africa cooperation, and there were some 51 states to that. Now, KJAC offers party neutrality, speedy resolution, confidentiality, flexibility, etc. And in that process, we've created the KJAC rules on international dispute resolution. Now, those rules are, of course, also on the website of AFSA, and I've also indicated the website reference to KJAC. Now, AFSA has also placed itself in a very interesting situation with reference to the AFSA rules in terms of BRICS and the BRICS dispute resolution framework in existence. If you can just go further down on the slides, please. Now, at the 6th BRICS Legal Forum, which was held in October of 2019, AFSA was appointed as the BRICS dispute resolution in South Africa, and there was, of course, also a call for the creation of various BRICS resolution centers within the BRICS nations and the BRICS member states. Now, the AFSA KJAC rules, AFSA international rules, are now used, it seems, as the basis rules for BRICS. And during 2023, at the 8th BRICS Legal Forum in South Africa in Kempton Park, those rules were adopted as modified AFSA rules in the BRICS Forum, and my understanding is that it's now been adopted in Russia. Now, AFSA as an institution has also been awarded full membership of the International Federation of Commercial Arbitration Institutions, and I've provided you also with the reference, website reference of AFSA arbitration.co.za for interest. The third is the Chartered Institute of Arbitrators South Africa branch, and we also referred to indicate that it's Southern Africa. Now, I'm fortunate enough to be the current chair of this organization, and we're trying to develop and grow it, and through formal and informal partnerships, also with various arbitral institutions and the other appointing and non-appointing bodies. Of course, with that, we have access to our 17,000 members internationally, and I think it's the 54 branches and jurisdictions in which we sit. And of course, with that, we present to our environment the Chartered Institute rules, expedited rules, again, importantly, the mediation rules, dispute board rules, which is of great importance in our adjudication environment, and also the various contract clauses in dispute resolution. Our current branch now fulfills the role of an ad hoc appointing institution with reference to both arbitrations, mediations, and adjudications. And we are developing into the Southern African SADC region with the same perspective of AFSA to ensure that we have rules and an environment within our 16-state region to ensure that there's uniformity, acceptance of standard rules, and the acceptance of judgments dealing with the matters, etc. Then, with reference to arbitration in South Africa and Africa, we have arbitration centers, which is recognized, and I think AFSA is currently seen as the premier arbitration center in terms of the 2020 arbitration global review in Africa. And we also seem to be in the second, or share the first position the Cairo Regional Center for International Commercial Arbitration, and we also hold the first place in Africa in terms of ad hoc arbitrations. Of course, that the 2020 report has sterling views on South Africa in terms of its environment, its business environment, its infrastructure, the class of arbitration facilities, arbitrators, etc., that one can use. Now, what does our courts think of us in terms of the arbitration environment? And there I'd like to refer to two issues. That's the first is the party autonomy and the choice of arbitration as a dispute resolution mechanism. Now, footnote 2, you'll see that I've attached the matter of Mafuni, Mohapi and Associates with Andrew and his brother, which was in the Constitutional Court in South Africa in 2009, Volume 6. Now, with reference to that matter in paragraph 34 of it, the Constitutional Court has expressed certain views, and they think that parties have not waived rights not to participate in terms of litigation in the High Court in terms of Section 34 of the Constitution, but the parties have now elected to participate and have their disputes resolved by way of arbitration, and that the Constitution accepts, and the parties can do so. In paragraph 235 of that judgment, I've also indicated the underlying portions that the values of the South African Constitution will not necessarily be best served by interpreting Section 33 of the Constitution, that's the access to courts in the system, in a manner that enhances the powers of the courts to set aside private arbitration awards. Indeed, the contrary seems to be the case. International and comparative law considers, and this judgment suggests that the court should be careful of not undermining the achievement of the goals of private arbitration by enlarging the powers of scrutiny imprudently. Now, in terms of our Arbitration Act, there are limited powers of interference, that's procedural irregularities within the tribunal, etc. But it's not an inquiry into the merits of the case, and it's not an appeal provision. Now, the second one is the issue of competence. And there I've referred you to the Supreme Court of Appeal in the matter of Canton Trading versus Fantini Becker, which is the leading issue on this matter. And I've underlined the portion in paragraph 35 of importance. But even if the dispute has not been referred to arbitration, the court may be disinclined to decide the question of jurisdiction unless the arbitration agreement is manifestly void. So effectively what we have is a situation where the courts have given effect to party autonomy, and the courts have said that the arbitrators must deal with their issues as they deal with it in terms of inquiries into jurisdiction. And if it then goes before the court, of course, at a later stage, then the court can deal with it. Giving effect to the issues of party autonomy, and of course, the importance of it also referred to in paragraph 37 of the matter of Zondi. Our courts are giving effect to the enforcement of arbitration agreements. Now, within that environment, we find that our courts have accepted arbitration as a proper dispute resolution mechanism, and it gives absolute credence to it. And there's currently a situation in our jurisdiction where it seems to me that courts are wanting matters to be dealt with by way of dispute resolution, and that is by way of mediation and arbitration. And of course, we have our courts involved in both international arbitration as well, and with reference to the model law, there are various issues in which the courts are involved. And I've referred you in the presentation to the provisions of the model law and what the courts can or can't do, but that's in terms of the internationally accepted standards. And I've referred you to the various articles in it. Now, where do we find ourselves in the High Court currently? And I'm now probably at the second or third last page of my presentation, the South African High Court, especially the South Gauteng Division, which is fairly congested. We have the following situation. If you now set a matter down for a hearing, you're going to wait until 2031 to get a court date for your matter to be heard. Our Deputy Chief Justice, Roland Sutherland, has commenced with the marvelous process of following what is also happening in the United Kingdom in the matter of James Churchill, which I referred to in footnote 7 of my presentation, to say that matters must now go for mandatory mediation. And if they can't resolve by way of mandatory mediation, they can come back onto the roll. But all matters from 2026 end and further have lost their placing on the roll. And if you haven't gone through mediation, you can't have your matter placed back on the roll. Now, in addition to that, what we're creating now is the second process, also by changing the rules of court, by saying, let's take matters out of the High Court roll and divert them to arbitration completely. And once they are in the process of arbitration, they are, of course, off the system, and they're dealt with by way of party autonomy and agreement between the parties. And once we give the parties the ability to make an election whether they want to go into private arbitration, the parties to the dispute will sign a form document, and the form document contains an arbitration clause. And once it's been signed by both parties independently, of course, they can arbitrate. Now, in the event of a dispute becoming before a court, that would then create a bottleneck again in terms of the review, in terms of enforcement, in terms of applications to have arbitrators removed, etc. And how do we deal with that bottleneck? And of course, the appointment of arbitrators when the agreement doesn't provide them. We further propose that we change our commercial court structure in South Africa. We create an arbitral division, and within that division, we create very strict timelines for matters to be heard. And once the matter is trial ready to be heard, which should take about 2 months, then we can have, we want a judge appointed. And in the event that the system doesn't have judges because it's so overworked, then we as the profession propose to make individuals of the profession available to assist the High Court, and we then act on an ad hoc basis to assist. Now, that process is currently under discussion, negotiation, and review, and hopefully if we have a further session at some point in time, we can positively say something about that. Then in terms of my last slide, because of the importance of private dispute resolution and the acceptance of the process, we, and being advised by colleagues also in London, are now doing away with the term alternative dispute resolution. We are now using it exclusively as dispute resolution, because we see dispute resolution as an absolute equivalent parallel. It is cost effective, it is time efficient, and it is not subservient. And in a presentation a couple of weeks ago with an actuary, we unpacked the whole process as to cost of arbitration, and we worked out, depending on the quantum and depending on how long it's going to take and the time value of money and inflation, it is cheaper in the long run to arbitrate and pay an arbitrator than to take ourselves into the High Court system. With that, thank you very much for the presentation and the opportunity. It's much appreciated.
Thank you, Henk, for illustrative the guidelines as set out in SIAB, the way how the South African context on domestic and international arbitration, along with that the AFSA and the other institutions in South Africa facilitating the arbitration in the way how it has to be. And we are very happy on behalf of KFCRI to thank you. Within a short notice, you have accepted and you have come forward to share with an excellent presentation. A PPT is so elaborative, and thanks for it. And already you got the chat from Dato Mary Lim on this very unique time wherein very interesting personality is going to continue with this conversation on this Global South ADR THIRUNAAL. Thank you, Henk.
Thank you for a wonderful, wonderful idea and this great knowledge sharing from across the globe. It is really appreciated. Thank you.
So for the next speaker for the day, we have with us Dato Mary Lim. We are privileged to welcome you, ma'am. A distinguished jurist, a legal scholar with an illustrious career spanning over 4 decades. She has served in various capacities within the Malaysian judiciary, including as a judge of the High Court, Court of Appeal, and most recently the Federal Court. Dato Mary Lim is also a director at the Asian International Arbitration Center and holds academic appointments as visiting and adjunct professor at several international universities. Her contribution to the legal forum, judicial integrity, and construction law are widely recognized, and she continues to serve on global advisory and arbitration panels. We invite Dato Mary Lim to share her insights and enrich today's session. I now hand over the virtual stage to you, ma'am.
Thank you very much, and good afternoon. My dear friend, Mr. Inbavijayan and Mrs. Inbavijayan, and everybody there at the Kovise Foundation. I've had the privilege of visiting your premises just in this last few months of the early months of this year. I was actually back in Chennai the second time. Yes, I didn't have the time and the opportunity to drop by the office again. I would like to do so. I'd like to go and visit Chennai and just visit your office and do something in person the next time round. I think that would be a lot more beneficial. I see Mr. Deva. I see everybody else. Good afternoon to you. Vanakkam. I am going to talk about the role of Malaysian parties as stakeholders in international arbitration. This topic has been identified to me by Mr. Inbavijayan himself, and I think it speaks volume of the fact that this is a man whose finger is always on the pulse of ADR, who knows what the clients want, what needs to be done, and how we should be collaborating and uniting between each other. So thank you very much, Mr. Inbavijayan, and to the Foundation for inviting me. We at the Asian International Arbitration Center are actually very, very excited, particularly with the way you have named this day. You call it the Global South ADR THIRUNAAL Day. And my colleagues and I were wondering what a choice of word, THIRUNAAL Day. It's a festival, and it's a festival of the richness of ADR. So I'm going to bring to this whole tapestry of ADR solutions that we can bring to our stakeholders, to our clients. It doesn't matter where they are, but this is Malaysia, and in particular the AIEC's offering. I'm going to touch on 3 areas in the practice of ADR here in Malaysia. And I would just like to say this morning we have, and in fact it's still ongoing, a sports arbitration forum. And, you know, the young ones are so involved in sports, and sports unite us without question. Winning or losing doesn't matter so long as there is fair play. And I think we should look seriously into that. And I suggested where better to resolve the disputes, but in the house of ADR. I like to, introduce or describe the AIC here in Bangunan Sulaiman as the house of ADR, just like the house of Chanel, the house of Dior. This is the house of appropriate dispute resolution, ADR. I'm going to cover 3 areas, as I said, and I want to first touch on the seismic moves that Malaysia has done in 20 years since we amended our Arbitration Act 20 years ago in 2005. It's exactly 20 years old. I have been part of that journey of amendment. It was an amendment quite necessary because Malaysia was quite trapped in the 19th, 20th century under its old legislation of the 1950s, but ideas were even older. Since that time, Malaysia has come a long way, and this act has put Malaysia, using the UNCITRAL model law, has put Malaysia as well as the AIAC in its proper place in the international arbitration and ADR community, keeping in line with best practices. I just wanted to say, as far as the Arbitration Act is concerned, it's a piece of legislation that deals for those who are looking at investing in Malaysia. It's a single piece of legislation. You don't have to look far. You don't have to look at 2, 3 pieces of legislation. It is in that single piece of legislation, whether you're dealing with domestic or international arbitration. The Act is drafted in such a way as to allow, in particular, international arbitrations, the choice of whether you want some additional provisions, and the additional provisions are contained in Part 3 of the Arbitration Act of 2005. Those additional provisions deal with matters such as consolidation of your proceedings, in the event you're looking at concurrent proceedings, and in the event you're looking at sending a preliminary point of law to court for some kind of guide, or you're looking at some issues on extensions of time for commencement of arbitration proceedings. International arbitrations, international parties may sometimes want to think about these kind of additional provisions when they are looking at dealing with the arbitrations on Malaysian soil. The Act gives international arbitration and our parties that option of taking this whole parcel of additional provisions or just taking 1 or 2. It is entirely up to the parties to pick an extra. But when it's a domestic arbitration, then the domestic parties have to decide that they don't want these additional measures and they have to consciously, deliberately opt out. So this is where we call the opt-in, opt-out mechanism under the Arbitration Act. I find one of the beauties of arbitration, in particular the Arbitration Act, workable in Malaysia. It is because of this single reason. The Act applies to the government. The government, be it the federal government or the state government, are huge consumers of ADR. In particular, we have a lot of construction disputes. So they are the first and biggest consumers of ADR, and the Act applies to them. And this is very encouraging to users or parties who interface with the government, whether the other party is yet another GLC or a private party internationally or domestically established. I think this is quite important when you're legislating. It is important to consider whether or not the government, be it federal, state, provincial, can be or are necessary parties to the legislation. And if they are exempted, then it gives you an uneven or unequal bargaining power. And in our country, the Arbitration Act applies equally to both private and public entities alike, and it applies also to the governments of the state or the federation. I then want to touch in the same breath about multi-tiered resolution clauses and the interplay of non-parties to arbitration agreements and collateral proceedings. There's been a fair bit of development here. So if the Arbitration Act applies, but you have multi-tiered dispute resolution clauses, and this has become quite a fashion. Here, the judicial trend is important because you like to see where the judicial support or non-support is. And the answer, we are abreast with the rest of the world when it comes to multi-tiered dispute resolution or escalation clauses. The courts look at it as, hey, they've written it into their contract and therefore parties should be taken to task to abide by those terms. A very simple principle, but sometimes quite quickly forgotten when they see arbitration and they wonder whether or not if they have negotiation, mediation, and we are all for alternative or more appropriate dispute resolution mechanisms. Should those other mechanisms be resolved first before they finally get to arbitration or before they finally get to litigation? The question has been resolved by our federal court as long as 10 years ago. And the Court of Appeal recently in some decisions, yes, the federal court has pronounced, yet there are parties who still want to try their luck when they're looking at multi-tiered dispute resolution clauses to say that they don't need to comply with it. The federal court here in this country, in the case of Juara Serrata, has quite categorically affirmed the principle that parties must stick to their terms of contract and they follow the outlined dispute resolution process. The failure to do so would deprive the party of going to the next process. It's just basically keeping parties to their bargain. As I said, the federal court has said it quite clearly 10 years ago in 2015, yet there are attempts, but the resounding voice of the Court of Appeal has been to comply with the federal court's decision, quite apart from following the doctrine of stare decisis. Then there is the question of what happens with non-parties and collateral proceedings in this cross-border world of ours. This has become, unfortunately, a matter of strategy, a matter of timing, and a matter of trying to get ahead. Trying to keep the assets out of view or keeping the dispute from moving on as it should. So the issue of non-parties to arbitration agreement, where does Malaysia stand on this? Here in 2018 is the case of Protesco. Court of Appeal had pronounced quite carefully that if it's a non-party who is taking a dispute to litigation, that non-party is not bound by the Arbitration Act, and it looks quite obvious. There may be others in that whole contractual arrangement who may be bound by the arbitration clause, but those who are non-parties, they are not bound. And therefore, the whole issue of mandatory stay and going to arbitration, insofar as the non-party is concerned, will not apply. Therefore, you would see and you would think, hey, what happens if there is a combination of a party to an arbitration agreement as well as a non-party? So you can have two parties in court, which is going to stay and which is going to move on. And here, in this case of Protesco, the court resolved it by saying, let's use inherent jurisdiction and use discretion and power to stay the proceedings in the interest of justice. So if it's going to cause a collision and an inconsistent finding, the court will look to see where the interests of justice lie and to stay, may it be the arbitrations proceedings sometimes, to get that proceedings. The reality is that proceedings here in Malaysia are far faster than the arbitration proceedings. I can't say for other jurisdictions, but because they're so fast, there is a tendency to get on with the court proceedings rather than with the arbitration proceedings. But because of the interplay of non-parties, the courts use the exercise of discretion and direct the stay of the court of the arbitration, because it's non-party, and get on with the court proceedings. This approach in Protesco was subsequently endorsed by our federal court the very next year in 2019 in the case of GSADRT, to say that that is the practical approach. The courts will decline actually to uphold the arbitration agreement where the interests of third parties who have no arbitration promises in their contract. And the courts also were very aware of the fact that you may end up with duplicity of proceedings. So using discretion and the powers under the rules of court, the courts do look at the protection of integrity of court processes over arbitration. Again, this approach has been diligently adopted and followed recently in the case of Abdul Rahman as well as Lee Fook Kyun, two of our local cases. So that is just to touch base with our very exciting and development of processes and the parties, non-parties, multi-tier dispute resolution clauses, where do we stand? And I think it would be no different in a lot of other jurisdictions, the courts trying to keep abreast. I move next to yet another interface between arbitration and another huge area of law, and that's insolvency. We all know that at the end of the day, it's no point going out to arbitration and you don't get the money trail, despite New York Convention and all. This issue came up recently, and the question is this: if you've got a debt which you then present because it's not paid up, you present a petition to wind up the respondent, non-paying party, or the debtor, what is the test to be applied? Do you, if there is an arbitration agreement now between the parties, immediately send the parties to arbitration, or do you ask the question, is this a debt which is genuinely disputed on substantive grounds? And the test that has been applied in the United Kingdom for a long time was what was called the Salford number 2 test, which is if there's an arbitration agreement and that agreement determines the dispute, then you will not wind up, or you will not allow the winding up petition, or you may stay the winding up petition and direct parties to go to arbitration and sort out that dispute. So the existence of the arbitration agreement is almost like a red flag that immediately is an answer to the winding up petition and how the discretion is to be exercised. Recently, in the case of Sean Participation, Sean is spelled as S-I-A-N, it's an Irish name, and so therefore it's pronounced as Sean Participation. I had the privilege of discussing this case last week in Hong Kong under the restructuring group of lectures or debates. And Sean Participation is an appeal from the BVI. The Privy Council came to the conclusion that Salford number 2 is the wrong test. You can't look at a arbitration agreement and immediately say that's a red flag, and you cannot proceed with the winding up petition. You stay the winding up petition, or you dismiss the winding up petition. In Sean Participation, the answer by the Privy Council is that you should be asking whether or not that debt is genuinely disputed on substantive grounds. And it is only where it is genuinely disputed on substantive grounds, then there is something in the nature of a dispute to send to arbitration or to send to court, wherever it is. So it's not the mere existence of an arbitration agreement that will stump a winding up petition. So Sean Participation, the Privy Council came up with that pronouncement and held that the Salford 2 test, which the UK courts have been following for the longest time, is in fact wrong. Malaysia recently had the opportunity of dealing with exactly the same question. And where were we going to follow? Who were we going to follow? Were we going to still stick to the old Salford 2, or were we going to follow the Sean Participation latest decision? And 2 months ago, our federal court came up with its pronouncement in the case of V Medical Services against Swiss Re Asia Healthcare. Federal Court, Justice Nalini Padmanabhan very carefully picked the whole regime through the differences between the two regimes, and reminded everyone that while they interface, there is a tension between the winding up process in insolvency as well as in arbitration, when the debt which comprises the basis for the winding up is subject to an arbitration clause. Now, having said that, her ladyship held that the Sean participation test, which is the higher test, was preferred. And her ladyship reminded everyone that the two regimes are completely distinct and different, serving quite entirely different purposes. And you cannot use the arbitration regime to stump the insolvency regime. And amongst the reasons her ladyship propounded was the fact that when you're dealing with arbitration, it is very private party to party interests which are in focus. Whereas when you're dealing with insolvency, there is the larger public interest. So once you set the winding up regime into motion, it takes a life of its own. And it's not dictated by the parties. And that's the reason why others can join in a winding up petition, even if you decide not to pursue a winding up petition. Her ladyship basically, in substance, agreed with the rationale adopted by the Privy Council in Sean participation and basically said, you must examine the facts to see if the debt is genuinely disputed. In Sean participation itself, there was an admission. So once there is an admission of a debt that's owed, what is there still to dispute and what is there to arbitrate? A lesser reason to even litigate. And therefore, the inability to pay the debt when presented shows that there is actually no dispute that you could raise on any ground, substantive or otherwise, to say that the company that's refused to pay or is unable to pay should be wound up. So that is the latest as far as Malaysia is concerned, the insolvency test, and this brings Malaysia aligned to the United Kingdom. I bring this to the fore because the conversation is still, the debate is still out there raging for Hong Kong, which appears to be oscillating between the two jurisdictions, two schools of thought, as well as Singapore. Singapore's last decision is about 8 years old in the case of An and BVD, where Singapore says, hey, we are supporting arbitration, period. The moment you see there's an arbitration agreement, unless there are exceptional reasons, there will be no winding up and you must support arbitration. So whether Singapore will rethink its jurisprudence in this area is yet to be seen. But as far as Malaysia is concerned, that's where we are. That is literally the latest as far as our jurisprudence and arbitration is concerned. So that's the second part that I wanted to talk about. Now I want to deal with the third part. And this is closer to home. As announced earlier, I am part of the Asian International Arbitration Center. The AIAC looks after arbitration, not just in Asia or ASEAN, but it is beyond. Mr. Inbavijayan is one of our panelists, and we are very proud to have him as one of our panel members. Now, we have been fully aware of the fact that we cannot keep going in the same way that we have been going for the last, we'll be 50 years old in 3 years' time. In the course of it, Singapore has overtaken us, and so is China and many other jurisdictions within this area. So we're trying to reassert our space and our place as far as the international arbitration institutions are concerned. And in this regard, the government of Malaysia has taken very positive steps. First, I thought I should say something about who the AIAC is. AIAC actually is a product of an agreement between 48 countries, where it was decided after the Second World War, we didn't want our disputes to keep going to Europe and to the other parts of the world. The disputes and the trade was all in our area, but our disputes and therefore expertise and our economy was being affected by the disputes being resolved somewhere else. And it was time that we bring it home. And the body comprising the Asian countries and the African countries under the auspices of what is called the Asian African Legislative Consultative Committee ELCO, decided that amongst the many things that we will do as part of decolonization and the advent of the development of these Asia and African countries, we should keep our disputes at home. We should resolve it here within our region itself. And one of the first things that was done was to set up this arbitration center. And in the last 47 years, we have now 6 arbitration centers under the regime of ELCO, the youngest being the one set up in Hong Kong. But having a center is not enough. You need to know what else needs to be done. And the director, the post I am currently holding, makes the decisions as far as appointments are concerned for arbitration. And in Malaysia, we peculiarly have the regime known as the statutory adjudication regime, specially mapped out for construction disputes. It was a very critical problem. It still is. And this regime was set up by the government. And the director of the AIC, that is myself, I have the single responsibility of appointing arbitrators and adjudicators. But it is a single person. And we all know that you cannot and should not keep power in one person. And part of the restructuring of the AIC is to then establish what is called the AIC Court of Arbitration, and this will introduce collegiate accountability and decision-making to, in essence, provide for greater integrity in the whole process of arbitration and ADR. At the same time, this, of course, can only be done through statutory amendments because this center, while it's set up by an IGA, it is, however, the powers that are given to the director are by legislation. And so last year, in July of last year, the Malaysian government amended the 2 principal acts, the Arbitration Act, as well as the Construction Industry and Payment Adjudication Act, for the purposes of establishing this Court of Arbitration to bring this collegiate body of experts to help make decisions on these material matters of empanelment as well as the whole arbitration process. And a further thing that has been done is to introduce third-party funding in arbitration. Third-party funding at the moment is outlawed, but with the amendment, which is yet to come into force, I believe it should come into force in the next 3 months, will legalize third-party funding for arbitration. Object here is to accommodate principles of access to justice. There is much happening. We are still innovating. We are looking at incorporating AI into both our process and systems so that we can simplify, we can be more efficient, and we certainly can look to innovating. And for that purpose, I think that we are looking for more and more collaborations with, I heard South Africa just now, with Henrik, and I'm sure with Mr. Inbavijayan, there is more that will turn around the corner. This is a long way since my early days of cases involving India, specifically the case of Sri Lankan cricket case under the New York Convention, and another case called the Keynes Energy against the government of India. We have come really, really a long way. And with that, I hope my contributions have helped in part of these celebrations. Thank you very much. Congratulations.
Thank you, Datu, for making this celebration a true celebration. From your words, eventually Malaysia is truly Asia.
Yes.
And we from KFCRI, the entire organizing committee is here. And fortunately, I pulled Mrs. Inbavijayan also. She's keen to even share her thanks here. And as a team, the motivation behind this particular festival, which we had in mind, which materialized after seeing you at our office. And even now, we have to envy ourselves on that particular ideology on 24/7.
You know, when we heard the word Thirunal, and we were thinking, by God, it is so creative and it's so true. It's a festival. It's celebrating our strengths as well as our weaknesses, because in uniting, we can only be stronger.
Yes. Yes. From the words of the judge, a present administrator of an arbitration institution, and the three significant aspects touched by the two, we are thankful, we are grateful, and we will take it as serious, not only as an arbitration institution, as a future platform and alliance of all the arbitration institutions. We have to constructively deal not only the commercial disputes, but also, very interestingly highlighted, the insolvency issues also. Thank you.
Thank you. Thank you so much, and stay safe, everybody. And the next one is here.
Oh.
You have to come here.
Sure. We are accepting that. And next visit to Chennai, you shouldn't miss us.
Definitely, I will not. Thank you so much. Stay safe, everybody.
Thank you.
Moving forward with our next speaker, we are pleased to welcome Ms. Linda Banja, Managing Partner of Banja & Co. Advocates, Kenya. She is an accomplished advocate of the High Court of Kenya with an extensive expertise in commercial and corporate law, data protection, gender diversity and inclusion, ADR, and business and human rights law. Mrs. Banja serves on several prestigious boards and committees, including the Chartered Institute of Arbitrators, the East Africa Law Society. Her leadership is advancing gender equality, equity, and human rights is widely recognized across Africa. We coordinately invite Ms. Linda Banja to address the gathering and share her valuable insights on the current scenario of ADR in Kenya. It's up to you.
Thank you. As been introduced, my name is Linda Banja. I hope I'm audible.
Yeah, you're clear, ma'am.
Okay, thank you. I sit on the committee for marketing within the Chartered Institute of Arbitrators in Kenya. I've been a member of the institute for the past 10 years. The Chartered Institute of Arbitrators in Kenya was formally registered in 1984, being a branch from the main institute in the UK, which was established in 1915. Membership mainly draws from different professionals within the field of architecture, engineering, quantity survey, law, insurance, accounting, and property valuation, amongst others. The widespread spectrum of ADR mechanisms that the Chartered Institute of Arbitrators engages in Kenya includes negotiation, mediation, conciliation, early neutral evaluation, case conference, expert determination, mini trials with inclusion of executive tribunals, pre-trial, made-up dispute review advisories, dispute review boards, renter judge, court annexed ADR, which is a core area of specialty that right now is being advocated for, adjudication, court annexed arbitration, and final arbitration. Currently in Kenya, we have a national alternative dispute resolution policy, which has been advocated and as a sessional paper within Parliament, which is trying to advocate the emphasis and the need to incorporate all ADR mechanisms within the different facets of life. Our core, I think the main area that is being advocated for right now, because that is what has been in force within even non-litigious areas of dispute resolution, is mediation, where we have what we call court annexed mediation, which has been incorporated within the Litigation Act. We in Kenya, similarly, again, we have the National Steering Committee that has midwifed what I've just referred to, the National ADR Policy, Sessional Paper number 4, which comprises representatives from different areas of the economy, judiciary, the National Assembly, Senate. We have what we call the National Center for International Arbitration, Intergovernmental Relations, Associations of Professionals in East Africa, Council of Governors, the Law Society of Kenya, the Consumer Federation of Kenya, the Kenya Private Sector Alliance, the civil society, and faith-based organizations. As you may identify, these are key areas of professional engagement that we find there are disputes that get to arise and need the incorporation and the inclusion of different ADR mechanisms. In terms of prominent arbitration institutions, our core institution in Kenya is the Chartered Institute of Arbitrations, Kenya branch, which is stationed in Nairobi. Then we also have a government-led institution called the Nairobi Center of International Arbitration. And then we also have smaller institutions like the Dispute Resolution Hub that advocate and emphasize and are even used to provide services in terms of alternative dispute resolution. In terms of arbitration case law, in Kenya, we've had a prominent case that was settled almost a few months ago on the issue of arbitral awards and the role of the Court of Appeal in setting aside the role of the Court of Appeal in setting aside of arbitral awards. So the main case in this that I'd like to reference to is the mutual aggravate case, which was the crux or the main area of contention was the role of the Court of Appeal in setting aside of arbitral awards. Basically, the case was about two parties, mutual aggravate and arbitration and the Airtel services and the Airtel Networks Kenya Limited, a dispute on an award of a sum of Kenya shillings 526,000 for general damages and negligence. So there are three key areas that were in contention: the jurisdiction of the arbitration, the arbitrator was he properly in place when he was arbitrating? Secondly, was the scope of the award. We find that the arbitrator had given an award that was outside the scope of that particular case, and then the terms within the agreement, even the arbitrator had made a mistake of giving an award that was exceeding the mandate and the jurisdiction of that particular award. So the matter was taken to the Supreme Court, and the key highlights of this particular case were that the court had indeed given leave within the Arbitration Act under Section 35, where it invoked its clearest jurisdiction. But in terms of damages, the dispute, they had gone beyond the scope of reference. So the arbitration agreement had not been carefully looked into. And when the arbitrator made the award, he went and exceeded his mandate within that. And then thirdly was the matters arising out of the broad, all-encompassing. This was an issue of tort or breach, and the parties had given clearly specified the contractual terms, which also again, while giving the arbitral award, the arbitrator made a mistake and overstepped his mandate. Finally, the key highlight also in this case was that the arbitrator had had gone outside and exceeded his mandate in terms of giving award or even requesting for enforcement of an award for things that had not been pleaded by the parties. So basically, in conclusion, was it clear that the court was properly in place when the parties had approached the court for the setting aside of the award? Yes. Were the issues that had been highlighted properly before the court? Yes. And can the court also look within the Arbitration Act and properly guide the arbitrator in terms of the scope? And yes, this was properly held. What is the government or judiciary doing to promote arbitration in Kenya? The key proponent, the key organizations that are steering forward the issues of arbitration within Kenya are the Chartered Institute of Arbitrators. And first of all, I think the first mandate it has done is to closely collaborate with the like-minded institutions. First of all, the first organization I'd like to mention is the Nairobi Center of International Arbitration. It is more independent as opposed to the Chartered Institute of Arbitrators because it's a not-for-profit, but this is more of a government-led institution. So we have initiatives such as the Nairobi Arbitration Week, which has just ended the past month, which brings into place different players, particularly students, and trying to highlight the importance for them to embrace arbitration and also how they can also, as legal students or legal scholars or partners, how they can be able to steer forward and assist not just non-litigious cases, but also in scenarios where there's need for intellectual exchange, there's need for research, there's need for scholarly engagement. So this is the first initiative where we have competitions, we have collaborations, we have intellectual exchanges in terms of research, in terms of knowledge and scope of arbitration. And for the part, this is the second year, I think it's being held, and it was successful. Personally engaged as a judge in one of the matters. So secondly, we have the state of ADR within Kenya, where the conception of what we call social transformation of access to justice. And we have initiatives that are encompassing arbitration through what we also call, again, alternative justice systems, where we try to water down the arbitration process, not entirely, but just making it more approachable, making it more malleable to the different members of our communities, the different members of areas of engagement that we people collaborate and engage with. So there have been initiatives where the Chartered Institute of Arbitrators have collaborated with the judiciary in terms of coming up with legislation. And I had mentioned the National Steering Committee, midwifing the National ADR Policy Session Paper number 4 of 2024, which had different stakeholders that I had highlighted. Secondly, there's the issue, there's the embracing of the alternative justice systems. Thirdly is the incorporation of the young members group, where we have under 40 students who are engaged in ADR, either as practitioners, legal practitioners, or special parties who are specializing in arbitration. So the Chartered Institute of Arbitrators have enabled the establishment of the young members group, with leadership starting from 40 and below. So this has been able to spearhead, again, initiatives that are emphasizing, recognizing, inculcating the role of arbitration, enlightening the community and even students in different schools. So we've been having also peer initiatives where they go to different campuses. They have moot court competitions. They have knowledge sharing sessions. And I believe this has played a big role in enhancing and developing ADR within the young members. Secondly, there has been the role of academia through the C-Hub ADR journal, which is edited by Professor David Karaoke Mwiba, and is peer-reviewed and provides a platform for scholarly engagement suitable for any academic practitioner and allows for resource between students, practitioners, and legal counsels on the aspects of arbitration. Thirdly, there's the aspect of women in ADR. It is a group, but as well, also this provides a platform just for women. I know it's kind of a, it may seem like it's prejudice against men, but it's more of advocating the role of women as key players within the legal framework and within the ADR space to be able to share knowledge, skill, expertise, and provide also different experiences that they've had, and also provide encouragement and scholarly support and intellectual exchange. The other aspect that is there is what I call niche practice, where there have been establishment of collaborations in specific areas. So for instance, there's the area of sports arbitration where we found the establishments of individuals who are particularly practitioners of sports arbitration, energy arbitration, and insurance arbitration. This has enabled the development of these areas, especially now also collaborating with the different cabinet secretaries within government in that particular area, and also providing knowledge, skill, and knowledge sharing. The prevailing arbitration legislation that is being used in Kenya is the Arbitration Act and the Kenyan Constitution as points of reference in terms of matters arbitration. I think for now that's my presentation.
Thank you, Linda, for the enlightening presentation about the entire landscape of arbitration in Kenya. We are very happy to hear how the Kenyan jurisdiction is having a constructive role in arbitration. In this context, there were earlier discussions and questions raised, but eventually the particular participants are not available right now. Many have an aspiration that Kenya's unique position as a regional hub when it comes to trade or the commerce, and it also is making to be a regional hub for international commercial arbitration. And there was an institution in the year 2013 created in the name of Nairobi Center for International Arbitration. And I could understand that it is the arbitration court created by the Act of the Parliament in around 2013 or 14 in Kenya. What is the takeaway? Because we feel that there is some other jurisdiction in Africa like Rwanda, the Kigali International Arbitration Center, the Addis Ababa Chamber of Commerce Arbitration Center in that particular region, at least in the eastern part of Africa. particularly the very prominent sea route. To solidify the Kenya's position as a preferred arbitration hub in Africa as well as in the global south, we expect a lot of reforms. Reforms are necessary to address challenges, particularly when it comes to cost barrier, enforcement obstacle, and lack of specialized arbitrator. It might be a notion or a myth, but still cost, enforcement, as well as lacking of specialized arbitrator in the perspective of the users, how it is being addressed or any reforms is happening in Kenya, and whether Chartered Institute of Arbitrator Kenya branch also is doing its part to look into and getting back Kenya as a regional hub.
Thank you for that question. At first, when the National Nairobi Center for International Arbitration was formed, there was a lot of concern that maybe there was competition between it and the Chartered Institute of Arbitration, but that was not the case. It was just more of a way of collaborating, because I've said it's mainly a government-led initiative. And CIAB is more of an independent institution and a not-for-profit entity. So the emphasis, even in terms of just what I've talked about, the Nairobi arbitration, it's more of collaboration. It's not, they're not completing, they're not conflicting in any way at all. Secondly, to answer to your question, Nairobi is the regional center for many institutions, including the UN, including many business, commercial entities. I believe both institutions, the Chartered Institute of Arbitrators in Kenya and the National Center for International Arbitration, have taken up initiatives in terms of the arbitrators, training them. Because right now, I believe you cannot just be assigned any arbitration without having at least mentorship, and mentorship, at least 3 mentorships, and then after that you'll be assigned. Now you can take up an assignment to act on a particular arbitration matter. Secondly, in terms of the cost, there's a scale that has been reviewed, because I remember there was a lot of concern that the fees was quite low, and there was a bit of resistance towards that. So there's been a scale that has been set up, and I'd be more than happy to share with you, that you can share with our listeners, that has set out based on the level you are in arbitration, then this is how much it costs, and what are the other additional costs that you may incur in terms of the venue, in terms of the arbitrator, and in terms of the expertise and the area of specialization. Thirdly, you had talked about concern in terms of being a regional hub. I think my emphasis right now is I know we've had a lot of contention. People are still concerned in terms of our political stability, but I'm happy to report that we are still getting back in form. We had a change in presidency, and definitely that comes with its hiccups, and it takes a bit of time to have that. But I believe it has not entirely affected the different commercial entities as it had the first 2 years. I'm happy to report right now, at least there's a bit of stabilization. So I'm happy to recommend and even encourage more arbitrators to visit Kenya. It's still the place to be.
Thank you, Linda. It's wonderful. I feel it's a second innings for Kenya, getting back to the stage once again for arbitration, and we are very much happy to come to Kenya, particularly the Indian subcontinent, which has a lot of trade connect, and the diaspora in Kenya. We can explore the opportunities, what is available, and no doubt your words has to come true, and Kenya is going to be really a hub, a regional hub, not only for Africa as well as the global south. Thank you.
Karibu sana from our Swahili. We say karibu sana. It means welcome. And we hope to have all of you join us. Let's make this world a global arbitration hub, just as this platform is. Thank you.
At this point, the Kovise Foundation Conflict Resolution International is happy to share that there's a big team of members, particularly law students who are part of the intern team in the foundation, working for the ADR purpose, doing the research, doing the marketing, and ultimately reaching to each and every participant and the speakers. And this is one of the very interesting role what we at KFCRI are doing. And to further explain this 24 hours event, and particularly the future announcements or 24/7 is going to be a reality with all these supporting members who are now spread across the jurisdiction, not only confining with India, they are across multiple jurisdictions facilitating alternative dispute resolution, which they got as a training platform from KFCRI. And we in KFCRI are quite thankful, and the efforts, particularly bringing these people as tribunal secretaries, as well as future case managers in arbitration, as well as in mediation. It is a prime task. I think the Chartered Institute of Arbitrators, associated persons like Linda, like Hey, I am also part of the SIAB, the MENA region. All have to take this as a serious point for consideration and facilitating, ultimately reaching to the destination of appropriate dispute resolution. What Datu Mary-Lim was highlighting about appropriate dispute resolution. This GSADR shouldn't be a Global South Alternative Dispute Resolution Thirunal or a day. It has to be a Global South Appropriate Dispute Resolution. And I thank the entire supporting members, along with the organizing committee, as well as the founding members who happen to be the pillars. And with this few note, we can just move on to the next session, technical session. Thank you.
Mr. Inbavijayan, can I just be given 2 minutes?
Yes, please, ma'am.
I understand today we celebrate your birthday.
Okay.
May I, on behalf of the AIC and everyone here, wish you the best of health. Happy birthday. Happy return. Many, many blessings.
Thank you, Dato Mary-Lim. It's a true blessing. I'm just reached 50. I exact 50. I hope with all your blessings and arbitration practitioners across the globe, I should reach at least another 40 years.
In good hands, in good hands. With God's grace and blessings, with the same right spirit, we should get there. You should get there. Blessings. Many happy returns.
Thank you. Thank you, ma'am.
Happy birthday.
Thank you, Linda. Thank you.
We now move forward with the next speaker for the day. KFCRI is now pleased to welcome Mr. Shahrukh Kumar, a dynamic legal professional with a strong foundation in dispute resolution and a passion for grassroots legal empowerment. A graduate of the School of Excellence in Law, Chennai, Mr. Shahrukh Kumar currently serves as a legal associate at Ilangovan Associates and a project coordinator at the Kovise Foundation Conflict Resolution International, KFCRI. With hands-on experience as a tribunal secretary in arbitration proceedings and as a mediator and dispute resolution advisor, he brings a practical and insightful perspective to the ADR landscape. His academic and professional journey is marked by active involvement in legal research, writing, and advocacy, including leadership roles such as vice chairperson and treasurer of NILS Tamil Nadu chapter. Mr. Shahrukh Kumar's interests span criminology, taxation, labor, commercial law, and civil litigation, and his commitment to advancing legal awareness in rural communities reflects his deep-rooted dedication to inclusive justice. We are honored to have him join us today and look forward to the valuable perspectives he will share. Over to you, sir.
Thank you. Thank you for the introduction. I hope I'm audible. So
yes, sir, you are.
Yeah, thank you. Thank you. So before we go into the technical session, I would like to, convene something on how the concept of the entire Global South ADR THIRUNAAL had emphasized, and how, since right now we actually enter the halfway milestone of the event. We are almost into halfway of the 24 hours program that we've scheduled today. So basically, the concept, how it emerged was KFCRI, Kovise Foundation Conflict Resolution International. From the day of its inception, the prime motive and idea of all the stakeholders of KFCRI has been to promote ADR in one way or the other. So the key motto of KFCRI is to take ADR basically to the grassroots level and to every section of the society. So in our pathway to that goal, we have started our work from the grassroots level in various ways. Initially, we started off by organizing training programs and awareness programs in a small scale, and thereafter it evolved to come out as webinars wherein we were able to reach out to people from across the globe from various jurisdictions. And then we had a concept called a roadshow. An ADR roadshow was being conducted by KFCRI in the past years, where KFCRI had reached out to various law schools and other educational institutions, reaching out to the student community on how ADR works and creating awareness on the importance of ADR and arbitration as well. So on that line, when we wanted to take a step ahead, we had this idea of organizing something called a THIRUNAAL. So the concept of THIRUNAAL is basically a Tamil word. In fact, the word THIRUNAAL we were not able to match it with an equivalent word in English. So we didn't want to complicate it much. So we had it as a day as the word day in English. But when it comes to the word THIRUNAAL in Tamil, so in the Tamil culture, which is followed in the southern part of India, THIRUNAAL is basically an auspicious day or a day of festivities. Basically, since the Tamil culture comes out of agriculture, has agriculture in its roots, it is basically a day in which the harvest is being celebrated. So when we wanted to host something, we didn't want to restrict it to a particular region or a particular jurisdiction. So when we thought about it, it is, if you imagine a THIRUNAAL, It is an event where people from various sections of the society, irrespective of their community, language, creed, or the cult to which they belong, they all come together to celebrate a common cause. And we wanted to celebrate ADR that way. And that idea was taken up as hosting a 24 hours program in the name and style of a Global South ADR THIRUNAAL. In fact, when I was about to begin my session, I was quite confused on how I should start off by greeting everyone, because when I saw the list of attendees, I could see people attending from various parts of the globe in different time zones. So I was, in fact, this is nothing short of a revolution in development and creating awareness of ADR, not only in India, not only restricting to the Indian jurisdiction, but all the jurisdictions across the globe, both developed, developing, and jurisdictions where ADR has just blossomed. So, first of all, I would like to congratulate the committee members and KFCRI as a whole for taking up this initiative of organizing, because this is a first of a thing event, first of a kind, where continuously people from different time zones across the globe come together and express their insights on ADR or arbitration from their jurisdictional point of view. So I was able to attend a few of the sessions of luminaries who were from different jurisdictions who had spoken before me. And in fact, this is the need of the hour, where we are able to bring in minds working in different jurisdictions. But the common motto or the takeaway from this THIRUNAAL, Global South THIRUNAAL, would be, in one voice and unison, to bring ADR to the grassroots level in every jurisdiction. So having said that, when it comes to institutional arbitration in India, the jurisdiction where we practice, we KFCRI, the jurisdiction where we extensively practice ADR and provide ADR services, to be very frank, the Indian jurisdiction as on date has not reached its mark in the institutional arbitration. Though India has been trying to become the global hub for arbitration over the past few decades, India has been a forerunner in promoting and advocating arbitration for resolution of disputes of various kinds. The use of how far institutional arbitration has been put to use is a question mark. Though the procedural statute in India, that is the Arbitration and Conciliation Act of 1996, recognizes institutional arbitration. The stakeholders in dispute resolution, the stakeholders in the legal field, how far they have made use of the availability of institutional arbitration is again a question mark. So rather than going into what is institutional arbitration, I would like to share my insights on how institutional arbitration is being put to use in India and what could be done to take it to the next level in the coming days. So, though after the enactment of the Arbitration and Conciliation Act of 1996, which is the procedural statute for arbitration in India, after the enactment of the said Act, the said statute, arbitration as a whole has developed over the past 30 years. Litigants, even till date, most of the litigants, though they are aware of something of the availability of a mechanism called arbitration, which is something alternative to the traditional form of litigation, the awareness of something, availability of something called institutional arbitration is very less. And the reason for this I see is that the common idea of litigants, or even, let's say, a part of the litigating lawyers, is that unless there is intervention of court in resolution of any dispute, we feel there is no authenticity or authorization in such a dispute resolution. When it comes to ad hoc arbitration, litigants and lawyers have a feeling that since the appointment is made by, in case of appointments made under Section 11, there is court appointments. Since the arbitrator is being appointed by a court of law having appropriate jurisdiction, they feel that it is a seal of authorization. So this arbitration is, they have a sense of feeling, because I say this from my personal experience, from what I've had with clients or litigants or fellow lawyers. They have a sense of feeling that this dispute resolution mechanism is being monitored by a court of law, which is not so. Though even in cases where an arbitral tribunal is being constituted by a court of law, the role of the court ends with the appointment of the arbitrator or the arbitral tribunal. It is the same case it is the same in case of an institutional arbitration, where an institution is going to appoint an arbitrator. There is lawyers and litigants. When I say lawyers, I only mean a section of lawyers who are new to arbitration. We feel an institution, an arbitral institution appointing an arbitrator, does not bear any seal of authorization. And we are doubtful about the enforceability of any resolution that is arrived through that arbitration, through the institutional arbitration. So what we fail to see is the availability of assistance and a background framework for the arbitration that is available in an institutional arbitration. In fact, in recent days, in the recent years, ad hoc arbitrators functioning in acting as arbitrators in ad hoc arbitrations have started the practice of engaging tribunal secretaries for their administrative assistance. So it is, we are of course in the right path. The next revolution would be replacing ad hoc arbitrations with institutional arbitrations. But what is required firstly for that from the lawmakers, I would say, is that it is only when the state or the courts of law start recognizing arbitral institutions and give them a seal of authority, the common litigants who come from the grassroots level, they'll start having their faith towards institutional arbitration. In fact, after the Supreme Court of India held unilateral appointment of arbitrators to be void in the judgment of Perkins Eastman, various small-scale financial institutions, non-banking finance companies, they started adopting the practice of institutional either appointing arbitrators through institution or conducting institutional arbitration as a whole, because they could not, once unilateral appointment was held to be invalid, these small scale and medium scale institutions could not take up the burden of going in for ad hoc arbitrations, because in claims brought out by such small scale or medium scale enterprises, the claim would be somewhere trivial, and ad hoc arbitration seemed to be costly in such cases. So these small scale institutions, small scale businesses and enterprises, they started getting into institutional arbitration. They understood, and once institutional arbitration was put into use, they started understanding the benefits that they could arrive from institutional arbitration, and how they were deprived of it in the past because of going by the traditional litigation or the ad hoc arbitration system. So for the time being, what is the need of the hour is the state and the judiciary coming up with ideas similar to what we have today, the Global South ADR THIRUNAAL. The state and the judiciary should come up with programs and policy decisions promoting institutional arbitration. It is only then India could reach its goal of becoming a global hub for arbitration. In fact, I came across an article of a few weeks back, wherein the number in many renowned arbitral institutions outside India, such as the SIAC or the London LAAC, the number of arbitrations pertaining to stakeholders from India in those institutions were far more than the number of disputes from their very own jurisdictions, which means stakeholders in India do believe in institutional arbitration, but the lack of an appropriate framework recognizing institutional arbitration till date is the reason why the stakeholders hesitate or they shy away from getting into the institutional arbitration process in India. So having said that, the Kovise Foundation Conflict Resolution International, as an ADR institution, we have our very own, in fact, the KFCRI arbitration rules and the mediation rules were drafted, if I'm not wrong, it was in the year 2020, and it saw various amendments in the years. But whenever we have stakeholders approaching KFCRI, after having been satisfied with all the nuances of institutional arbitration, the final point where litigants shy away from taking up institutional arbitration is the doubt that arises in their mind whether this is recognized by the state, whether this is recognized by a statute, or will the court of law recognize this mode of dispute resolution, if at all, in the future. But what they fail to understand is that this institutional arbitration has been recognized from the day on which the statute on arbitration came into force in the year 1996. So how do we take this to the grassroots level is through awareness, creating awareness in forms such as what we have today, the Global South ADR THIRUNAAL. So the takeaway, to summarize what I have dealt with in my experience as a lawyer and an ADR practitioner. The development of arbitration and the society as a whole depends on how far we take up institutional arbitration to the grassroots level in the next decade, because this is a very crucial period where we are somewhere nearing, India is a jurisdiction nearing the goal of becoming a global hub for arbitration. But the only factor that keeps us away from the goal is the lack of faith, lack of creating faith among litigants and people who come up with disputes on institutional arbitration. So we from KFCRI, as it was pointed out earlier, this is just one day of festival that we are celebrating. We propose to take up this to the next level, where we'll even have ideas of having a 24/7 ADR expo, or we'll definitely come up with a new word similar to what was coined now, THIRUNAAL. So with that, I would like to end my session by saying the entire legal landscape of a country like India, a jurisdiction like India, would definitely see a positive changeover when institutional arbitration is put to its absolute use. And the day when institutional arbitration is put to its absolute use, KFCRI would definitely be the supporter and the forerunner in such a mission. So thank you for this opportunity. And once again, I would like to congratulate all the participants, attendees, panelists, and the team of KFCRI for bringing up this revolution in arbitration landscape, particularly from the southern part of India. That is how we named it Global South. Thank you.
Thank you, Kumar. Anyway, you are part of KFCRI from the day of its inception, the growth, and what right now we are. It's all because of the team. Initially, we worked, and now the team is also facilitating the way how it is expected. And as Mr. Kumar mentioned, this is really a compliment what we can take into, particularly coming from the southernmost part of India, which is obviously in the heart of the Indian Ocean rim. That's very important. The diaspora, as well as the global south countries across jurisdictions, need to have the same emotion. That's what is expected. And I could see Shahruk's emotion also very clearly, because this happened to be the ideology for a long time to work it out. Now it is happening and it will be the future. Thank you, Shahrukh.